is, Judge. I mean, Mr. Hand and I have negotiated as far as we can. There's no pending motions or anything.
Okay, good.
It's gonna be employed 100%.
Okay. It just sort of shapes your Thanksgiving plans, whether it's a trial or not a trial.
Certainly not.
All right, we have all our technology set up. Good morning again, everyone. We have the presiding bond calendar this morning, and we may also have a couple plea. Were the pleas going to be this morning or later today? This morning also? Pardon me?
About 11.
Okay, great. And those are Mr. Ford and Perez. Are those the two pleas we're doing today? I know there's some availability issues with Coleman and Jones.
Judge Perez is 88 Whitenhours, but I do see he's on, so he may have an answer.
Okay, well, I mean, I've heard it's a plea. I thought it was Shapiro, regardless of who
Or
it is.
Shapiro, I'm sorry.
I just didn't want folks waiting around if they could patch back in a little bit later, because we're going to start with the bond hearings.
Agreed. It's my understanding it is a plea, Judge, but I don't want to speak for Mr. Shapiro.
Okay. Well, he can speak up. All right. Good morning, public defenders. Is there a particular order in which you want to handle the bond hearings, or do you want to just go in the order of the calendar? I'm fine. I didn't know who's handling what. You guys may have arm wrestled, and we'll do Ms. Bray's first or what? Are you Mr. Lang, by the way?
Yes, Your Honor.
Hello, Mr. Lang.
And I did want to announce for you on position 1, I'll be covering for Attorney Correa.
Great. So you have 3?
Correct. Your Honor.
1, 4, and 5, and Ms. Bray, you've got 2 and 3.
Yes, yeah.
Okay. If you guys are neutral, let me ask Mr. Abate, is there an order you'd like to go in? We have a very full house, and if folks are here mostly for one of the cases, we should do that first so they can be on their way.
No specific order. Okay, can we take mine?
Mr. Lang gets the elbow to the side of the head. Yes. We'll start with Mr. Small.
That's fine, Your Honor.
All right. Mr. Small, please.
Oh, wasn't it? That's true. Yeah. Yeah, not no.
So he can be, the defendants can all be seated for this. If they need to share something with their attorney, they'll be able to confer, but it'll be the attorneys at the podium. Good morning, Ms. Rivers. Are you able to hear us?
Morning, Judge. Yes, I am. I'm ready.
Great. All right. 1 second. All right. This is position 2 on our calendar. It's 22 CP 213522, State versus Gregory Small. Good morning, Mr. Small.
Good morning, sir.
I'm Judge McBurney. I don't think we've met before, and I have your case solely for purposes of bond. Your case is unindicted. You are entitled to a bond hearing because of the charge you face. That bond hearing is in front of a Superior Court judge instead of a magistrate. Ms. Bray is going to present the reasons why I ought to set a bond for you and what that bond should look like. Then we'll hear from Mr. Abate, who is the prosecutor who, for right now, is handling your case. The roles of folks, well, the people who fill these roles may change if and when your case is indicted. It may come to me, but there's a 1 in 15 chance of that. There are 15 different judges your case could go to when it's indicted. You'd get a different public defender once it gets indicted, and you may have a different prosecutor on your case as well. But for today, this is the team working on your case. When you are ready, Ms. Bray.
All right, thank you, Your Honor. Good morning.
Good morning.
Your Honor, you have before you Mr. Gregory Smalls. He is 27 years old. He does reside in the Metro Atlanta area. He has a good address at 372 Rankin, Rankin Circle. That is in McDonough, Georgia, 30253. He lives there with his mother, Miss Winsome Bryant. She may be present today, Your Honor. I haven't checked in the audience to see who's here on which case.
We have a Bryant online also. I don't know if that's mom, but if
Oh, I can't even see it.
it's okay. I mean, there's not a video. There's just a Bryant is
Okay.
on with the T. Got a lot of folks on.
Got a lot of folks, I see, Your Honor. I did speak with his mom yesterday so that she would, well, she was already aware of the date, just not the location.
Sure.
You know how we are. Your Honor, prior to his arrest on this offense, he was employed full-time with IFCO Warehouse. That's also located in McDonough, Georgia. He worked the 3 p.m. to 11 p.m. shift there, Monday through Friday. He has one daughter who's 5 months old. She resides in the state of Florida. He does send money home to Florida to help, take care of the daughter. He provides financial support for her. He is originally from New York. He has lived here in Atlanta, the Metro Atlanta area, since 2015. So he does have ties to the community, Your Honor. He has stable employment. We're hoping that if he gets a bond and it's affordable, that he'll be able to return to that job or else get another job, Your Honor. With regards to this offense, Your Honor, it is alleged that he caused the death of another gentleman by the name of
Mr. Snelling.
Yoris Snelling. Yes, Yoris Snelling, if I'm pronouncing that correct. Mr. Small categorically denies having done so, Your Honor. I am asking Your Honor to take into account the amount of days that he has been in on a no bond status. I also want Your Honor to take into account the amount of time it has been taking to indict these cases and move them forward. I've had clients with a lesser charge sit in Fulton County Jail 2 years unindicted, Your Honor. So I just want Your Honor to take that into account. At the time of his arrest, he was at home where he was supposed to be, so the police did not have to search for him or anything like that. They simply went to his house and woke him up and took him to the Henry County Jail because McDonough's in
Henry
Henry County, right? And so he sat there in the Henry County Jail from a Friday all the way through to another Friday. Not quite sure why it took a week to get him here, one county over, but
Okay, so I have Mr. Small. Is it small? Is there an S on the end? No S.
It's small, sir.
No
S
S.
at the end.
Okay.
No S at the
So
end.
I have Mr. Small making it to Fulton County Jail just before Halloween. So you're saying there was a whole week in Henry County as well?
Henry County as well.
Okay.
Why, I'm not sure, but it took them that long to get him here to Fulton County. It is my understanding that he is not a convicted felon, Your Honor. I do believe there is a misdemeanor probation out of Henry County for an obstruction that may have happened last year, but he did not plead to it until sometime this year.
Okay.
Okay, so he is on a misdemeanor obstruction. But even with that, Your Honor, I am asking Your Honor to set bond on his behalf. As I've stated, he denies committing this offense. I believe that he is not a danger to anyone that may or may not be connected to this case. So I don't think that there's a danger of his intimidating witnesses or anyone or anything like that. I don't believe that there's a risk of flight for him. He does not own a passport, hasn't been out of the country, has no intent of fleeing the country.
Does he still have family in New York?
That's a good question.
Yes, sir.
Is that where, it sounds like you're living with your mom. Is your father or you have siblings up in New York?
Nah, no, sir. That's my grandma and my grandpa.
That's whose grandparents are in New York?
Yeah, that's all.
Okay.
So anyway, Your Honor, for those reasons, I believe he meets the Ayala factor. So I am asking Your Honor to set a total bond on his behalf in the amount of $30,000.
Okay. Mr. Small, you have one kid or more than one kid?
Nah, sir, there's one kid.
Okay, so
first.
the Ms. Sanders, who I'm probably going to hear about from Mr. Abate, that's the mother of your child?
Yes, sir.
And is she typically down in Florida? Because you just mentioned Ms. Bray,
That the child.
that the child's in Florida, but mother of child's not in Florida, or just happen to be, and I don't want you to talk about facts and circumstances of the case. I'm just trying to understand the dynamic, why Ms. Sanders would be here when you said Florida.
Okay, the child lives with Miss Sanders' mother, is
Okay.
what I was told. And
Okay.
Miss Sanders' mother lives
In Florida.
So
Okay.
he sends money to Miss Sanders' mother.
Got it.
for the
And Ms.
kid.
Sanders may be back and forth. It sounds like at some point in the not
Yeah.
too distant past, Ms. Sanders was here.
Right.
Okay, got
Yes,
it.
But
All
the
right.
child remains in Florida.
Understood.
Okay.
Thank you.
Thank you.
Mr. Body,
Good morning, Judge.
good morning. Oh, before you, Ms. Jackson, good morning. How are you?
Morning, Your Honor.
Can you share with me criminal history for Mr. Small?
He has 5 cycles. The last arrest was July the 14th, 2022 in Henry County for a probation violation. The underlying charge was misdemeanor obstruction of an officer. He appears to be on probation in Henry County for obstruction of an officer. That disposition date was May the 5th, 2022, and the term is for 12 months. I do see one other misdemeanor conviction was in 2021 out of Henry County for driving without a valid license. Nothing in addition, Your Honor.
Thank you so much. Ms. Tucson, are you on the call? We've got lots of folks. I can't see if you're on. All right. I will always give you the last word, Ms. Bray. If you could talk to your client while I'm hearing from Mr. Abate, what the probation violation situation was about in July. There was the most recent arrest we just heard about in July was supposedly some issue with the misdemeanor probation. Mr. Abate, when you're ready.
Your Honor, do you mind if I stay seated at council table?
I don't, as long as Ms. Rivers can hear you, so make sure that microphone is on and in your direction. All is good.
Thank you, Judge. The state would respectfully request you deny defense counsel's motion for bond for several reasons. You heard from Ms. Bray a few moments ago that the defendant has ties to New York. I would submit to the court that makes him a risk of flight. I'd also submit to the court that the defendant is a threat or danger to the community and the people in it based on the facts and circumstances of this case. You heard a little bit about it from Ms. Bray, but on October 7th of 2022, the defendant actually laid in wait, waiting for the victim in this case, Mr. Snelling, to leave his home. He waited for several hours, approximately 3.5 hours for the victim to get ready to leave for work. As the victim exited his home and got into his vehicle, the defendant then ran up to the victim's vehicle and began firing multiple times, shooting and killing Mr. Snelling. And at that point, took off and fled in his vehicle. As the shooting was occurring, Ms. Sanders did see outside the window the defendant's vehicle fleeing from the scene and was able to positively identify that as the defendant's vehicle, as she shares a child and has known the defendant for quite some time.
And Mr. Snelling, the deceased, was the current significant other of Ms. Sanders.
That's correct. They were living together.
Okay, and the state's view is that Mr. Small, angry, upset about that, something, was laying in wait for Mr. Snelling.
Yes, and he actually, to add to that point, Your Honor, had sent several text messages and messages through social media, basically threatening both Ms. Sanders and the victim, saying, "I know where you at. I'm waiting for your boyfriend to dump out the trash or leave the house. I'm gonna pay y'all a visit. I'm going to get that in. And when I do get him, and shit, yo, I'm going to see which car y'all get in and watch what's going to happen," is what he texted over and over and over again, which is the basis for the terroristic threats. Ms. Sanders is so scared since this incident. She no longer lives in Atlanta. She has fled the city of Atlanta because of what she witnessed this defendant do to her boyfriend, and how the threats that he made actually came true, Your Honor. So based upon that, I would submit that he's a significant danger to the people in the community, as well as a risk of intimidating witnesses based on the account of Ms. Sanders and how the defendant had been threatening both Ms. Sanders and Mr. Snelling prior to murdering Mr. Snelling. Mr. Smalls was also on bond for aggravated assault and cruelty to children in the first degree. He had been arrested on June 22nd of 2022, received a bond in Henry County. Your Honor, the Henry County probation hold was due to, one, this new arrest from 6/22/22 for the aggravated assault, as well as, from my understanding from speaking to probation, he had not reported after that arrest for aggravated assault, Your Honor. So that's why he sat in custody in Henry County for about a week prior to being moved to the Fulton County Jail to face the charges in which he's facing here today, Your Honor. So I would respectfully request that you deny defense counsel's motion for bond at this time. And to address Ms. Bray's concern, at least the major case unit's been very diligent in making sure the cases have been indicted within the 90-day limit. If not, obviously her client would be entitled to bond and the revisitation of this hearing.
Thank you for sharing that. A few questions. What is the basis for your claim that Mr. Small laid in wait for 2 or 3 hours? I mean, everyone's new to the case, but Ms. Sanders had noticed his car out there for 3 hours, or it's cell phone records, or
Actually a ring video from a neighbor, as well as the victim's mother who lives in the neighborhood, where you can see Mr. Small's vehicle getting there at 1:49, and then him getting out of the vehicle, producing a firearm, and initiating the shooting at 4:49.
okay. The arrest in Henry County, I'll ask Ms. Jackson in a minute, but that would, or maybe that would be on her radar, because that was before the July arrest. So Mr. Small, you're saying, was arrested for, in Henry County, aggravated assault and something else, I guess bonded out, but then that would be the basis for the probation violation is, hey, you were on probation, you got arrested for a felony offense.
That's correct, Your Honor.
Okay. And was on bond for those felony allegations in Henry County, fast forward to October 7th of this year. While on bond for that, was the aggravated assault, is Ms. Sanders the alleged victim of the aggravated assault?
I don't know the circumstances of or who the victim is for that aggravated assault.
Okay.
So I
think you said cruelty to children was a secondary charge in the unindicted Henry County case?
That's correct, Your Honor.
Okay. All right. Got it. Ms. Jackson, I'm going to turn back to you if I may. Do you show a June arrest for Mr. Small? You shared the most recent arrest, which was July, for the probation violation.
Just a moment, please, Your Honor.
Sure.
Your Honor, while she checks, I just wanted to bring to the court's attention, there are 2 members of Mr. Snelling's family who'd like to make an impact statement when the court deems appropriate.
That'll be coming right up.
Thanks, Judge.
Are they here or online?
I believe they're present.
Great. Is it working outside now? We're good. Excellent. Okay. So if you feel a little crowded in here, folks, there is now a screen with audio. It's not a big screen, but audio outside as well. But you're welcome to stay in here. Ms. Jackson, any update?
Okay, I see where he was arrested June the 23rd, 2022 in Henry County for aggravated assault, cruelty to children in the first degree. There seems to be a second charge, an additional charge of cruelty to children in the third degree.
Okay,
Okay, no disposition for it.
thank you.
Yes, sir.
So Ms. Bray, I think we understand now what the probation violation was. Anything you want to share about the June arrest in Henry County? Sounds like your client got a bond after a hearing down there.
He did, Your Honor, and bonded out, and that is in fact the reason for the violation of probation arrest the following month.
Okay, all right. Mr. Small, is there anything else you wanted to add?
No, Your Honor.
Okay, Mr. Small, I'm going to deny bond at this point based on what I've heard. I don't find that you are a flight risk, that you'd go to New York. It sounds like your center of gravity is more down here with your mom and work. And unfortunately, Ms. Sanders, although she's elsewhere now, I think that the better course of action is for you to stay where you are for at least the short term. Your case will stay with me until it is indicted. And I'm sure Ms. Bray has told you this. I'm going to repeat what she's told you. If after you've been in custody for 90 days, the state has not indicted you, then we will be back together again. In fact, Ms. Bray is pretty good at saying, hey, it's day 89. When can I get in front of the judge? And then I'm required to set a bond. There is a law. It's not the judge feeling this way. There is a law that says someone who's not been indicted within 90 days is entitled to a bond. Whether it's a bond you can make or not will depend. We'll all know more about your case. Ms. Bray will have had a chance to look more at the case file to push back maybe on some of the things that Mr. Abate said. But based on what I've heard, I don't think bond is appropriate. 90 days without an indictment, my opinion about whether bond is appropriate or not doesn't matter. I need to set a bond, and I will. And we'll see you again on day 91 or whenever it is Ms. Bray can get you in here. And we'll talk about bond again. If you get indicted before those 90 days are up, then you can still talk about bond. It just may be with a different judge. As I mentioned, there are 15 of us who get these criminal cases, and whoever judge that is can be asked by your lawyer to think about bond again. But for now, I'm going to leave you in no bond status. Thank you. Oh,
You already stated that it wasn't because you thought that Mr. Small was a flight risk. So what was?
Correct. No, it's danger to the community and risk of committing a felony. Learning that Mr. Small was on bond for a felony allegation, and then these allegations arose. I'm not finding that being on bond, I don't know what the conditions were out of Henry County, but that didn't seem to be a big deterrent to keep Mr. Small out of trouble. And I'm sorry, Mr. Abate, there were folks who wanted to be heard, and I need to hear from them. They know what I'm going to say now, but I didn't mean in any way to not hear from them. So if anyone on behalf of Mr. Snelling would like to be heard, you've got an absolute right to share with me your thoughts, and I apologize for getting out ahead of things.
Your Honor, I think they're okay, and they give their thanks to the court for their.
Okay, all right.
Thank you, Your Honor.
Okay, understood. That's it for now, Mr. Small. Ms. Bray may be getting some information from Mr. Abate about your case. The real information flow starts after you've been indicted. That's when your lawyer's entitled to everything the state's got. All right, thank you. So we'll do Mr. Hurd next.
It was in the warrant about the threats. I just wasn't.
And again, folks, on behalf of the Snellings, I apologize. I didn't hear from you. I wasn't ignoring you. I got ahead of myself. I'll do better with the next case.
That's her. Oh. I can get you this. Oh my God. It's on video.
Did y'all?
Folks, here.
You sure? It's not even in the car.
Make a seat, like you said.
Yeah.
It's her. No doubt.
The right. You didn't
Still in this car.
But he asked.
But yeah, I didn't miss the weapon. No.
Yes, I said he rolled it, trigger and everything 2 times.
Well, that's what he said. The other witnesses didn't say that, but that he punched him on the ground and kicked him in the stomach or something like that. It was 2 times. So, yeah. I will think it's this for sure. I read it either. I just got it today.
All right, Ms. Bray, are you ready to pivot to Mr. Hurd, or you need a minute?
I'm ready to pivot now.
All right. Mr. Hurd, I'm Judge McBurney. I have been assigned your case for purposes of bond. Your case is unindicted, and as long as it remains unindicted, if there are any questions about bond or whatever else is going on with your case, it'll come to me. If and when the state does indict your case, it'll be randomly assigned to one of 15 judges, of which I'm one. So it may get assigned to me, but if it does, that's a coincidence. It's not because I dealt with the bond in your case.
Yes.
All we're going to talk about today is bond. Ms. Bray is going to share with me her thoughts about why you should have a bond and what that bond should look like. Mr. Abate, who is one of the murder prosecutors with the district attorney's office, will give me his view, and I'm going to let you know what I'm going to do about bond. You have not been in jail for very long. It may seem like it's been a while, but right now I'll be working through whether bond's appropriate. And at the end of our conversation today, I'll also let you know if I don't grant you bond, what the horizon looks like, because at 90 days, there's another conversation we have to have if your case has not been indicted. Okay? All right. When you're ready, Ms. Bray.
All right, Your Honor. Your Honor, before you is Terrence Hurd. Mr. Hurd is 49 years old, born and raised here in the Metro Atlanta area, Your Honor. He is a 1991 graduate of Booker T. Washington. He also completed a year at Atlanta Metro College. He currently resides with his fiancee, Miss Kenya Williams, and that is at the address that pretrial has, the 3200 Cushman Circle, Southwest Apartment L6 here in Atlanta, Georgia. He is the, did somebody say something? No.
No, we're good.
We're good?
Yep.
Okay. Your Honor, he is a proud father of 6 children. All of them are adults, 4 girls, 2 boys. 4 of them reside here in Georgia. He has 2 adult children that live in North Carolina. He is the grandfather of 13 grandchildren, Your Honor. Mr. Hurd is someone who has always been employed and acted as a productive citizen, Your Honor. Prior to his arrest, he was employed with Battery Systems, which is located off of Lanier Parkway in DeKalb County. He's been there for the last year. Prior to that, he was employed with Ashley Furniture for about a year. And prior to that, he was a driver for Amazon for 3 years. Prior to that, he worked as a tutor with the Atlanta Public School Systems. He did that for quite a while. Then the cheating scandal happened with the teachers, right? And so a lot of the tutors were let go. I'm just pointing, and he had been with APS for years. So I'm just pointing out that he's always been employed and he continues to be employed. He is not someone who is in and out of trouble, Your Honor. I believe any of his past history would be old things that happened like in the early 90s. The latest thing I was aware of was maybe a driving with suspended license or some kind of license offense from maybe 2017, 2018. Nothing since. I did speak with his brother yesterday, Barrick, V as in Victor, A-R-R-I-C-K, Hurd. So he may be present in the courtroom. The fiance, Kenya Williams, may be present in the courtroom. Again, I didn't check prior to standing up and doing the hearing, Your Honor. I am asking, Your Honor, to take into account his minimal history and set bond on Mr. Hurd's behalf And on his behalf, I would be asking for a $20,000 bond, Your Honor. To briefly go into facts, this incident date, I believe may have happened, say, on a Thursday. But that weekend prior was the 30th high school class reunion from Booker T. Washington that he graduated from. And he did attend that reunion party. Afterwards, there was like an after party at the location.
Where the shooting occurred?
I want to say yes, because that was
Okay.
the strip mall area. So there was like an after party or something going on with lots of people who were present. The victim in the case, Mr. Tigner, is someone that Mr. Hurd knew. I mean, he didn't know him well, but he knew him through
They'd
mutual.
recognize each other.
Yes, he knew
Okay.
him through mutual friends well enough to speak, hey, how you doing? That type thing. On this night, Mr. Tigner had a really nice car. Mr. Hurd asked to use the car, just take it down the street, come back. He didn't get a no from Mr. Tigner, so he did hop in the car, took it down the street, came back. But when he came back, Mr. Tigner was very upset. Mr. Tigner attacked him, physically attacked him. Mr. Tigner had a weapon. Mr. Tigner pistol whipped him with the weapon, with the gun, in front of witnesses. Nobody tried to stop it. Mr. Hurd wasn't even trying to fight back, is my understanding, because Mr. Tigner was so much bigger as well as younger. Plus all of Mr. Tigner's friends were present. So that was not an option. You know, he had no clue that that he was even going to be attacked, because he never had a problem with Mr. Tigner before. So that happened, say, that Saturday. And then leading up to that Thursday, Friday is when this event happened. And they happened to be in the same location at the same time. And at this point, Mr. Hurd knows that Mr. Tigner has a gun because he's been beaten with the gun. He's had the gun, the trigger pulled twice, but the safety was on, but you could hear the clicks. He was terrified. He was still terrified because this is someone who attacked him to what he was thinking was no real reason. So they see each other. And it's my understanding that Mr. Tigner is either inside his vehicle or
The same nice vehicle?
the same nice vehicle, or halfway out of the vehicle, but Mr. Hurd sees him reach. And in his mind, oh my God, he's reaching for a gun, because he's now aware that, hey, he has a gun. He beat me with it. He fired. Mr. Hurd fired. And then he left the scene. He was later questioned by police. And what I've just said is what he informed the police happened, that he was in fear for his life because this man had just attacked him 4 or 5 days earlier. And he really believed that this man was reaching for a gun and was going to kill him. So I am asking Your Honor to set bond on Mr. Hurd's behalf because he has ties to the community. Like I said, he's always been employed. He may have had minor trouble in the early 90s, but nothing major since then. And he is a productive citizen.
And he'd stay at the Cushman Circle apartment
Yes.
with his fiance.
Yes.
Okay. Got it. Thank you.
All right.
Ms. Jackson, what can you share with me about Mr. Hurd's criminal history?
The defendant has 10 cycles. The defendant's last arrest was July the 2nd, 2015 in Fulton County for driving without a valid license. That charge was null pros on July the 12th, 2018. did see one misdemeanor conviction listed in the GCIC, and that was in 1995 for possession of marijuana less than an ounce. I did not see any felony convictions listed in the GCIC, Your Honor.
Thank you so much.
Yes, sir.
Mr. Abate.
Thank you, Judge. I would not disagree with Ms. Bray. I don't believe the defendant would be considered a flight risk, as all of his ties seem to be here in the city of Atlanta, Fulton County. What I would submit to the court is that the defendant is an extreme threat or danger to the community and the people in it, based on the facts and circumstances of this case. As Ms. Bray did describe to you a little bit about the background of this case, this is clearly what I would call a revenge shooting. There was a homecoming event the week prior, and they did, both Mr. Tigner and Mr. Hurd did get into an argument because Mr. Hurd used Mr. Tigner's vehicle when he wasn't authorized.
So they're not classmates. It sounds like from Ms. Bray, they would know each other either from the neighborhood or because we're both alums of Booker T, but they weren't contemporaries.
That's correct.
Okay.
It's my understanding that they had known each other for many years, actually, and that there had been at times where Mr. Hurd had loaned money to the defendant when he was having some hard times.
Mr. Tigner loaned money to Mr. Hurd.
That's correct.
Okay.
But on that night, when he took Mr. Tigner's vehicle, there was a pretty heated exchange that involved fists. I think the characterization of the defendant being pistol whipped is something that the defendant has said. I didn't find any other witnesses in reading the materials that I had that anyone had said the defendant, or that the victim in this case pistol whipped the defendant on that night. What was clear is that there was punching, and at times there was, I guess, some kicking on the ground. But in the photos that were taken upon the defendant's arrest, which were a little bit less than a week later, he had a small scratch above his eyebrow, but that was the only injuries that the detectives could locate on the defendant. But what I would say to the court is that happened approximately a week before the shooting. This entire incident is caught on video surveillance. And on the video surveillance, you can see the defendant park his vehicle after he sees that Mr. Tigner is parked in the Sunset Plaza shopping center. You see Mr. Hurd kind of surreptitiously begin to approach Mr. Tigner's vehicle, in which he is sitting in the vehicle. Doors are closed, and there's no gun found in the vehicle. So this narrative that Mr. Hurd shot Mr. Tigner because he saw Mr. Tigner reach underneath of the seat. Upon the search of the vehicle, there was absolutely no gun, and that would be virtually impossible because the door was closed. You see on video, the defendant then opened fire more than 10 rounds into the vehicle in which Mr. Tigner sat and died. He shot 8 times. The police are immediately called. The defendant then flees the scene and attempts to hide the gun at his aunt's house. The detectives do a search warrant for his aunt's house. Upon getting some information that the defendant fled to that location and were able to recover the firearm. Upon his arrest, he told the detectives that he had no idea what they were talking about, that he wasn't involved in any incident that occurred at Sunset Plaza on October 27th. But after being Mirandized, the detectives then made very clear that this was all caught on video. And that's when he decided to say that he was scared for his life on that day. And that's why he opened fired at 11:34 a.m. in a public parking lot where there were many bystanders who could have been shot, 1, and 2 witnessed the event and positively identified the defendant as committing the shooting. I would agree with Ms. Bray as well as Ms. Jackson that the defendant has no felony history. He does have an armed robbery from the early 90s, but it appears to have been dead docketed. He does have a series of misdemeanor arrests and convictions stemming from driving on suspended license to what I believe to be simple battery. So nothing extreme like this event, Your Honor.
Did you say that the video would show that Mr. Tigner never opened his car door? In other words, he was shot through a closed door, or the door opened and Mr. Tigner was trying to get out and was shot. Or I couldn't tell from what you were saying. I could tell from what Ms. Bray said, that it sounds like Mr. Hurd's version of events was, we saw each other and it looked like there was going to be an encounter. I saw him reaching for something, and so I shot him. If I'm curious if what you believe is that the evidence would show the doors to Mr. Tigner's car never opened.
That's what I would believe the evidence would show, and the video evidence shows that actually the victim, Mr. Tigner, had absolutely no idea that Mr. Hurd was even in the vicinity and approaching his car, armed with a firearm and getting ready to open fire and take his life.
Okay. All right. Is there anyone from Mr. Tigner's family who wants to be heard at this time?
Yes, Your Honor. There are two individuals from Mr. Tigner's family, three. His daughter, his fiance, and then his sister would like to make short statements to the court.
Okay. Well, we didn't do this because of my mistake with Mr. Snelling's family. The way this works is that anyone who wants to be heard, and you've got an absolute right to be heard, if you'd come on up to the corner of the prosecution's table, that would be great.
I'm gonna let you guys take my seat so you can speak directly into the microphone.
That's even better. Thank you, Mr. Abate. So whoever's going first, take Mr. Abate's seat and introduce yourself. I'll need your name and your connection to Mr. Tigner.
Good morning. Good morning. My name is Shakija Marshall. I'm the fiance of Mr. David Tigner.
Good morning, ma'am. Thank you for being here.
Good morning. Thank you, Judge, for giving me the opportunity to speak for my now deceased fiance. Mr. Hurd reckless actions has completely caused immediate heartache, anxiety, trauma, and a financial burden on my family. My fiance was taken from his 6 children, the youngest, my daughter, being 4 years old, his family, friends, and the rest of the community. We haven't been able to get adequate sleep or eat normally. My daughter had an everyday routine with her dad when he took her to daycare and when he took her home at night. Since he took her superhero dad away, I haven't been able to return to work. She has a fear of us being at home alone. She has a fear that when somebody leaves, that they're not coming back. I have been having anxiety attacks and uncontrollable emotional outbursts since my fiance David was taken away from us. With the holidays being here, it hurts us even more because he loved being around his family at this time, getting the food menu together, laughing, talking, and just being the light of our lives. Judge, I ask, please don't provide this man a bond. This was a planned and plotted attack on my fiance. We have fear that if he is released, that he may hurt us by knowing our family and where we live. Your Honor, this vicious act of violence was committed in broad daylight with not a care in the world. Your Honor, we plead with you to deny Mr. Hurd a bond. Thank you again, Your Honor, for letting me speak.
Thank you, Ms. Marshall. Where were you working before?
The United States Postal Service.
Okay, and you're not back to work yet?
No, sir.
Okay. Are they giving you leave?
No, not right now.
Okay.
They were at first, but not right now.
They've stopped.
Yes.
You mentioned 6 kids. Are those 6 children you had with Mr. Tigner, or they were 6 children who were important in his life?
6 children total, and my 4-year-old is the youngest, but the children are here today.
Okay. All right. I appreciate you being here and sharing that.
Thank you. Good morning. My name is Deshaun Quarterman. I am the oldest of David Tigner. Since the passing of my father, I've been feeling all alone in this world. We talk to my dad every day. I miss him, Wayne, at the school, at my school, in my office for me. He dropped my sister off every morning. Every Friday, he cooked for my parents, my staff. He was there every Friday giving away free food. My daddy just had the giveaway to the kids and everybody that go there. I try so hard to keep my head high and stand strong for my other siblings who are also feeling empty inside. Without our father, it's very hard. My father wasn't the only victim. His family and community are also victims. He don't deserve to be on the street, walking freely while we suffer in depression. I fear for my life seeing him on the streets, Your Honor. That Tuesday, my dad came in, Wednesday he came in. He told me that he just had seen Mr. Hurd where he shot him at. I feel like it was a planned attack. I am begging you to deny his bond. Please help bring some comfort to our family and community. No bond would keep our community safe. My daddy did a lot for his family, friends, and the community. He was my hero. He didn't deserve this.
Ms. Quarterman, tell me what you do. It sounds like your dad would come to your work and cook, you said, for your staff. What do
For
you
my
do?
staff, I own a daycare right here on the end of the street at
Okay.
180 Memorial Drive.
Got it. And what did your father do besides cook for your staff?
He was an entrepreneur. He had his own trucking company.
Mhm.
And that was about it.
Okay. All right. Well, I appreciate you being here and sharing this, and I'm sorry for your loss.
Thank you.
You're welcome.
Good morning, Your Honor.
Good morning.
My name is Yvonne Tigner, and I am the sibling of David Tigner. My brother David was a family man. He loved just being with family, just loved being with us. And he felt that family was the most important thing at this, point in time in life. He was a father, an uncle, a brother, a son, and a man that met no strangers. David was a pillar at home and in the community. He would often help others while still making a way for his family. The impact of his passing has left a huge void in our lives. For David was truly a blessing to us. This suspect should not receive bond because he knew my brother. This is the same young man that my brother has fed. Not only fed, Your Honor, this is the same young man that my brother has given money to help him pay his bills, his rent. So he knew my brother very well, very well. This young man also has knowledge of where my brother and his family live. This suspect's family lives right here in Atlanta. And he could possibly try to influence family and or witnesses to help him avoid prosecution. My mother, my son, my brother's kids, and his grandkids are all nervous as to whether or not this young man, this suspect, will stay incarcerated or be released. I am begging you, Your Honor, please deny bond to this suspect to help give my family some sense of security and peace.
Thank you, Ms. Tigner.
Thank you.
Mr. Abate, anything else on behalf of the state?
No, Your Honor, we just respectfully request you deny defense counsel's motion for bond at this time for the reasons stated prior.
All right. Ms. Bray, anything else you want to add?
Your Honor, just that, once Mr. Hurd arrived to the Fulton County Jail, you know how they'll keep you down in intake for so many days before they decide where they're going to send you. At that time, Mr. Hurd became aware of threats that have been made by Mr. Tigner's associates. Daughter said he was an entrepreneur. His associates have, according to Mr. Hurd's fiance and to Mr. Hurd, what he heard himself, have placed a bounty on Mr. Hurd's head. As you know, the jail is a dangerous place due to the overcrowding. I don't even know what all else, probably the gang issue, but I do want Your Honor to take into account, he's 49. And he doesn't.
Hey. Sorry, Ms. Bray, keep going.
I know. So he's 49. You heard what the history was. And as I had stated, yeah, there was something way back in the early 90s
Right.
that didn't pan out. That was the only thing in his history like that, Your Honor.
Right.
And that he's not a flight risk. He is not a danger to any of them. I believe some of them might be a danger to him. So again, I am asking Your Honor to please set a bond, and I'm asking for a $20,000 bond.
Okay, thank you. Mr. Hurd, I will do what I can to make sure you are in a place where you will be isolated from some of the threats that Ms. Bray has relayed, and the more information you can get her, then she can get to me, the easier it will be for me to make sure that you can be as safe as possible. I don't think bond is appropriate at this time based on what I've heard. I don't find that you're a flight risk. It sounds like you have lots of anchors in the community. But I do worry about the safety of the community based on the things that I've learned during the course of your bond hearing. I'm going to ask Mr. Abate to do his best to get to Ms. Bray the surveillance footage or stills from it. And I'm going to give Ms. Bray an opportunity to review it. If the video shows that Mr. Tigner never opened the door to his car, never tried to get out of his car, but it shows more along the lines of what Mr. Abate described, then I don't think bond is appropriate. And it sounds like this was more of a vengeance situation than a self-defense situation. And I worry that whatever's going on with Mr. Tigner's extended family, and you could only escalate. And so I'm not saying I'm holding you in custody for your own safety. That would be reversing things. But I do think that in terms of avoiding any risks to witnesses, et cetera, and maintaining the safety of the community, keeping you in custody is the right decision. But two things could happen between now and the time of your indictment that would be a reason for us to have another conversation about this. One is what I alluded to at the beginning. If 90 days have passed from the date you were arrested and you haven't been indicted, I have to set a bond. It doesn't matter what I think is the right thing. I mean, it may be a big bond. It probably would be more than 20,000, but I'm required by law to set a bond for you if it's been 90 days and you are not indicted. That's number one. Number two is what I just talked about, which is if Ms. Bray takes a look at this video and thinks I should look at it, and it shows Mr. Tigner getting out of the car and he's reaching for his waistband or something like that, that's a very, very different setting than what I heard from the state. And I appreciate always two versions of the story. I've come to learn that. And the truth is usually somewhere down the middle. Sometimes it's spot on with what one person says. But based on what I've heard, I think that I maximize community safety by leaving you in custody. But I am open to revisiting this either at the 90-day mark, or should Ms. Bray, after she gets some of the initial discovery, think that it makes sense for us to reconvene so that I can review some of what she reviewed. Ms. Bray, any questions or anything else on behalf of Mr. Hurd?
No, Your Honor.
Okay. Mr. Abate, will you or a colleague of yours work to get something to Ms. Bray, not necessarily this week, but maybe early next week?
Yes, Judge, I have gotten a supplemental report from Detective McClure. I will get to her today. I'm working on getting the video surveillance. So as soon as I get that, I will also send a Dropbox link. to
Great.
Ms. Bray.
Okay, perfect. Thank you so much.
I am aware that his 90th day, Mr. Hurd's 90th day and Mr. Small's 90th day is going to be around January 26th. Do you happen to know what your calendar?
I didn't look,
It won't be necessary. We'll have an indicted before then.
Both of them?
but just in case, so we all know, that's actually a good week. That's a civil trial week. That's all right, civil trial week. So that Friday, the 27th, I would be available to work through something. So that might be day 92, but it won't be, hey, I'll see you in May.
Okay.
I heard Mr. Abate as well, so it may be moot,
Right.
but
maybe.
the best laid plans, things can come up. So you may want to reach out to Ms. Nelson if we're getting halfway through January and there hasn't been the progress the state forecasts, then we can put it on a calendar. We can always cancel it if on January 23rd, 2 true bills come out. Okay? All right.
Today.
I think it was Karen.
I thought it was a girl at first. I'm gonna have to wait to get it, y'all, so they don't shock me. Cause you know, I'm ready.
Lang, L-A-N-G.
Yeah, him.
Yeah, could be indicted today. Yes, ma'am.
That's quick. One of these?
Oh, no, you're on.
Oh,
No. Another one.
Earlier
I was
work.
asking, yes, it's right at the 90th day, and I'm like, okay, what's going on with that?
Three things. One, did we get an update from South Annex about Miss Singer? She's not available. So you're welcome to stick around, but we won't be able to handle her situation today.
I guess I'll just think about with Mr. Hand and Ms. Nelson, we'll find the soonest appropriate day.
Great.
Okay.
All right.
Are we excused from Monday, or should I appear?
No, don't appear on Monday, the Monday after Thanksgiving. No, and we need to figure out when we're going to do it, but you have always said it's going to be a plea. And it's just, Ms. Singer is a hard person to get. She's got commitments in many places, none of which she wants, I'm sure.
I'm just worried about that Capri page.
Page is good.
Yeah. So that Wednesday, we have Zoom calendar space. So it would like, if she has to be remote, it would likely be that Wednesday, which would be the 30th. Okay. Have a good holiday. Ms. Bray, you have a good, you're still here. If you,
I'm gonna hang out with Mr. Lane.
All right.
until he's done.
so this is number 2. Who do you want to just start with Mr. Beasley, or is there a particular order, Mr. Lang, you want to go in?
We can take them down the calendar, Your Honor.
Okay, so we'll do Beasley, but before that, is there a Ms. Hoag here? She might be outside. Okay, well, after we get Mr. Beasley in here, if you'll just get this to Ms. Hoag. Thanks. This is a presiding thing. Hoag. Oh, should I give it to him? You got it? Is she out there?
Yeah.
She's got it. Are you Ms. Hoag? Great. I just signed the stuff. Ms. Niles is coming around. She'll get it to you, okay? You're welcome. All right, Mr. Beasley, please.
Beasley. So Ms. Correa is our attorney. She was not able to be here today. Mr. Lang, I work with her.
Yeah, and I'll just go ahead and give her
This is right next to hers. I have your file. I've gone over it. So if your family is here, they're gonna read character statements, they're gonna read information that supports you. And I'm gonna make sure the judge knows that there's a self-defense situation, that you yourself were shot and injured during this incident. And make sure the judge knows it.
Mr. Lang, we can hear what you're saying to your client.
All right.
You want to make that red,
It won't turn off for some
but
reason.
hold your finger on it.
There we go. All right. Turn it back on.
Thank you, Mr. Whitenauer.
Yes, Judge.
All right. This is 22 CP 213-229, State versus Ernest Beasley. Hello, Mr. Beasley.
How you doing, Your
I'm okay. I'm Judge McBurney, and I have your case for purposes of bond. Your case is unindicted, and as long as it remains unindicted, if there's anything we need to do with it, it'll come to me. Once it's indicted, assuming it will be indicted, it will be randomly assigned to one of 15 judges. I'm one of those judges, so we may keep working together after indictment, but if so, that's just a coincidence. And frankly, chances are it won't get assigned to me because it's only a 1 in 15 chance. But as long as you're not indicted, Mr. Lang or Ms. Correa will be assisting you with questions of bond. And that's all we're talking about today. Mr. Lang will tell me in a few minutes why you ought to get a bond in your case. And Mr. Abate, who is a prosecutor, not necessarily the one who'll keep your case, is going to share with me the state's view about whether you should get a bond or not. I also may hear from members of Mr. Malone's family. That's the deceased in this case. And they have a right to be heard if there's something that they want to share with me. Mr. Lang, when you're ready.
Yes, Your Honor. Your Honor, before you is Mr. Ernest Beasley. In this matter, Your Honor, first I want to give Your Honor a little bit of a factual summary. In the allegations in this case, the incident location was a 110 Victor. Mr. Beasley at the time of this was living at 125 Victor. So this happened in his neighborhood in the location where he lived. There was a gathering happening in the community. Mr. Beasley was present at that gathering. A fight broke out between two people in that gathering.
Not include, as I understand it, not including Mr. Beasley.
Correct, Your Honor.
Two other people are fighting.
Two other people. And then during that altercation, a gunshot was fired. Mr. Beasley reacted by defending himself and trying to defend the others around him. And that brought forth the allegations we have before Your Honor today. Some things I think are important to note to the court regarding factual circumstance. Mr. Beasley remained on scene. He did not flee. He was one of the individuals who called 911 and brought police to the scene. He surrendered himself immediately to law enforcement to answer any questions they had and cooperated with them in every way, shape, and form. He never tried to flee the scene. He never tried to remove himself from the scene, nor did he ever try in any way to obstruct the investigation or the officers in the scene.
I'm sorry to interrupt. Did he hand over the weapon that he used in self-defense?
That's my understanding, Your Honor, is that the weapon was surrendered to officers on the scene. It was never hidden or disposed of in any way. His story has remained the same from that very day to this very day. of exactly what happened, that any and all actions taken during this were in self-defense. With regards to the Ayala factors, Mr. Beasley is 48 years old. He's a lifelong resident of this Atlanta area. He has extensive family ties here, including a large number of family that are here today. Specifically, his sister Samaya and another family, Aisha, are both here who would like to read character statements to the court if the court would allow it. Additionally, he has two children, two grown children, aged 25 and 23, as well as one grandchild. He has his 10th grade education. He currently works for a contracting company called Johnny and Sons. His uncle owns that company, has owned that company for 30 years. Has owned that company for more than 30 years. Mr. Beasley has worked with that company since he was 18, so for the last 30 years of his life.
He'd be able to go back there?
Yes,
if
Your Honor.
allowed to work while on bond?
Absolutely, Your Honor.
Okay.
He works there both operating a bobcat and laying concrete. He's also currently working with the Atlanta workforce and a means to get his CDL so he can start driving trucks. We've spoken to Mr. Beasley about the specifics of this case. Mr. Beasley would be more than willing to submit to an ankle monitor if he were given a bond. He has no reason to leave, not even just the state of Georgia, but really the city of Atlanta, Fulton County. He can subject himself to any requirements of the court. The ask is that he be allowed to leave on bond and be allowed to return to his family. I would ask the court in this case to set a bond not in excess of $35,000. And then, as I stated, there are two family members who would like to read character statements for Your Honor.
All right, well, why don't we do that? If you could have them, and they can either, it's probably best if they sat in your chair and spoke into the microphone. So just however the deputies want you to get there is fine with me.
Let the judge know who you are first.
Okay. How you doing?
I'm doing well. How are you doing?
I'm good.
If you don't mind taking your mask off, that'll make it easier for while you're talking. If you just introduce yourself so the court reporter can make a record of who you are, and then I'm happy to hear from you.
Okay. Okay, good morning, Judge McBurney. My name is Samaya Rasul.
Can you spell your last name?
Yes, RASOOL.
All right, Ms. Rasul.
I'm Ernest's little sister. You need anything else?
Pardon me?
Did you need anything else?
Anything, you can tell me whatever you want to tell me. So I know who you are, and you're Ms. Rasul, your little sister.
Okay. So I'm gonna start off saying I'm a business owner in the state of Georgia. I am writing on the behalf of my brother Ernest Beasley, asking, can you please grant him a bond today? Judge McBurney, my brother is a great person, very supportive, excellent father, and very business-minded. Overall, a great guy. This is a very unfortunate incident. Ernest have never been a violent person. My brother had no other choice but to defend himself. I don't know if any of y'all know, but he was shot as well.
Let me unpackage that last thing you said.
Okay.
Meaning you're saying that in this incident, your brother was shot, or historically, like 5 years ago, your brother was shot?
No, he was shot years ago too, but he was shot in this incident.
Okay.
Yes. Judge, if you can please consider, Ernest stayed on the scene of the incident, waited for the police, but he called the police, waited for the police to arrive, and did everything the police asked him to do. I was literally in my bed at 3 o'clock in the morning when they called me. The police and Ernest. And it was a terrible scene, horrible, and sorry for the family. We apologize. But, and it's very bad, but Ernest is not a violent person. My brother was leasing a home on the street where the incident took place. And I would like to correct, Ernest stayed at 110, and where the incident where it happened at, it was 125.
Okay.
Okay, just wanted to reiterate that.
Do you have any idea where your brother would stay? He's not going back to that neighborhood.
Oh, he's staying with me. I
I have a great home in the Camp Creek area marketplace.
Okay.
Yes.
And your brother would be able to stay with you?
He can stay with me. I have a guest room.
Okay.
Yes, I have a guest room. Okay, where I left off at. Okay, and he was not looking for trouble. My brother was living in a community where he stayed. He stayed there. Ernest worked full-time, very hard with his uncle concrete business, and come to help me with my clothing business part-time. So he do come to help me as well. In addition, Judge, if you decide to grant Ernest a bond, he will be, I'm sorry, I have this in here too, even though we just talked about it.
That's all right.
Okay, in addition, Judge, if you decide to grant Ernest a bond, he will be residing with me in a safe area at the above address. Oh, my address on here, I don't want to give it out.
You don't need to give it out.
Okay.
If I'm gonna grant a bond, it
Okay.
sounds like that's where he'll be staying and
Absolutely.
Mr. Lang can get, it'll be in the bond order, so it's not gonna be secret, but you don't need to share it right now.
Okay. Also, Judge, he has family support, including myself, my mother. We have brothers, other sisters, and this is the only area we have ever been in is in Georgia. He will not go anywhere. He will definitely, if you can, and if it's, if it helps, can you please put him on an ankle monitor, or he will always be around us. He would never go back to that community again.
I don't know where Victor Street is. If
Mhm.
you're on Camp Creek, how far
Oh,
away?
it's way far. It'd probably take about 25 minutes to even get there.
What neighborhood would you describe Victor being in?
A regular neighborhood?
No, but is it like Mechanicsville or Buckhead?
Oh, I don't
or
even know the area. I think
Peoplestown?
it's like the north side of Atlanta.
Okay,
I stay on the south side of Atlanta.
okay.
I'm sorry, yeah,
Northwest.
northwest.
Atlanta?
Yeah, and
Okay.
Camp Creek is,
I know where Camp Creek
Oh,
is. So,
okay.
so Victor is up by like Bolton and,
No, if you come out of Fulton County Jail and take a right and go up Chapel Road,
Yeah.
off of Bankhead, and go on up Chapel, you can turn on Easton and go across Holly, and that's Victor Street.
got it. Okay, thank you. That is not near Camp Creek.
and one more thing, Judge, Ernest have never violently hurt anyone. He's just not that type of person. It's just, life happens. And so, I'm sorry.
Okay,
Okay.
thank you, Ms.
All right,
Resel. I
thank you.
appreciate it. Mr. Lang, who else?
Another family member, Aisha. Ms. Rosal.
Good morning, Judge. How are you?
I'm well. How are you?
I'm doing pretty good. Again, my name is Aisha. I'm Ernest's younger sister.
Is your last name Beasley?
Beasley.
Beasley? All right.
Yes. His mother is here today as well. And we just want to,
So you're another sister?
yes,
Okay, got it.
yes, I came right after him.
All right.
And if you would please grant him bond. Like my sister said, he has somewhere to stay. He works. He's a good person. He's not violent. We love him dearly. It's unfortunate what happened, and so sorry to the family for what happened, but I truly believe what he said. He acted in self-defense. He's spoken a few times to my sister, some encounters that he's had with the young man. And he did stay on the scene. He did initiate the call for the police. And since this has happened, every time I speak with him, he's adamant on this being self-defense. My brother loves animals. He's crazy about dogs. Has been that way since we were kids. We just ask that you grant him a bond. He's a good person. He really is. Never been violent. Doesn't have a violent history. And he acted, I believe him when he says that. So if you would please grant him bond, we miss him. He, between her home and my home as well, I have a home in Atlanta, south side of Atlanta, Clayton County area. So between.
He'd
the
need
both-
to stay, he wouldn't be able to your brother wouldn't be able to
Well,
bounce back and forth.
just to let you know that he has support, he has
Got it.
places, he has homes to go to.
Okay,
And we love him, we miss him, and we just want him home. And if you would please find it in your heart today to grant him a bond.
okay. Thank you, Ms. Beasley, for being here.
Thank you, sir.
All right.
All right.
Mr. Lang, anything else? There was a hand that went up. Now, if there's anyone here on behalf of Mr. Malone, that time will come. I promise. I'll talk with Mr. Abate and then any family members of Mr. Malone who may have a very different perspective. But right now is the time for the defense to make their presentation, which Mr. Lang has done. And he's had Ms. Razul and Ms. Beasley share things. Anything else?
Not at this time, Your Honor. I would just ask after we hear the criminal history that I be allowed to sum up.
Sure. Okay. So we'll do that, meaning at the very end, or you want to hear the criminal history now?
Whichever works better. for Your Honor.
You'll go at the very end because that way you can respond to things you may have heard from Mr. Abate. Ms. Jackson, could you share with me what you've got as to Mr. Beasley's criminal history?
Yes, Your Honor. The defendant has 38 cycles. The defendant's last arrest was October the 10th, 2019 in Lake City, Georgia for criminal trespassing. And there appears to be an outstanding hold in Douglasville, Georgia for criminal trespassing. The date on that warrant was January the 12th, 2022. The defendant does have prior felony convictions. One in 2004 for possession of controlled substance and possession of a firearm by a convicted felon. There was one in 1998 for possession of controlled substance. And the defendant does have misdemeanor convictions. One in 2019 out of Clayton County from the Lake City incident for criminal trespassing. And there was one in 2019 for a DUI, and one in 2002 for battery, family violence. Nothing in addition, Your Honor.
Thank you so much, Ms. Jackson. Mr. Lang, I do have two questions that you can be thinking about. If you want to answer later, you may have an answer now. One is if you could amplify a little bit on Mr. Beasley having been shot in this incident. And then two, I'm just trying to process the 38 cycles, what they're based on. From what I heard from Ms. Jackson, it sounds like there may be a substance abuse issue that we ought to be thoughtful of. If I'm fashioning conditions of bond, Mr. Beasley would obviously need to stay out of trouble. No guns, stay far, far away from Mr. Malone's family, et cetera. But he also would need to be complying with the law in other ways as well. And so just that criminal history suggests to me that could be something he's working through. All right, Mr. Abate.
Thank you, Judge. I would respectfully request you deny defense counsel's motion for bond for several reasons. I would submit to the court that the defendant is a risk of flight. He does have 3 prior failure to appears, 2 out of Fulton County, 1 out of Fayette. They are older. I will let the court know as to the 2. There was 1 in 2000 in Fulton County, 1 in 2001 from Fayette County, and 1 in 2004 here in Fulton County. I would submit to the court, he's also a risk of flight as if he is convicted of these charges, he's facing a mandatory life without the possibility of parole sentence, as he does have 3 prior felony convictions. Based upon that, Your Honor, I would submit that he's also a risk of committing felonies pending trial. He does have a February 17th of 1998 conviction. It is a possession of cocaine here in Fulton County. The case number was Z97212, where he received 2 years probation. He also has 2 prior trafficking cocaine convictions here out of Fulton County. The first case number is Y15686, and the second is 04SC17054. He was sentenced to both of those cases on the same day, where he received 15 years to serve for each of those offenses in front of Judge Constance Russell. He was paroled from my records for both of those cases that ran concurrently in 2010, Your Honor. I would submit to the court that he's also a threat or danger to the people in the community. To touch on the fact, I was actually just texting with the detective because the news of Mr. Beasley being shot was news to me. I've confirmed that he was not shot. He was not bleeding on scene. As defense counsel did state to the court, he remained on scene. So I would submit to the court that he's a danger to the community and the people in it, based on the facts and circumstances, which the court alluded to, was that there was a fight in the yard at this gathering at the 125 Victor Circle address here in Atlanta, that Mr. Beasley had nothing to do with. He was actually inside of the home with the party. There was a gunshot that was heard outside. And that is when Mr. Beasley picked up his assault rifle, came out and opened fired on the victim, in this case, Mr. Malone. He actually stood over the victim after he fell and continued to shoot him. And as he continued to shoot him, and as Mr. Malone died, he kept kicking him with his foot, saying a lot of inappropriate things, but some of which would include die, N-word, die, N-word, die over and over again, and then continued to shoot him. Mr. Malone never pointed a firearm, threatened Mr. Beasley in any way. So this contention that this was self-defense is not true, to be frank with the court. Mr. Beasley's sister says this incident was incredibly unfortunate. This incident is not unfortunate. It didn't have to happen at all. If Mr. Beasley would have stayed inside and minded his own business and not picked up his assault rifle, which he was not entitled to carry since he's a 3-time convicted felon, this would have never happened. It was completely preventable.
How many times was Mr. Malone shot based on the information you have?
Over 13 times, Your Honor.
Okay.
I would also submit to the court that he's a risk of intimidating witnesses, as there were several witnesses on scene who positively identified him and provided the accounts that I provided to the court, that Mr. Beasley was inside, came running out and shooting at the victim with his assault rifle. Mr. Beasley, like as the court heard, did stay on scene, but relayed to the officers that they were inside of the house at this party. The victim pointed a gun at him, and he immediately, when they got outside, and that's when Mr. Beasley shot. That, based on all the witness statements and testimony that the officers received, is just not the case in this instance, and that this is not a case of self-defense. This is a case of senseless gun violence, to be completely candid with the court.
Just so I'm trying to follow what you're saying. You agree that Mr. Beasley has given a consistent story to law enforcement, and what we heard today is consistent with what Mr. Beasley told law enforcement, but you're saying that statement is inconsistent with what all the witnesses have said, which is it doesn't sound like self-defense, that there was something going on outside and Mr. Beasley injected himself into that, didn't fire a shot in the air, but in fact fired at least 13 rounds into someone, including some when that someone, Mr. Malone, was on the ground.
That's correct. And to be concise with the court and correct, Mr. Beasley contended or told the Detective Logan, that Joshua Malone just showed up at the house. When Mr. Malone saw him, he just started shooting at Mr. Beasley, which caused Mr. Beasley to return fire with his assault rifle. That is highly not the case, because there's no shell casings that would indicate that Mr. Beasley ever fired, or excuse me, Mr. Malone ever fired at Mr. Beasley. And the witness statements and ID, I guess, the people who were at the incident made clear that there was this fight between Mr. Malone and a guy named Dun outside. Mr. Beasley decided that after he heard a gunshot outside to go grab his rifle and just gun down Mr. Beasley.
Mr. Malone.
Mr. Malone, I apologize, Judge.
Okay.
There are 2 family members on behalf of Mr. Malone. His mother, Ms. Roberson, and his fiance, Ms. Hill, would like to address the court when the court deems appropriate.
If you're done, I'm happy to hear from them. Is there more you wanted to share?
No, Your Honor, I'm done.
Okay. So Ms. Roberson and Ms. Hill. Okay.
Good morning, Your Honor.
Good morning. Are you Ms. Roberson or Ms. Hill?
I'm Ms. Hill.
Ms. Hill, tell me how you're connected to Mr. Malone.
I'm Joshua's Malone fiance.
Fiance?
Yes.
Okay.
Good morning, Your Honor. Thank you for this time to take what I have to say in consideration. Joshua leaves behind his our 14-year-old daughter who now has no father. Myself, which now have relocated myself here to Georgia, to not have him. The suspect is a danger to the community by involving himself with the assault rifle. How can he get his family? How can he go back to his family when we're trying to pace back our lives? Joshua's birthday is in 2 weeks. We're trying to figure out how we're going to go through the holidays, his birthdays without him. How can he go back to be with his loved ones when we're suffering, trying to pace back our lives without him?
Thank you, Ms. Hill.
You're welcome.
Ms. Hill, how old was Mr. Malone? Well, with his birthday that's coming up, how old would he have been?
34.
34? Okay. And had you, the 14-year-old daughter is a child you had with Mr. Malone or?
No, she's from his previous relationship.
Okay,
she's in
but
my-
you're helping take care of her?
Yes.
Okay, thank you.
You're welcome.
Ms. Roberson?
Good morning, Your Honor.
Good morning.
This statement,
Can you tell me how you're connected to Mr. Malone?
Joshua Delmar Malone was my third oldest child. I mean, my second oldest child.
Okay.
He was an awesome baby from, at the age of 1, I was pregnant, getting ready to have another baby. And I said, okay, Josh, you gotta learn how to start walking because I can't carry your sister and carry you too. Well, the next morning he got up and he started walking. Even at 34, Josh was very manable. He was brought up, yes, ma'am, no, ma'am, please, thank you. Very respectable. The part that bothers me, that throws me off from this here, is the fact that Ernest had spoken to us and said, Joshua was fine, Joshua's good. After the incident there was an incident in the prior with Dun, and I told Josh to stay from over there. But Ernest assured me that he was okay, assured my baby girl that he was okay.
So your son, Josh, and Dun, they had issues.
They had issues. As far as Josh knew, him and Ernest was okay to a fact, but Ernest and Dun went farther back than Josh. So it's like, you coming over here, but that's neither here nor there. The day of this incident, Josh had been over there all morning, all day long. Ernest and Dun just decided to show up an hour prior to killing my son. You can already see that they can't be honest because he's either lying to his family or his family is lying for him, which that's family. We sometimes do things that we shouldn't do. That's not correct. And God sees everything, even when you try to lie. He knows that he was not shot. He knows that he was not outside. He knew that he had nothing to do with that, Your Honor. And to give him a bond after he did something like involved yourself in something that you had nothing to do with, number one. Number two, to stand over my son and overkill my child, I don't feel like it would be fair for him to have a bond. I just don't. Speaking on Josh's behalf, Josh has a 14-year-old daughter that he was trying to raise on his own until this young lady relocated to Georgia to be with him and help raise this child. This child won't even go home to her home that he provided for him, her, and his fiance. She won't go there because she's afraid that her dad is not coming home. She slept in the house one night and all night she kept saying, Grandma, come get me. Grandma, come get me. she can't be there because she knows that her dad is not coming back. She calls her daddy to share her day like she does every day. She can't do that anymore. So I'm not saying that I'm being selfish, that they can't see their family members. They can go to the jail and see them. When I put my son in that ground on November 5th, that was my goodbye to my child. I would never see my child's body. I would never hear my child's voice. They still have an option. And he put himself in that situation. If Dun would have shot him like that, it'd have been something different because he was involved in that. Ernest had nothing, Your Honor, to do with that. I don't care what type of lies they tell. There's too many witnesses that says he's a liar. He's being deceitful, and it's not right. And I thank you for your time. And I apologize to his family for having to see their child. And as a mother, I know it hurts that mom to her core because that's her child. And everything she wants to do is save her child. I'm dreaming right now. I woke up just the other night. These kids got to hear me. My child is reaching for me saying, Mom, 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 and I'm reaching for my child and I can't grab him. I can't save him. Your Honor, this lady can still touch her child. And I thank you for your time.
Thank you, Ms. Roberson. Mr. Bata, anything else?
Just that, Your Honor, I think I can shed some light as to why Mr. Beasley was so angry at Mr. Malone. There were some allegations that Mr. Malone was having an affair with Mr. Beasley's significant other, which led to the anger and issues that I guess ended on the night of October 14th, 2022.
Okay. All right. Mr. Lang, I'm happy to let you summarize from the defense perspective. Please include in it, I don't know if it was confusion on people's part, but it's not sounding like your client got shot. And I'm just trying to understand a little bit the dynamic because it's at this very early juncture, it's a self-defense posture. And you laid it out very clearly. And gosh, the way that sounded, as you've heard me say to other folks here this morning, there are always two sides, at least, to a scenario. And it's sounding a little more nuanced than just plain self-defense. But when I heard, I think it was Ms. Razul say, well, yeah, he got shot, so then he got his gun. That's very different from what it sounds like maybe some of the more neutral witnesses would say in terms of what they saw and heard and experienced.
Your Honor, to address that directly, I do not have the video yet, but I understand the body-worn camera of the officers that responded on the scene will show that my client's right calf was covered in blood at the time that he was shown to officers. He still currently has a bullet wound that is scarring over on his right calf from this incident. He was shot. He was injured during this incident.
Video from the homicide. I told him.
Right, I know. There's also video where he confirmed that to the officers that were talking to him, both the homicide investigators and the officers on scene. Your Honor also asked me about the substance abuse issue. I did speak with Mr. Beasley about that. That's not something one can run from. That is a illness that many people suffer from and is very hard to overcome. Mr. Beasley has been clean for the last 6 months with the help of his family. They are his support system. They are helping him stay clean. If given a bond and returning home, he will be able to remain clean with that support system. Whereas if he remains in the Fulton County Jail, we know how much stuff gets into the Fulton County Jail, and it is very difficult when you are struggling with substance abuse to stay clean when it is basically force-fed upon you in the situation you're in.
I didn't ask because it was a reason not to grant bond. It would be a part of the bond conditions that Mr. Beasley continued to address that concern.
But with his family right now, they are his support system. They are the ones helping him stay clean, and they will be the ones helping him do so. Based on all the information presented, Your Honor, there is a reasonable argument here that this is a self-defense case. That is the primary reason we are asking the court to set a bond. If at the end of the day, this is proven to be a self-defense case, Mr. Beasley would be able to A, better assist his counsel while being outside of custody, and B, I think is entitled to a bond at this time.
Okay. So, Mr. Beasley, this is the closest one so far I've heard this morning. What I'm going to do is ask Mr. Abate or someone from his office to get Mr. Lang. How does this work? I don't know, Ms. Correa. Will you keep this, or you will maybe be the channel through which information flows to Ms. Correa?
This will be Ms. Correa's case. She simply had a court conflict today and wasn't able to be present. And since I had other cases on the calendar, I'm covering it for her.
Okay.
I am more than happy to be CC'd on any communications, but this will remain to be Ms. Correa's case.
Got it. So the state will need to get to Ms. Correa, perhaps through Mr. Lang, things like the body cam video, et cetera. These are all things the state ought to be able to get pretty quickly. I need a little more information before I would be comfortable setting a reasonable bond. I always set a bond for $500,000, but I might as well say no bond because that's not a reasonable bond for you. It does sound like there are a series of conditions that would keep you in a safe place and away from Mr. Malone's family. But for me to be comfortable with that, I would need to be more comfortable about this self-defense angle. And I will tell you, hearing that Mr. Malone was shot 13 times, I'm not saying those are the facts. It's just what was relayed to me. That's not so much self-defense. And if Mr. Malone is lying on the ground and you are shooting him as he's lying on the ground, I'm not saying you did. I'm just telling you what I'm processing. That's also not so much self-defense. There seems to be some uncertainty about whether you were shot. I'm not saying you're uncertain. And Mr. Lang provided some pretty persuasive statements just now that you were shot. I need to better understand, and you ought not to say anything right now about what happened then. You can talk to Mr. Lang. He'll decide if he wants to share any of that. But you are on the record in bright spotlight. And so if you were to say, oh, I only shot him 12 times, that will come back to haunt you. So don't say anything right now, but you can talk to Mr. Lang and there may be something you do relate to me. But just to sum up, I am open to the notion of a reasonable bond if I can get more information that really Mr. Lang needs to get first. Well, Ms. Correa needs to get so she can process it. And then we ought to reconvene that would shore up this notion of self-defense, because Mr. Lang's original presentation had me mapping out, all right, you're going to have an ankle monitor. You'll live with Ms. Razul. You'll have a curfew, but you should work. You got a job. That's good. But then I heard the other side, and those conditions wouldn't prevent someone who is already a convicted felon from having an assault rifle. I mean, I'll tell you, that's one of the biggest stumbling blocks, is that I will need to see pretty clear evidence that it was self-defense, because you were not to have had a gun. And there's always the argument to be made, well, wait a minute, I'm saving a life, maybe my own, maybe Dun-Dun's, maybe someone else's, by grabbing this gun I know I shouldn't have. And there may be legal protections you enjoy in a particular setting. But I shifted away from feeling that way after I heard about number of shots, things like that. So I think Ms. Correa needs a chance to get a little more information from the state, and then we can reconvene. The other thing I'll say, I think I said at the beginning, regardless of what I think about self-defense, if the state takes too much time before they indict you, come day 91, you are automatically entitled to a bond. Not necessarily the bond you want, but it would not be a no bond status. So there's time working in your favor when it comes to bond. But I need more information about the self-defense side of this. This isn't where we'll sort it out, because your lawyers need to think about how they want to share information without painting you into a corner they don't want you painted into, given that if this is an indictment, you're facing a pretty serious situation. As Mr. Abate mentioned, should the state choose to recidivize you, which they could, the only sentence you could get if you were found guilty of the murder piece would be life without parole. you die in prison. That's as serious as it gets. So we're dealing with real high stakes here, as we ought to. Someone's dead, and you're admitting you shot the person. So circumstances matter. And so I want to give Ms. Correa a chance to look through things like body cam and whatnot. And she may say, you know what, Mr. Beasley, let's just keep our powder dry on the bond thing right now and work on getting you the most favorable possible disposition, given that there wouldn't be an argument in front of the jury about who shot Mr. Malone, however many times he got shot. You did. It would really be, were you justified in doing it? And that can be a tricky argument if you've got the big gun and Mr. Malone is lying on the ground. That may not be the facts at all. I wasn't there, and I'm certainly not cementing myself into a particular view. I'm just hearing it from two sides. And given that uncertainty, I'm going to ask Mr. Abate to get that kind of information to Ms. Correa, and we can get you back in here almost any day. It may be that you appear virtually and you tell Ms. Correa, that's fine, I'll Zoom in. But you won't be stuck waiting, other than Ms. Correa needs a chance to process some of that. So I said a lot. Why don't you and Mr. Lang, he should mute, and then you guys talk for a second.
So I'll go from down here to my foot. Yes, that's what I'm saying. You can get that video. I know it's video.
So, Your Honor, I understand it will most likely not change Your Honor's decision. I do want to clarify one thing. I misinterpreted something that Mr. Beasley told me, so I want to make sure it's actually stated since he asked me to. What Mr. Beasley was stating to me was that when he was interrogated by homicide detectives, he did show them the specific bullet wound that he sustained that night. It is recorded on the interrogation camera.
Got it.
What he wanted the court to be clear on.
Understood. Okay. And that's one that we get to the bottom of real quickly. I mean, you were shot or you weren't shot. I'm not worried about that so much. And it may be that Mr. Abate is climbing a steep learning curve as well. All right. So Mr. Beasley, I may see you soon. At the latest, I would see you at that 91-day mark if your case hasn't already been indicted. If it does get indicted, you may see me, you may see a different judge, okay?
All right, thanks so much.
We're going to do Meadows once you get Mr. Beasley where he needs to be. I'm ready for a shoplifting case.
Me too, because it wouldn't be mine.
Mr. Hand doesn't want the shoplifting case, though.
Yeah.
Mr. Lang, how long have you been handling these types of calendars? Okay, we hadn't met before, and we only do it like once every 20 weeks. But I usually see Ms. Bray, a couple other folks. Give me 1 second.
We're going to give the judge our information. We're going to do our best to get a bond to that. We talked about this is a hard hearing tomorrow.
All right. This is position 4, 22 CP 213548. It's State versus, do you pronounce your first name Jakara? Jakara? Jakara Meadows. It's Ms. Meadows. Ms. Meadows, you are here today so we can talk about bond in your case. Mr. Lang is going to share with me in a few moments why you ought to get a bond and what that bond would look like. And then Mr. Abate, who is one of the homicide prosecutors with the DA's office, will give me the state's perspective. There may well be family members of Mr. Rhodes that I'll hear from as well. And there may be family members of yours that Mr. Lang wants me to hear from. And at the end, I'll let you know what I'm going to do. But it's just bond for today. As long as your case remains unindicted, you'll see me for issues concerning your case. Once your case is indicted, it'll be assigned to one of 15 different judges. I'm one of those judges, so there's a chance that your case would stay here, but it's a small chance. You'll probably get a different judge, and you'll then get a different lawyer, a colleague of Mr. Lang's, who will then be representing you on whatever you're indicted for. Okay? Mr. Lang?
Your Honor, before you is Ms. Jakara Meadows. She is 19 years old. She has extensive family support in the Atlanta community as well as in the courtroom today. Multiple members of her family are seated behind me. I have spoken with her family about this case. I've spoken with Ms. Meadows about this case. I'm going to start with, again, just a factual summary for Your Honor. In this case, officers were approached by a vehicle that the decedent got out of and walked towards officers stating he had been shot. Officers still do not know where this shooting happened. They're not able to get any surveillance of where the shooting happened or anything to that effect. At a secondary location, the decedent interacted with officers stating that he had been shot. The decedent gave officers my client's name, stating that she drove a red Jeep Compass. I identify that car for a reason. I'll get back to that in a moment, Your Honor.
But what you're saying is that Mr. Rhodes, before he died, told the police that Ms. Meadows shot him.
He identified my client by name, yes, sir.
Okay. May not have been Ms. Meadows, but some name that links back to your client, and also said, hey, she drives a red Jeep Compass.
Correct, Your Honor.
Okay.
The reason I bring that vehicle up is because I spoke to Ms. Meadows. Ms. Meadows has never owned or operated any vehicle that matches that description, nor has any member of her family. I went through with her as many people as I could think of.
Okay.
No one has ever driven or owned a vehicle of that make and model. As it goes to IALA factors, as I stated, Ms. Meadows is 19 years old. She has a 3-year-old son named Loyal who lives with her and her mother. She lives at the Boulevard address on her booking report with her mother. She's lived there for the last 3 years. She previously has worked for a housekeeping company, working as a housekeeper at different hotels. However, at the time of her arrest, she had just started a job at the airport, working with their fresh to order location. She has spoken to that job since her arrest. They are going to try to keep her on. They will be transferring her to a different location, but they do intend to try to keep her on and keep her having a job there. She's born and raised in this area. Her entire family lives here. She's the middle child, having 2 older brothers and a sister, or sorry, 2 brothers and a sister. Again, looking at the specifics of this case, I am asking the court to set a bond not to exceed $35,000. I understand the allegations in this case. However, there are large holes within the police report as to the investigation of this matter and a lot of information that needs to be sought out. I have spoken to Ms. Meadows about her relationship to Mr. Rhodes. There had been a romantic relationship in the past. And not to disparage anyone, but a romantic relationship in which Ms. Meadows was repeatedly abused, manipulated, and controlled. Ms. Meadows finally left that relationship about a month prior to the incident alleged in this matter. Ms. Meadows is unsure why her name was stated. She was with her sister the entire day. She was with her family the entire day. She did not have any interaction with the decedent on that day. So she is unclear as to why her name was brought up. That's something we're going to have to investigate further going down the road. My main goal right now is finding supporting information of she was nowhere near this incident location, and we don't even know where the actual incident happened. But that is the information I have for the court today. Again, I'm asking for a bond not to exceed 35,000. I believe we'll hear that this is my client's first lifetime arrest.
Okay. Well, let's find that out first. Ms. Jackson, can you share with me what you have on Ms. Meadows?
Yes, Your Honor. The defendant does not have any prior arrests on file.
Thank you. Mr. Abate.
Judge, this is ADA John Whitenauer, and I'll be handling this case.
Good. Mr. Abate's eyes got kind of wide when I called his name and there was this silence afterwards. So I'll turn it over to you, Mr. Whitenauer.
John, before you start, I can do it if you want me to.
No, it's all good. Judge, the victim in this case is Cornelius Rhodes, Cornelius, Rhodes, Rhodes. He was 32 years old when Miss Meadows shot and killed him. He was the owner of an insurance company, Rhodes Indemnity, and he was the father of 3 children. It is accurate that he had been in a relationship with Miss Meadows for approximately 5 months. That relationship was ended by Mr. Rhodes on or about July 10th, 2022, when he and some members of his family and Miss Meadows returned from a trip in Florida. And it was only 17 days later that Miss Meadows decided to shoot and kill Mr. Rhodes. How do we know that it was Miss Meadows? Well, on July 27th, 2022, an officer with the Atlanta Police Department was flagged down at the intersection of James P. Brawley and MLK Jr. Drive. And from a red Nissan Altima exited Mr. Rhodes. It was apparent that he had been shot. Officers did observe a wound to his right abdomen and a laceration to his right forearm. Although he was stumbling about, bleeding profusely, and was sluggish and slow, officers were able to ask him some important questions, and he made what we would now call dying declarations to those officers. And those are as follows. He was asked who shot him, and he stated, Jakara Meadows. He was asked if that person was a female, and he nodded his head, indicating yes. He was asked if she drove a vehicle, and he nodded his head yes, and was able to state that she was driving a red Jeep, and was able to also provide the model, a Compass, a Jeep Compass. At that point, he became unresponsive to questions, was ultimately transported to Grady Hospital, where doctors attempted to save his life, but were unable. Perhaps had Miss Meadows not left him for dead and fled in that Jeep Compass, which was his car, and instead attempted to render aid, he'd be with us today, but he is not. She left him to die and remained out until she was arrested on October 28th, 2022. This incident occurred on July 27th of 2022. Warrants were obtained by the detective on September 23rd, 2022, and she was located and arrested about a month later on October 28th of 2022. This motion for bond was filed November 1st. She's been in for 26 days, and so we are still short of the 90-day indictment deadline. Your Honor, I'm not going to argue to the court that this defendant poses a risk of flight because she does not have any failures to appear in her history. Indeed, this is her first and only arrest on her GCIC. I'm not going to argue to the court that she poses a risk of committing further felonies. And I'm not prepared to argue either that she poses a risk of intimidating witnesses. I do not have any information that she has yet done so from either the next of kin in this family or from my review of jail calls. However, Judge, I would argue that she does pose a significant threat and danger to the community and the people in this community, given that this was, from the state's perspective, an unprovoked attack and murder of Mr. Rhodes. And speaking with next of kin, it's my understanding that from their experience with Ms. Meadows, that she is quick to anger and that she is unable to control her impulses. And for that reason, the state is concerned that if she were released, we might see this behavior again. Your Honor, there are several members present today who would like to be heard by the court. First, I would ask that you hear from Ms. Shawana Feliciano. She is the mother of Mr. Rhodes.
All right, Ms. Feliciano, are you here?
She's present on Zoom, Judge.
She's on Zoom. Great. Ms. Feliciano, let me do this. There you are. Okay, Ms. Feliciano, can you see me? I'm Judge McBurney. Good morning.
Yes, good morning, Judge. Thank you.
And share with me again, I was looking for you in court, so I got distracted. Your connection to Mr. Rhodes?
I'm Shawana Feliciano. I'm the mother of Cornelius Rhodes.
Okay.
My son was tragically shot and killed on July 27th. I'm asking, please take into consideration to deny bond for Jakar Meadows. Jakar Meadows shot and killed my son and left him for dead in the streets. She took his car. She's very aware of the car that I'm mentioning today. She didn't render aid. She didn't come forward to the police. She just left him in the street. My father was a businessman who tried to help her. He gave her a job and a place to stay. She knew him very well. She knew me very well. She knows his sisters very well. Just Cara was a very jealous female. I witnessed this myself. I was afraid for my son, and I mentioned this to him. And he told me that he would end the relationship once we returned back from Florida. He gave me his word, and I know that's just what he did. And because of that, that's why my son is deceased. This girl is an angry person. She has a temper problem. It doesn't matter that she don't have a past history. It doesn't mean that she doesn't have a problem. If this girl is released to the street, she's a threat. She has demonstrated her unwillingness to cooperate with the authorities. She's had ample time to come forward and make statements and to give us some closure. She's decided to go against that. I have had many sleepless nights. My son was the glue to our family. The holidays are here. He was so loved by so many people, so many. I'm on depression medication. I'm seeking therapy. And I don't even know how to move forward. But I know that he didn't deserve to be murdered and left in the street. He has 3 beautiful kids that ask for him every day. His smallest is only 2. He loved his dad. We won't get him back. We'll never get that opportunity again. So I'm begging, please do not give this girl an opportunity to hurt another family and to be on the streets. That's all I have. Thank you so much.
Thank you, Ms. Feliciano. I appreciate you sharing that. I appreciate your time. I'm sorry for your pain.
Thank you, Judge. Also present on the Zoom call and would like to be heard by the court is Mr. Rhodes' sister, Amber Rhodes.
All right, Ms. Rhodes needs to start the video. There she is. Give me 1 second. All right. Hey, Ms. Rhodes, you're on mute. Once you unmute, I'd like to hear from you. You're still muted.
Ms. Rhodes, can you hear us? All right, you're working on it. Okay.
So what we could do, Mr. Whitenauer, is give Ms. Rhodes a chance to sort out the muting. You said there was a third person, so we can come back to Ms. Rhodes, see if she's able to fix that while we hear from the other person.
Judge, that sounds great. The next person is Gia Sheffield.
Good morning, Judge McBurney. I'm here.
Hey, Ms. Sheffield, how are you doing this morning? Well, let me
Not
guess,
well.
not very well. Tell me your connection, please, to Mr. Rhodes.
I was the girlfriend of Mr. Rhodes for the last 3.5 years. Our relationship just ended May of this year. So I had no recognition of the young lady until all of this came about when I got the call to come to Grady. And so this is all just, it's very difficult. It's overwhelming. Give me a second.
Take your time.
Sheffield.
But Judge McBurney, as I stated, I've been a girlfriend of Cornelius Rhodes for the last 3.5 years. We were going to get married. We had so many plans, so many things that we were trying to do. We decided to separate because there were some unreconcilable differences that we needed to work out. So we decided we were up under one household, and we were living together in Decatur, where she, I guess, was living with him as well. And I decided to move on to my own place. And we were still trying to get everything together. We were still being a family, doing family things and trying to work on it. That we decided in May to just separate and see, other people. And that's how I guess Jakara came into the picture. Well, with regards to the case of Jakara and the killing of Mr. Rhodes, I believe she should not be granted bond at this time. Judge McBurney, at first I was sympathizing because I feel for her. She's young, she's 19, she has a child, and some of the things that she was stating, I was relating to. But then Jakara did not take accountability. She has not came up for at all. She could have at least went to the police when this happened. She could have done anything. She ran. I was the one who found his vehicle, the Jeep Compass, the red one that she claims she does not know anything about. I found that vehicle parked in a park in Atlanta, Georgia. It was abandoned by her. I had forensics to pull up to do all the evidence. Judge, I believe she should not be granted bond. She had the opportunity to handle the situation completely different, to save not only his life, but her own in this predicament. You can't trust a person who has proven to be violent when angered, who has lacked better judgment, and who's not able to make responsible decisions. She's an adult now. Coming from someone who has had to make decisions upon dealing with Mr. Rhodes, I know for a fact that this could have went differently. But she took it upon herself to play God in a situation. And I don't feel that that was right. She has shown no remorse for her actions. And it's an insult to everyone who loves him. Give me a second.
You take your time, Ms. Sheffield. Can I ask you a question?
Yes.
So you said you found the Jeep in a park?
I found it in Mosley Park 2 days after he died when we were looking for it, because he named her as his shooter, and he also named that she was in his car. So we were looking for his vehicle. I found his car. It was abandoned in the park.
And did you let the police know that you found it?
And they came to the scene immediately and they did the forensics on it.
Okay, so they're aware. This isn't news to law enforcement now for the first time. You let them know, hey, here's the Jeep Compass, Mosley Park. I'm not going to touch it. You guys take it from there.
Correct.
Okay. Thank you.
He was found, Judge, with clothing and a towel with reddish brown stains under the floorboard.
Okay. All right, Ms. Sheffield, was there anything else you wanted to add? I wasn't cutting you off. I just had a question.
I just feel a person who lacks accountability, remorse, and lack of judgment skills should definitely be a valid concern of not only flight risk, of just a threat to the community, especially now since she knows that she's up against conviction. This person has been proven uncooperative and untrustworthy. Just as no one knew she would kill, we don't know what else she's capable of. In addition to the fact, we feel although we know she is legally eligible, there is no legal obligation to the court to grant this bond. Judge, since we've been together, I still have to care for his kids. We never stopped that. Like, he still cared for mine, I still cared for his, so we always done family stuff. And since his kids are, it has taken a toll on them. They're very depressed. They're acting out emotionally. His 2.5-year-old son, his 3-year, I'm sorry, he's 3 now. He just had a birthday. All he does is ask for his daddy when he's here. When is my daddy coming home? Is my daddy gonna come back from the hospital? Our last day with Cornelius was July 27th when we rushed to Grady. And his son and his kids had to see that image of their father, him in ICU, not coming back. And that's the only image we all remember right now. It's not okay. She has left a void on us all, and we just want a sense of security for this unfairness. And that is all.
All right. Thank you, Ms. Sheffield. And thank you for still being there for the kids.
Thanks.
All right. Ms. Rhodes, any success in unmuting?
Yes, can you hear me?
Yes, ma'am. Let me get you. Whoops. That wasn't what I meant to do. Let's see here. There you are. Yes, ma'am. So you are Mr. Rhodes' sister, or one of his sisters.
Yes, I'm his oldest.
All right. You may be on more than once. Do you have more than one device connected? Or maybe the speaker is on your.
Judge, if we continue to have some issues with connectivity, I do have her statement and I can read it to the court if you'd allow.
Okay.
You can hear me?
Yeah.
Okay. But yes, my name is Amber Rhodes. I am the oldest sister to Cornelius Rhodes. My brother was very proactive. He was a very proactive person. He was a big necessity to not only our family, but to our community. Sorry. We actually have 3 dozen people watching this court right now, just in hopes of the denial of bond for Jakara. Cornelius was a licensed agent, insurance agent. He sold insurance to Fortune 500 companies. He was a businessman. He was a leader. He was a role model. He was a father. He taught us. He led us. He inspired us. I'm sorry, y'all.
It's all right, Ms. Rhodes. This isn't easy.
His life was taken. It wasn't due to natural causes. His life was taken. My brother was taken. Jakara took his life from us. She took his life from us. And for that alone, she should be denied bond. But furthermore, I'm sorry. Let's see. Jakara did choose to take his life. She took his life in a coldest way. She took his life in a heartless manner. We all know that. I understand that that's my opinion. Probably can't say that. I'm sorry. I don't know how to do this, y'all.
There's not a right or a wrong. You should just, and I'm clearly understanding how you're feeling about bond, because that's really what we're working through now. It's not good people, bad people, but it's whether it's appropriate for Ms. Meadows to have a bond, and you're helping me understand your perspective and really your family's perspective on that.
This was not a premeditated incident. This was not, I'm sorry, this was not a self-defense incident is what I meant to say. This was very much so premeditated. She left him in the streets. She never came to turn her. She never said anything. She never gave any. She never reached out. There was nothing about this. This was cold. This was heartless. This was done heartless, period. She's already proven to be a flight risk. She did not come in. She didn't turn herself in. So who's to say that she won't? She's been determined to be. Sorry, y'all. I'm so bad at this. I can't. Basically, what I really want to say, what I really want to get to is she should not be denied. She should be denied bond because it's showing the city of Atlanta most important is to get away with murder. Fact that she has done this, she's still walking the streets. He said, we know she did this. We have the evidence, we have a dying declaration, and she is still walking around. There is giving hopes or false hopes, or is giving the wrong intention either way. On top of everything else I said, and I'm so sorry, y'all. I'm bad at this, and I'm really that's all I got. She should
All right.
not.
Thank you, Ms. Rhodes.
You're welcome.
Your Honor. I'm sorry.
Almost. Mr. Whitenauer, tell me what you know about, one, the status of the Jeep, and two, the circumstances of Ms. Meadows' arrest, because I'm going to ask Mr. Lang this same question about the arrest. He says he doesn't know anything about the Jeep because he's talked to lots of family members and to Ms. Meadows, and they say we don't know anything about the Jeep. But the arrest circumstances, incident is in July, warrant is in September, and arrest is not till the end of October. Was there a big fugitive search for Ms. Meadows, or was she found at her home? If you know.
Judge, I do have that information. It's a lengthy supplemental, so I don't have it at the top of my head. So I don't have an answer for that question now. I can look back through it and get you an answer. As for the car, it was located and a search warrant was obtained for it. It was registered to Mr. Rhodes, and evidence of an injury was found in it just from plain view when they first came to the car.
So it has been processed, but you don't, this is all very recent, you don't have results yet of, Ms. Meadows' fingerprints were on the inside of the car, or her DNA, or that towel you mentioned with dark red stains, that's Mr. Rhodes' blood. That's being processed, too soon to have that.
So I don't have any GBI results as to the blood. I can tell you that from the supplemental report, it's my understanding that at that time, it seems that Mr. Rhodes and Ms. Meadows, had been in this short-term relationship, perhaps about 5 months, and that while Mr. Rhodes had been living with another individual, Mr. Best did not want Ms. Meadows in that residence as well, and that when Mr. Rhodes had attempted to bring Ms. Meadows into the residence, he was asked to leave the residence. And so around the time of this murder, it's my understanding that Mr. Rhodes and Ms. Meadows may have been living in that Jeep Compass at the time. Clothing, both men's and women's clothing was found in the Jeep.
Got it. Okay. Thank you for that. Back to you, Mr. Lang.
Yes, Your Honor. First, to answer your question, I want to clarify something we've heard repeatedly. Ms. Meadows turned herself in this case. She spoke with officers repeatedly during the investigation of this case. That is why it took 4 months for there to be warrants. There were 2 detectives who repeatedly met with Ms. Meadows and her family and spoke with them about this incident. When a 3rd detective was assigned to the case, that detective took out warrants. Ms. Meadows.
So I'm sorry to interrupt, but so really as early as late July, because Mr. Rhodes said, hey, it's Ms. Meadows who did this. Law enforcement and Ms. Meadows were having conversation, and late July, early August. But the point is, well before late October, law enforcement knew who Ms. Meadows was, had met with Ms. Meadows. So this wasn't a situation of all points bulletin, find Ms. Meadows, and it took 3 months to
That is correct, Your Honor.
Okay.
And then even the police report we have, the ending of the police report does state that she peacefully surrendered herself to officers
on the 28th.
After learning that warrants had been taken out. Yes, she surrendered herself to those officers upon learning about the warrants. I've spoken to Ms. Meadows and her family. They have repeatedly been involved with the detectives in this case, giving them information, trying to seek out the correct, circumstances of this case.
Okay.
Your Honor, I did also, during ADA Whitnauer's argument, I did hear that apparently a member of Ms. Meadows' family would like to speak to the court on a character statement, if Your Honor would allow it.
I will. And I guess anything else you want to address that you heard?
The only other thing I would want to address with Your Honors, we heard repeatedly that Ms. Meadows is quick to anger, cannot control her impulses, and has been proven to be violent. However, she's 19 years old with no criminal history whatsoever. If someone's been proven to be violent, they've usually been proven to be violent by committing an act of violence and encountering law enforcement because of that.
Okay.
We've heard of no history whatsoever of her having actually been proven to be violent. We've heard no substantive testimony before the court today about violent acts.
All right. Who is it who wants to be heard?
This is Miss Sheffield again. When
Oh,
we
hold on.
started-
No, not Ms. Sheffield.
I'm sorry.
You're good, but we're hearing from, I heard it was one family member. It's not one family member.
You want to do one at a time, correct?
I do want to do one at a time, but I also want to know how many it's going to be. Okay, and since they're just oh, yeah, they can't.
I can get up. They want to say.
You mind?
No.
That'll be easier. Thanks.
So let's have, can I have the slide over for me? I just need to give you a count for the officers so
All right, so if you're going to be speaking, please take your mask off if you're all right with that, so court reporter can hear you clearly. Let me know who you are and your connection to Ms. Meadows.
My name is Jamarcus Hurd, and Jakar Meadows is my daughter, not my biological daughter. I had been with her mother about 11 or 12 years, and when we started doing what we did, she was a little bitty child. And I the one took her, me and her dad, her biological dad, we the one took her both times to deal with the officers about this situation. I know when you tell a story, everybody tell the story how they need to tell it for it to work out in their favor. You understand what I'm saying?
I do.
But I took her on 3 different occasions, me and her biological father, to communicate with the police about this situation that we really don't even know about. And that's all I want to say. I don't know nothing about her being violent. I helped raise her up from a puppy, you know, and
Don't know that she wants you to call her a puppy, but I understand.
Sorry, you know,
That's all
I'm
right.
just saying, you know.
I hear you, Mr. Hurd, and I appreciate you sharing that. And it is clearing some things up that
Yes, sir.
this is something where from not quite day 1, but maybe day 2, the police had access to Ms. Meadows. She was saying, I'm here, you need to talk to me. And you accompanied her, which is smart, but there was no evasion, hiding, anything like that.
No, sir.
Okay, all right.
Thank you, sir.
Might I respond on that point?
You can when we're done, because this is going a little bit out of order, but I'm going to hear from the 3 family members, and then Mr. Whitenauer, I'll give you a chance again, because usually you would have heard this before you had a chance to speak. Okay? Thank you, Mr. Hurd.
All right.
Who's next, Mr. Lang?
grandmother, Your Honor.
All right.
Good morning, Your Honor.
Give me 1 second. We had to get Joe quiet there. Okay. Yes, ma'am. You are
I am Dorothy Meadows,
Ms. Meadows. Good morning.
Carla's grandmother. I just wanted to come and talk a little bit about Jakara, not too long. I miss my granddaughter. I hadn't seen her in a while. And we have been looking for a minute. We didn't know, probably we knew she was with somebody. We didn't know the young man, the man that she was with. Your Honor, I'm not gonna say too much, but I know she had been abused. And we tried our best to get her away from that situation. But when you telling someone that young that they think they're in love with someone and they're not. But I know she was abused. She's in my life. I love her. And I just, you know, it just hurts me to see her in this situation. So I just wanted to, you know, come on here. She got a 3-year-old son that loves her very much.
Where's Loyal staying now?
He stayed with her, Jakara's mother.
Okay.
Her mother's in the courtroom
Got
too.
it. She just stood up.
Yes, ma'am.
All right.
Yes, sir, I'm sorry.
No, that's okay.
Yes,
All right.
but I just wanted to come on here and say a few things about Jakara.
All right. Thank you, Ms. Meadows.
Mhm.
And Ms. Meadows,
Yes, sir.
if your granddaughter got a bond that she could make, she would not be staying with you, she'd be staying with her mother? Is that
Well,
correct?
Yes, but if she needs to come and stay with me, she sure can come and stay with me. And I have a house in Southwest Atlanta. I stay between the Camp Creek area and the Green Park, Greenbrier area. She
Okay,
can come and stay with me and she'll have her own room.
okay,
Yes, sir.
thank you. All right, and last but not least,
Father.
okay,
How you doing, y'all?
I'm okay. And you are,
I'm Jakari Meadows, biological father.
right, your name?
DeWarn Meadows.
Mr. Meadows, okay.
Oh, Your Honor, my daughter should be given a bond. Like you said, it's her first time being charged with any crime.
Pretty serious crime to be charged with first time out.
Yes, sir. I understand that. But both sides of her family are from Georgia. We live here, we work here. Jakara, it's my daughter, you know. And as far as her being violent, Your Honor, that's not true. If she is decided, or if you decide to give her a bond, I mean, whether it's on an ankle monitor or not, she works, she can go to school or whatever the case may be, Your Honor. She just needs a chance for her life. And I understand the situation and the severity of this crime. I do.
Sure. Mr. Rhodes doesn't have a chance for his life now.
Yes, sir.
He's deceased.
Yes, sir. But on Jakara's half, Your Honor, I mean, if you can find it in yourself or the court to grant her a bond. I mean, she has a lot of family support here. And we love her and we just want her to come home and be able to have a chance to do the right thing, Your Honor.
Okay.
And as far as them saying, we kept in touch with multiple detectives. They say they had no warrant when this thing first jumped off. They switched detectives, then they came up with a warrant. And as soon as me, her mother, and herself found out about the warrant, the next day, she turned herself in, Your Honor. So she's not a flight risk.
Okay.
Yes, sir.
Thank you, sir, for being here. Appreciate it.
I love you, man.
Anything else you want to add? Because I do need to give Mr. Whitenauer a chance to respond to things he just heard.
Nothing from the defense, Your Honor. I do apologize for going out of order.
That we're rolling with it. Mr. Whitenauer.
Yes, Judge. I did want to respond to the contention that Ms. Meadows has been cooperative in this investigation. I did want the court to be aware that on July 31st, so that would have been just a few days after the murder, detectives did communicate with a Miss Miyoko, that's M-Y-O-K-O, Jackson, who advised that she could arrange for a meeting with Ms. Meadows. That meeting was to occur at a Burger King on North Avenue. Two detectives with the APD were present, Detective Barry and Detective Hansen. They observed on scene Ms. Meadows, and after speaking with her briefly, had her and the previously mentioned Ms. Jackson sit inside their car for privacy. They then attempted to interview Ms. Meadows. While they were doing that, Miss Meadows' father insisted on joining the conversation and interrupted Detectives Hansen and Detective Barry. Miss Meadows was advised that she was not in custody and that she was free to leave. At that time, she identified herself by name and provided a date of birth. She confirmed that she was in a relationship with the defendant, Mr. Rhodes. But at that point, Mr. Meadows, who we just heard from, interrupted the interview and demanded that Ms. Meadows speak with an attorney, and he physically removed her from the vehicle by pulling her arm. Because of that interruption from Ms. Meadows' father, the communication with Ms. Meadows was ended. So I don't think it's accurate to say that she or her family has been cooperative in trying to determine who shot Mr. Rhodes, but I don't think there's really much of a question of who shot Mr. Rhodes, given Mr. Rhodes' dying declaration and the fact that an initial search of his vehicle, the red Jeep Compass that was registered to him, in it were found men's and women's clothing, as well as documents with the defendant's name. So Judge, again, we'd ask that you deny this motion for bond because we do believe that at her young age and what I understand from speaking with next of kin, her proclivity to be quick to anger and unable to control her impulses, that she does pose a significant threat and danger to the community and the people in it. Thank you.
All right, thank you. Mr. Lang, anything you want to, as the movement, you need to have the last word. We just got a little bit out of tempo here. Anything more you want to add?
I believe the court has all the information I have to present.
Got it. Okay. So I want to note initially, and this doesn't have so much to do with bond, that I don't view it as someone being uncooperative when a suspect or a family member of the suspect says, hey, you ought to talk to a lawyer. So I'm not finding that to be in any way remarkable. That could be whether it was Mr. Meadows or Mr. Hurd insisting that Ms. Meadows consult with a criminal attorney when detectives want to talk about a homicide, to me is not particularly remarkable. And I thought where the story was going to go is that Ms. Jackson said, hey, I can set up this meeting, and Ms. Meadows was a no-show. But as far as I've heard, Ms. Meadows has not in any way made herself difficult to find, and did at least initially meet with law enforcement. Then upon the insistence, maybe not just the advice, but the insistence of a family member, the conversation with law enforcement ended, and there was the recommendation that Ms. Meadows consult with an attorney, which isn't anything that I ought to or that I would hold against a suspect, from shoplifting all the way up to murder. So we've got very serious charges. We have Mr. Rhodes, who is not someone that family can be with again. It's always tough when I hear family members of the accused saying, I miss X, the accused, because I know just as passionately members of the deceased miss the deceased. And there's no bond I can grant anyone that would return Mr. Rhodes to his family. That being said, I do believe that there is a set of conditions that I could impose that will keep Ms. Meadows far, far away from Mr. Rhodes's family, and allow her to move in the direction that she needs to move while these charges are pending. I will, as I understand it, Mr. Whitenauer, there's just one count. It's a count of murder. Is that correct? On the calendars, there's just one. I don't want to set a partial bond.
At this time, that is the only charge that she's being held on, one warrant for murder.
Okay. I am going to set a bond, Ms. Rhodes, of $100,000. That may be too high initially, but these are serious charges. If that's a bond that you and your family demonstrably cannot make, and the state has not indicted your case, then I will lower that bond, because then we're all waiting for the state to do what it needs to do. And then I will lower your bond significantly, because the state will not have met its obligation that's set by statute to formalize the charges. That bond can be set through the sheriff's 10% program, because I will want you to be subject to pretrial supervision level 3. You will need to wear an ankle monitor that will be paid for by the county. So it's a county funded ankle monitor. You will have a curfew initially of 24 hours, but if you can document the job with that restaurant that won't be at the airport anymore, but somewhere else. But if you can get to Mr. Lang, hey, I'll be working, I'm making the hours up, 7 a.m. to 4 p.m. I'll adjust the curfew so that you can leave your home to get to work, do your job, and then get back home. I don't want to keep you from providing for your household. If instead of work, it's school, then you can document, here's when I'm in school. We'll adjust the curfew so that you can attend classes. You will have no contact, direct or indirect, with any member of Mr. Rhodes's family Direct contact is you calling or writing or posting. Indirect would be to have any of your family members or friends contacting any member of Mr. Rhodes's family. If the Rhodes family produces to the state any text or phone log or anything like that that shows you or your family is trying to reach them, that's one of the quickest ways to have your bond revoked. And you'll be required to live at your mother's address. I'll need to get that, Mr. Lang. You just need to get it to Ms. Nelson because that will be the address that goes on the bond. Mr. Whitenauer, any other conditions you'd want to see beyond what I described?
Yes, Judge, we would ask that she also, and this would be through pretrial, but we'd ask that it be a condition that she consume no drugs or alcohol and be subject to random screens. And we'd also ask that she be prohibited from possessing any firearms.
Okay. The firearms provision I will include. Do you have any reason to be concerned about Ms. Meadows's drug consumption? She's not able to drink legally. But I don't know if you had a reason to be concerned about either of those, or for you, that's just a standard condition.
I think it's fair to say that's just a standard condition. I generally don't think drugs and alcohol contribute toward good decision-making.
Okay. Well, they both would be illegal for Ms. Meadows to have anyway. And so you'll need to continue to obey the laws, Ms. Meadows, but there cannot be any firearms in the household. So should you be able to post this bond and you reside with your mother, which is the address you'd have to stay in, at least initially, there'll need to be no firearms in that household. If for some reason you need to move, you need to clear that new address with pretrial services. So if you need to move, I think your grandmother said you could stay with her. You don't get to just make that choice. If for whatever reason it makes more sense for you to be with your grandmother than with your mother, pretrial services would need to sign off on that. Mr. Lang, any questions about anything I just described?
None from me, Your Honor. Just let me make sure my client understands all those conditions.
Okay.
Your Honor.
Yes, Ms. Jackson.
Since this is, you said this is going to be through the 10% program, a level 3?
Yes, ma'am. Did I say something that doesn't work?
No. The defendant is 19 years of age. When someone is normally 21 to 17 years old, we normally ask for an adult co-signer. So you can waive that if you choose to.
No, I don't want to waive that. Fortunately, I don't deal with a whole lot of cases where we've got accused who are this young, but we certainly should have an adult co-signer. So Mr. Lang is consulting with the family right now. Is mom going to be the adult co-signer?
I believe so, Your Honor. She's just giving me her name and phone number so I can provide it pretrial.
Great. All right. Thank you, Ms. Jackson, for flagging that. We'll get you the full name and phone number for Ms. Meadows's mother. That's also the residence where Ms. Meadows will be should she be able to post this bond.
Thank you, Your Honor.
All right. Great. Mr. Whitenauer, anything else? Oh,
no, Judge.
Okay. Thank you. All right, we're going to pause one moment before we do Mr. Sales, which is our last one. Is Tech Tennyson here? Excellent. You'll come on up.
While we're doing this, would it be appropriate for me to approach?
It would be appropriate.
The addresses?
Yes, please. And Ms. Jones, are you here? Felicia, Felicia Jones, she may be outside. Yeah, Ms. I just signed something for her, so if you could, she may be waiting outside. All right, raise your right hand. Do you swear or affirm that the contents of your affidavit, including all the attachments, are true and correct to the best of your belief and knowledge? Great. Thanks for your patience. I've already signed, so if you would sign and date, you're good to go. Did we find Miss Jones? No? Okay, I'll hold on to her stuff. You're welcome. We can't find Miss Jones. Oh, you can't? Well, these deputies, nothing. Yeah, we'll get our fugitive squad on it. There we go.
Thanks.
I don't know what that badge is for.
Mom's name is MYO. That's all I have to do.
Did you get everything you needed? Great. I'm going to take care of one more thing. Investigator Rambler, come on up. Oh, and then I'll sign these indictments. We're going to do Investigator Rambler first. I've never had an armed robbery like that, where they say, I have no money on me. Fine, cash app me $500 or I'll shoot you.
Yeah, it's modern.
It is modern. Kind of thing my kids would figure out. They wouldn't do. All right, and so you're just trying to figure out the phone that is mom's phone number, but it's the phone that this guy used to connect with this woman. How do you say that name? Jimmy Seha? Jamesia. Okay, that's what you're rolling with. Yeah, Jimmy Seha. Okay. Creative name. I guess when you find her, she'll tell you. Yeah. All right, so I have signed everything. Do you swear or affirm that the contents of your affidavit are true and correct to the best of your belief and knowledge? Great. The little page, oh, there's two? Oh my gosh.
So they don't.
Are they related? Okay.
Whatever court is.
Sign that one.
You do that and that.
I thought this is quick. There's just one. This one has Abate's name on it.
Yes.
So who knows what's going to happen?
PC is probably not good.
For the young lady? Oh. Wasn't a fugitive. I guess they didn't have the full story. No. So these two, this thing about Northside Tavern, these two are, okay. $30.
Started over shoes.
All right. All right. Could you see your time? One of the ones I signed yesterday was the last guy, well, not the last, one of the three remaining YSL fugitives. It was. Well, I'll tell you, Judge Glanville doesn't want any more. It's like, stop. We're full. It is. It's ginormous. And I don't know how you're gonna work through it logistically in terms of like hearings and whatnot. Here's another one. Then the $30.
Yeah.
We've had murders with shoes, not $30 with shoes. Yeah. Yeah. This seems more Abate's pace. Yeah. $30. And, yeah. Yeah. I thought it was going to hit his head and then ultimately die. We have those cases where it's just but then you hit your head and died. Like, no, but then he got up and called the police. What? That's all right. I get plenty interesting. All right. That's the last one. You sign right there. You're all set. All right, indictments. You too.
26 indictments.
26, we're all light today.
Hey, Rambler.
One more, no bills? No bills. You had flow today. So many aggravated assaults.
Yes.
Just like yesterday, couple murders. All right. It's trouble. Are they still going? They were supposed to let me know when they finish. Please do, because Judge May, the federal judge, is waiting around. She's gonna leave. She can't until she knows they're done. In fact, if you don't mind, I don't know if Mr. Wade is not in there. I need an email. I don't bring my phone out here. So if someone could send an email. Okay, just let me know. Okay. Thanks for your patience. Have a great week.
Yep.
All right, so you'll let me know.
Okay.
They're still going? Okay, all right.
That's all you needed to know?
Yeah. If they're not done, then I'm on call and ultimately Judge May is on call. That's all. And they told me they'd let me know. They're usually pretty good about that, but they get distracted.
Yes, sir.
All right, so just to manage everyone's expectations, we're gonna do Mr. Sales's bond hearing, and then I think we're doing the Perez plea. Do we have other pleas we're gonna do also?
Yes, Judge, I believe also we have Mr. Ford.
Mr. Ford, we were gonna do.
Your Honor, this is ADA Hiles. We also have Quintavious Jackson.
All right. Mr. Hiles is sporting a new look. Took me a minute to process that. All right. And is Mr. Jackson in person here or is he in custody? He's in custody. Okay. This is the same Quintavious Jackson, the extended family and all that.
Yes, Your Honor. And it was when Mr. Cladis left, we had to get him a new attorney, and we had already talked about running everything concurrently together and agreed that it would be the same negotiated sentence for these unindicted cases. And now that we got a new attorney, we're ready to resolve.
Great. That's the 10-3, something like that. Who's the new attorney?
Miss Nicole Jones.
Oh, all right. It's the Miss Jones who I tried to give the divorce paperwork to. She's like, no, that's not my case. All right. She's here. Good. So we'll do that as well. We just need to finish up our bond calendar and then we can do those other things. And we had an interpreter here. Do we need is he still here? He's maybe talking with the client. Good. No, they can stay where they are. They can talk. We'll do that one next after we do Mr. Sales. Please. he's still here? He's maybe talking with the client. He's still in there. All right, Ms. Rivers, you still with us?
Yes, I am.
Great. You ready?
Ready.
All right. This is our final bond hearing for the morning. It's State versus Michael Sales, 22 CP 213560. Mr. Sales, I'm Judge McBurney. How are you doing? Good. We're going to talk about bond. In your case, you're charged with murder and aggravated battery. Mr. Lang is going to tell me why you ought to have a bond and what that bond should look like. Then I'll hear from Mr. Abate or someone from the district attorney's office about their perspective, and I'll let you know what's going to happen with bond. I'll keep your case as long as it is unindicted. So if we need to have a follow-up discussion about bond or anything else, I'll handle that. If and when your case is indicted, it will likely be reassigned to another judge. It'll go to a list of 15 possible. I'm one of those, but chances are it'll go to a different judge. And then you will get a different public defender who will represent you until your case is resolved. Understood? Yes? Yes, sir. Great. Mr. Lang.
Yes, Your Honor. Your Honor, before you is Mr. Michael Sales. I'm going to again begin with just a brief summary of the facts in this case. As it pertains specifically to Mr. Sales, an individual, the victim in this case, Mr. Craig Gordon, was found deceased in his home by a friend of his by the name of William Degree. That friend identified to officers that he had received several calls from Mr. Gordon stating that he was in fear, or that he had been in a fight with his roommate, Mr. Sales. That is how police have identified Mr. Sales and why they believe he is the person who perpetrated this crime. In my exploration of the events and the details with Mr. Sales, we've already identified a couple of issues in this investigation as it pertains to going forwards. Primarily, Mr. Degree stated to officers that he received multiple phone calls from Mr. Gordon, yet then the next statement he made to police was he does not have a working phone. The officer,
Mr. Degree doesn't have a working phone?
Mr. Degree does not.
Okay.
The officer even identified in the police report that they were unsure how Mr. Gordon would have been able to make contact with Mr. Degree since Mr. Degree stated he has no phones. So the primary link between my client and this alleged crime is up in the air at this time. It's a question that we still have to figure out. I'll be working on getting things such as the phone records to try to corroborate these calls and whether or not they truly happened. As it goes to Ayala, Mr. Sales is 42 years old. He's born and raised here in Georgia. He was born and raised in the College Park area. He lives at the address on his booking report, the Davila Trace address in College Park, Georgia.
Is that address the address that was also occupied by Mr. Gordon or
not?
Okay.
That originally was Mr. Sales' mother's house. She has moved to Fayetteville and gave him the house. He now lives in that house. He has lived in that house since the day he was born. So all 42 years of his life have been spent at that address. He graduated from Riverwood High School in 1998, then studied 2 years at Virginia State University and 3 years at Clayton State. He has his associate's degree in information technology. He was one class away from his bachelor's degree, but had to leave school to help with some family matters and has not been able to return since. He currently works in 4 different capacities, some of them related to each other. He operates a nonprofit called the Broken Angels Foundation, which is a center for battered women and also helps take in foster and abused children, give them a safe place, things like to that effect. Through that, he also operates Broken Angel Ministries, which is a mentoring agency designed to help get underprivileged youth off the streets and not involved in gang activity, rather in the music industry. He helps operate a recording studio for that. He's still working on finalizing and getting that set up. The hope is that eventually the program will be able to take kids off the street, give them an outlet to express themselves through music, and form a record label where he would be able to take children off the streets and away from gang activity and allow them to express themselves. He also then operates his own clothing line called the Forever Rich Apparel, and the record label will be called Forever Rich Records once it is off the ground. Previous to all that, he worked for 18 years as a logistics specialist working in warehouses. He does not have any children. He has multiple professional certifications through his work in IT, working with Microsoft, Pro Tools, and Cisco, having certifications from each of them. Based on the information presented, I anticipate when we hear about the criminal history, we will hear a number of drug charges to bring that up to the court preemptively. There was a period in Mr. Sales' life where tragically his significant other lost their life, and that led him to a dark period in his life where those charges popped up. He is clean now. He has been able to find help for the troubles that were causing him to go down that road. And I believe from what we will hear, that is the majority of his history. Based on the information presented, based on the fact that the link between my client and this charge is tenuous at best, based on what the officers identified to be non-lining up statements from the witnesses on scene, I'm asking the court to set a total bond in this case not to exceed $40,000.
Let me understand one piece. I thought I heard you say Mr. Sales has lived at the College Park, wherever the family home is, for all 42 years of his life. But then Mr. Gordon was his roommate. Mr. Gordon was living in the family home, or Mr. Sales was not living in the family home for some time?
Statements made by some of the witnesses were that Mr. Sales was Mr. Gordon's roommate. Mr. Sales had to spend a little bit of time outside of his home. His home is where the recording studio is going to be. It was being renovated so that that could happen. There was also an issue when we had particularly bad weather where the power line was ripped off the home. So he did, for a very brief period of time, basically crash, as the saying is, at Mr. Gordon's home, but it was never a full-time permanent living relationship. There was a brief period of time where he was staying at that address.
Okay, so it's not both are true. Home has always been, and in the future, in theory, would be that family home. But there was a window when Mr. Sales could be found at Mr. Gordon's residence because Mr. Gordon let him stay there.
That is correct, Your Honor.
Okay.
Lastly, I do apologize, I forgot to add this. I do want to make clear to the court. I spoke to Mr. Sales about his relationship with Mr. Gordon. He said that he and Mr. Gordon were very dear friends. Mr. Gordon took care of him when he was in need, when he did not have somewhere to stay. Mr. Gordon gave him that. He has never wished any ill or harm on Mr. Gordon. He has only ever considered Mr. Gordon a dear friend. He is not sure what happened in this case. He is not sure why his name is being brought into it, but he wants answers just as much because this was a dear friend of his that was taken from him.
Okay. Are there any friends or family members of Mr. Sales who want to be heard?
Not that I'm aware of at this time, Your Honor. I did speak to his mother. She was unable to get off work in time to be here, from my understanding.
Okay.
And I don't believe there's anyone in the courtroom today on his side. But I did speak to his mother and am aware of his connections throughout the community and am trying to establish contact with them as well.
Got it. So if he were to get a bond that he could make, he would go back to this house where the recording studio is being built. That house is an empty house, or his mother would also live in that house?
His mother has moved to Fayetteville. She would no longer be living in that home. Let me double check with my client, though, Your Honor, as to whether the house is ready for him to return or if he would be going to Fayetteville.
Okay, yeah, he's waving his hand around.
Yes, the repairs have been made to that house since.
Okay, so that's where you would live?
Yes. Is anyone else going to live at that home? My brother. So he'll be living at that home with his brother.
Okay, got it. Thank you. Ms. Jackson, what do you have for criminal history for Mr. Sales?
The defendant has 14 cycles. The defendant's last arrest was September the 20th, 2021 in Fairburn, Georgia, for possession of cocaine. There was no disposition listed in the GCIC. The defendant does appear to have an open case pending in Fulton County for aggravated assault. That case number is 21 CP 203-149. The defendant does have misdemeanor sentences. It's one in 2020 out of Fayette County for a non-fingerprintable offense. It originally started out as a DUI, but they reduced it and they did not list a reduced charge. And there was another one in 2019 out of Fayette County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you. I'm just looking up the CP case.
It's a pistol whipping.
Okay, I just wanted, it's not Mr. Gordon. It's a different alleged victim.
Miss Blake, I think is her name.
Yeah, a Blake, yes. Okay, you're up.
Yes, Your Honor, I would respectfully request you deny defense counsel's motion for bond. I'd bring to the court's attention, the defendant does have an FTA out of Fayette County from October of 2014. I'd also bring to the court's attention that when the detectives in this case contacted the defendant, Mr. Sales, he agreed to meet with the detectives and was a no-show. And that was shortly after the incident, Your Honor. As it pertains to Mr. William Degree and his cell phone situation, what's clear to me from speaking with the detectives is that the victim in this case, Mr. Gordon, actually called Mr. Degree at work where he was. And when Mr. Gordon called Mr. Degree and asked him to come over because Mr. Sales would not leave his home and that he was acting irate and angry, Mr. Degree could not leave work. Therefore, he wasn't able to rush over there. What he did tell the police is that Mr. Gordon, when called, sounded like he was in a little bit of a panic because Mr. Sales would not leave his home that he had lived in for 30 years, Your Honor.
Is Mr. Gordon, was he significantly older than Mr. Sales? Were they peers?
So Mr. Gordon was 64 years old. It's my understanding that Mr. Gordon would rent it's kind of like an Airbnb type situation. He'd rent one of the rooms in his home, which is what he did with Mr. Sales. Mr. Sales failed to pay for the rent. They did have a friendship from being in the community, from my understanding, and he was allowing for him to stay there, but not rent free. When he refused to pay rent, that is when Mr. Gordon respectfully asked him to leave, and this incident occurred. He was seen at the home, leaving the home at 7:10 a.m. on a Ring camera of the neighbors on the day that Mr. Gordon was found, which was June 22nd, 2022. After Mr. Degree got off work, he immediately went over to where Mr. Gordon lived at 6420 Jones Road here in South Fulton. When he arrived, he found Mr. Gordon laying on his bed with a flat screen TV on top of him, beaten and bloodied and bruised and basically unresponsive. He was able to get the TV off of Mr. Gordon, and immediately him and his friend who he had brought over there took him to the nearest fire station, which was right down the street where he could get the most immediate aid. While doing that, Mr. Gordon was slightly responsive and was able to speak a little bit. And when Mr. Degree asked him, what happened, he said that the defendant, Mr. Sales, he said Michael struck him over and over again. At that point, he was taken to Atlanta Medical Center where he had hemorrhaging of his brain. He had bruising and swelling of his neck and all over his body. Once he arrived at Atlanta Medical Center, he was unresponsive completely. The family had hopes that he would recover. Unfortunately, the brain damage was too significant, and on July 15th of 2022, he passed. The detectives then.
So he was in ICU in the hospital the whole time?
Yes.
Never got out?
That's
from
correct.
June 22 until he passed?
That is correct, Your Honor. During that time, the detectives with the South Bolton Police Department began to look for Mr. Sales. Like I said, they were able to get in contact with him over the phone, but he ultimately did not show up for the scheduled meeting.
Their reason for looking for him is because of what Mr. Degree or firemen or someone heard Mr. Gordon say, because he was minimally interactive during that last bit of time before he lost consciousness?
That's correct. And the last person seen leaving from Mr.
The ring camera?
Yes, Your Honor.
Okay.
And so what they were able to.
Were there other room? I keep interrupting you, but you mentioned that Mr. Gordon would rent out a room or rooms. Were there other residents of the Gordon household?
No, Your Honor.
Okay. Mr. Sales and Mr. Gordon.
That's correct. And so during their investigation, they were actually able to also speak with Mr. Sales' brother, who he has told the court he would live with. What Mr. Sales' brother, I believe his name is Andre, relayed to the police is that Mr. Sales has an incredible or extreme anger management issue and acts violent because of that anger management issue, and that he had not seen him, but he had called his brother and his mother and basically threatened them, saying, "You guys think I'm crazy. You have no idea what I'm capable of doing," were the exact words that he relayed to the detective. From there, he was able to locate, I guess, different hotels that Mr. Sales had been living in subsequent to this incident. At each one of the hotels, after a day or two, he was kicked out due to his violent nature to the other hotel occupants, as well as the front desk staff at these motels. Ultimately, he was arrested. My understanding is by the Fugitive Task Force because it was turned over to them. There was nothing overly significant or substantial about the arrest. I will bring to the court's attention, obviously the defendant is in a wheelchair here today, and it's my understanding he's got ankle issues, but he's very, very mobile. He seemed to be very, very mobile on the ring camera where he's acting erratic as he leaves Mr. Gordon's home that he so graciously allowed him to stay. I'd also submit to the court, as Ms. Jackson has informed you, he does have an aggravated assault pending in which he was out on bond for at the time of this incident. He also had a Fayette County incident that involved the possession of cocaine that he was also out on bond for. So he is out on bond for 2 cases when he violently and brutally killed Mr. Gordon. Based upon all of that information, Your Honor, I respectfully request you deny defense counsel's motion for bond at this time. There are 2 family members, when Your Honor deems appropriate, who'd just like to make a quick statement.
Sure, in just a moment. Was there any evidence of burglary, meaning things taken from Mr. Gordon? Clearly, burglary could be, I broke in and committed an aggravated assault, but were there things taken from Mr. Gordon's home?
Not that I'm aware of from what the reports and through the brief conversations I've had with the detectives. What I do understand is that when Mr. Degree and his friend arrived at the home, the screen porch and the front door were wide open. So there wasn't any sort of forced entry, as if somebody who had access to the home had entered and left without shutting the door.
Okay, but you don't know if all the drawers in every room were open and the silverware had been taken or anything like that?
No, and there was, from my reading and speaking, there was no indication of that. It was just the main thing that was out of place was the television on top of
Sure.
the victim.
Okay, all right. Yes, I'm ready to hear from the family members.
Hi, everyone.
Hi.
Judge. My name is Kayla Gordon. I am his youngest child, the only girl of 2 older brothers. I'm here solely to speak on my dad's character of being a family man. And I'm trying not to cry.
It is all right. You lost your father.
Yeah. I don't think that the suspect should get bond because he is a complete danger to the community. He has history of physical assault, possession of cocaine, and sorry, what's your name? I forgot. Adam State, anger. I go to sleep every single night because this is my first time seeing the suspect, thinking who could do such a thing to leave my dad there completely beaten. It was so bad at the hospital, we weren't able even to recognize him by his face, that we had to look at his toes to realize this is my dad. It's the most traumatizing thing that I've ever had to deal with in my life. And if he's able to get bond and to even just see the light of day, knowing that he did this to my dad, who's 61, and he's complete age range difference, I just do not think it's fair. I don't think he should have bond just simply because he's a threat to the community. Him being in a wheelchair has no sympathy for me. We won't be able to find him, just like it took months just to find him and even ask him questions from the detective. I just don't think he should get bond. And that's my statement. Thank you.
Thank you, Ms. Gordon, for being here.
Good afternoon.
Do you mind taking your mask off?
Oh, yeah.
That's okay. That way I'll hear you better. Thank you.
Sorry about that. Go this way. Good afternoon, Your Honor. My name is Craig Gordon Jr. I'm the first son of Craig Gordon Sr. Craig Gordon Sr. is leaving behind his 3 adult successful children, the mother of his children, his brother, 2 nieces, and his mother, and also 2 children-in-laws. There are multiple reasons why Michael Sales should not be allowed bond. Some of the reasons are, my father was beaten to the point of unresponsiveness and left for dead at the scene of the crime. Sales is the only suspect for that vicious act. Another reason is that the crime was committed June 22nd, 2022, and Sales wasn't arrested until October 28th, 2022. Over 4 months had passed before the arrest. The main reason provided by the detectives being that since Sales didn't have a verifiable address, he could not be located, so the detectives suspected that Sales was on the run. Another reason Sales should not be allowed to receive bond is because he poses a significant threat to the public, having a criminal record of over a 10-year period with convictions ranging from assault, battery, domestic abuse, possession of cocaine, and more. And finally, Sales should not be allowed bond because there's a key witness who may be able to shed some light onto what happened that night. Sales knows this individual. He could potentially harm that person. God does not allow us, he does not want us to, he wants us to forgive, but he does not require that we forget. I'm asking that you deny bond. Please show the same amount of mercy that Sales showed to my father. Show that same amount of mercy to him.
Mr. Gordon, you don't need to share the name, but this witness you alluded to, how would that person be in a position to know something of interest to either side in this case?
The only witness I'm aware of is the William Dupree individual, and that was the name given to us by the detectives doing the investigation.
Okay, got it. All right. Thank you for being here. I appreciate you sharing your comments.
Yes, sir. Thank you for your time.
Mr. Abate, anything else?
No, Your Honor, I think he's just referring to Mr. Degree, who was on the phone as well as had hung out with both the victim and the defendant prior to this incident day.
Got it. All right. Mr. Lang, anything in summation on behalf of Mr. Sales?
Yes, Your Honor, just very briefly. I did speak to Mr. Sales about that open aggravated assault case we heard about. The details of that case appear to be it's largely a he said, she said case where Mr. Sales, according to what he's told me, was the victim of a robbery where his phone was taken. He was held at knife point. He acted in some form of defense. And then when officers arrived, he and the other individual were charged, is my understanding. As it goes to Mr. Sales being contacted by officers and missing that appointment. The reason that appointment is missed is the reason that Mr. Sales is in a wheelchair before you today. He was involved in an incident where he broke both of his ankles. When he was supposed to be meeting with those detectives, he was in Grady being treated for those injuries. So he was unable to respond to officers at that time. As far as everything else goes, Your Honor, there has not been any documentation of any point of my client interfering with a witness in any other case that he's been heard on. We heard 14 cycles, 1 FTA, which does not show a pattern of failure to appear or a pattern of flight risk to the court. His entire family and all of his connections are within this state. Based on that information and further investigation into this witness who's being spoken about, who from my understanding has a great deal more he could play in this case, I'm asking the court to set a bond.
Okay. Mr. Sales, at this point, I'm not comfortable setting a bond based on the limited information I have. I am concerned about the fact that you were on bond for an aggravated assault case. I appreciate it's described as he said, she said. It doesn't mean you weren't on bond for a felony offense that involves allegation of violence towards another. And then this situation came up. So I'm not confident that I'd be able to set conditions that would ensure you stay out of trouble, you don't hurt others, and that you show up. And I appreciate Mr. Lang's observation that 1 FTA from 8 years ago doesn't mean that you're a flight risk. That's not my concern so much as both your work and your residence situation seems not as stable as I'd want it to be if you are going to be out on bond for charges as serious as this. So I appreciate you sharing. The repairs are done at this house and you're going to stay there, maybe with your brother. I heard some different things about your brother as well. And it sounds like you are in some ways trying to do good with some of these opportunities you're creating for others through Broken Angels, but it's not showing me that type of verifiable employment where we would have a supervisor that we could check in with, et cetera. So at this juncture, I don't think bond is appropriate. Mr. Lang is going to continue to work on your behalf. He'll get more information about the case. He knows that if he learns more about Mr. Degree or something else such that I ought to hear about it, we would reconvene to talk about a change in circumstances in terms of the posture of the case. The other thing I can tell you is that if we get to that 90-day mark, in other words, 90 days after you've been in custody, if you have not been indicted, then I have to set a bond. You are entitled to a bond. It may not be the bond you're angling for, but I would have to set a bond legally, regardless of what I thought about bond. We're not there yet. The state is saying they're going to get your case indicted before the 90-day mark, but we don't have to rely on their word. If we get to day 91 and your case is not indicted, Mr. Lang is going to get you in front of me. It may be you appear virtually from the jail. You may insist to be here in person. That's fine. That just may mean it's day 94 before I can see you. But at that point, if you've not been indicted, then I am obligated by law to set a bond. Mr. Abate, anything else on behalf of the state?
No, Your Honor.
Mr. Lang, anything else on behalf of Mr. Sales?
Not at this time.
All right, thank you.
Judge, that completes my business. May I be excused?
You may. And Mr. Lang, thank you for your work. It was nice meeting you.
Yes, Your Honor. Your Honor, may I ask my approach?
You may.
Not in specific relation to any case.
Sure. And we will do the Perez matter next. If we do have Mr. Lares here. So let's get folks situated for that.
Actually, I didn't mean to issue that. These are difficult. As long as you get it.
Thank you, Your Honor.
Mr. Lang,
Have a good Thanksgiving. You too. Take at least one day off.
All right, everyone's in position. That was quick.
Oh. Yeah. Yeah. Okay. All right. Okay. All right. Thanks for asking.
Okay, so you'll stick with us as long as you can, and then you'll go. Okay, understood. I gotta get the trial calendar. Give me 1 second.
Okay. Swap out. Gotcha. We might make it. It's like go see plea in federal court.
Exactly.
Thank you. Well, hey, good morning.
La señora es intérprete también y trabaja conmigo. Ella te va a traducir, gracias. Ya, ya llenamos el papel. Ok, todo listo. Bien, bueno, estás en buenas manos.
Thank you so much for your help. Anytime. Good to see you. See you're happy. Yeah, the same to you.
Wow, what's this for you?
Yeah, you too.
She got court?
Yeah.
Who's down there? Who's down there?
22, let's see, 181, 650. Melita?
Melito.
Melito.
Somebody come here with water.
You're gonna see right now, what?
What are the charges?
It's a 1 count of sexual battery.
Okay,
I'll flip it for you.
that's all. That's all.
Oh, that's all you need? Okay, cool.
Hey, get them right quick. We gotta do it. You got one?
You ready for turkey?
Yeah. Yeah, definitely. That's what, Thursday, today's Wednesday.
Tuesday.
Okay.
All right, I need to send one email to a federal judge.
Judge May is here, you said, Judge?
She's not here, but she doesn't need to wait anymore. She can actually now go.
Gotcha. Was she filling in?
Well, it's complicated.
I'm gonna say it must have something to do with Donald Trump.
Senator Graham. So it's sort of her case and mine.
Right.
All right. I'll start by swearing. Let me call the case first. This is 181. Where's that? Thank you. There it is. Position 17 on our trial calendar. It's indictment 22 SC 181653. I'm going to swear in the interpreter first. Ma'am, do you swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor.
Great. This is State versus Melito Perez Vasquez. Mr. Bennett, you are here on behalf of your client?
Yes, sir.
And what's the best way? Just Perez Vasquez in terms of referring to your client?
Perez Vasquez would be fine, Judge. Thank you.
All right. And we've got Mr. Shapiro here for the state. The interpreter is going to translate everything that is said in English into Spanish. Even if you understand the English, please wait for the translation before you answer any questions. You are free to answer in English or Spanish, but the interpreter will then share for the record whatever your answer was in English. Does that make sense?
Yes. Yes.
Great. If at any time you need to have a private conversation with Mr. Bennett, please let me know.
Okay. Okay.
And if at any time you have trouble hearing or understanding what's going on, please let me know.
Okay.
In a moment, Mr. Shapiro is going to put you under oath. Once you're under oath, you have to answer all of his questions and mine truthfully and completely. Will you do that?
Yes.
If you have any questions of your own, you need to let me know that.
Okay. Okay.
Mr. Shapiro, when you're ready.
Thank you, Judge. Judge, for clarity of the record, I've been informed by defense counsel that Ms. Perez Vasquez identifies as female, prefers female pronouns. So when conducting the colloquy, the state will refer to Ms. Perez Vasquez using her preferred pronouns.
Please do.
All right, Ms. Perez Vasquez, would you please raise your right hand?
Excuse me.
Hold on one sec. Yes, Ms. Rivers.
Thank you.
What was the, excuse me?
He sounded muffled.
Oh, okay. The microphone wasn't as close to him as it could be. We should be better now.
Oh, thank you.
Sure.
Is this better, Ms. Rivers?
Much better.
Ms. Perez Vasquez, would you please raise your right hand? Do you swear or affirm that any statements or testimony you will give in this matter now before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can lower your hand. Ms. Perez Vasquez, would you please state your true and correct legal name for the record?
Melito Bartolomé Pérez Vázquez. Melito Bartolomé Pérez Vázquez.
Thank you. And are you at this time taking or under the influence of any medications, drugs, or alcohol?
Drogas o algún alcohol. Bajo medicamento de VIH positivo. Under medicine, HIV positive.
Okay. Does that medication in any way affect or impair your ability to understand these proceedings?
Ninguno. None.
How old are you, ma'am?
¿Cuántos años tiene, señor? 40. 40.
And how far did you go in school?
Primaria. Elementary.
Ms. Perez Vasquez, do you understand that in this indictment, you were charged with the offenses of enticing a child for indecent purposes and child molestation?
Animar a un niño para actividades indecentes y abuso a un menor de edad. Entiendo. I do understand.
Okay. Do you understand that you have the right to plead either guilty or not guilty to those charges?
I do understand.
And do you understand that if you were to plead guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove those charges against you at a jury trial?
I do understand.
Have you had enough time to speak with your attorney about all of the facts in the indictment against you?
Yes.
Do you need more time to discuss the case with your attorney?
No. No.
And are you satisfied with your attorney's services?
Yes.
And Mr. Bennett, for purposes of the plea, are we waiving a formal reading of the indictment?
Yes, we will waive.
And are we waiving any defects in the indictment?
Yes, sir, we waive.
All right, Ms. Perez Vasquez, has your attorney advised you of the minimum and maximum sentence for the charge to which you're pleading guilty today?
Recibir por una acusación como la que tiene usted. I do understand.
Is it your understanding that today you are entering what's called a negotiated guilty plea, which means that the state is going to recommend the following sentence to the court? The state's going to recommend a dismissal of count 1, enticing a child for indecent purposes. And for count 2, the state is going to recommend a reduction to felony sexual battery. And Judge, that's OCGA 16-6-22.1, it's subsection D. And that in exchange for your guilty plea, the state's going to recommend 5 years probation, that you complete the entire term of probation for community safety, that you be required to register as a sex offender and follow all of the special conditions.
And sexual defender.
Sex offender, yes.
And the next.
Follow all special
Y que
conditions.
siga todas las condiciones especiales que se le den.
That you undergo a psychosexual evaluation
Psicosexual.
and follow any recommended course of treatment.
Que le den de tratamiento.
That you complete a Fourth Amendment waiver.
Una renuncia a la cuarta enmienda.
And that you have no further
Que no
contact
tenga
with the
más
victim in this
contacto con la
case.
víctima en este caso.
Is that your understanding of the
¿Usted
negotiated
entiende
plea
la
you're accepting
negociación que
today?
se ha hecho? Sí. Yes.
Do you understand that the
Usted
court's not
entiende
required to
que
accept the
el
state's
juez no está
recommended
obligado
sentence?
a aceptar esto? Yes.
And do you understand that the
Pero
court has the
entiende
right
que
to
el juez
sentence
tiene
you
el
to the
derecho
maximum
a
possible
darle la
sentence for this
sentencia
charge?
máxima que se le puede dar a un cargo similar. Yes.
Which is what?
No, que es cuál.
Judge, for the reduced charge of felony
Sexual battery.
the range is 1 to 5 years
De 1 a
because the
5
age of the
años.
victim in this case.
O la edad de la víctima de
Felony
este
sexual
caso.
battery applies in the instance of any
Y
victim who is
el
under
abuso
16 years of
sexual
age.
Okay.
mayor aplica para una víctima de esta edad.
Ms. Perez Vasquez, are you currently on probation or parole?
¿Usted está ahorita bajo probatoria o parol? No. No.
Do you understand that while on probation, that you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or
Ya
federal?
sea estatal, federal. Sí. Yes.
And do you understand that
Pero
while on
entiende de que
probation,
cuando
you
esté
must
bajo
follow all the
probatoria,
special
usted tiene que
conditions
seguir todas
of your
las condiciones
probation,
especiales de la
including those I've just
probatoria,
listed for the court?
A las que le imponga el juez. Yes.
Do you understand that if
Pero
you fail
entiende
to
de que
follow
si
the
usted no
special
cumple
conditions
las
of your
condiciones
probation,
especiales de su
you may be
probatoria,
subject
usted
to a
puede estar
revocation
sujeto a una
of that
revocación de
probation
esa
and
probatoria
sentenced
y
to
de
serve the
una
remainder
sentencia
of
por
your
el
sentence.
tiempo que el restante de su sentencia. I do understand.
Do you understand that
Pero
because you're
entiende
pleading
que
guilty
por
to a
ser
felony,
tanto
you may
culpable
not
de delito
receive,
mayor, usted no puede
transport, or
recibir,
possess a firearm?
transportar y portar armas. I do understand.
Do you understand
Usted
that doing so
entiende
may
que
result
durante
in
este
new criminal
tiempo
charges for which you could face a
se lo
sentence
hace, usted
between 1
puede-
and 5 years?
The interpreter requests a repetition. The interpreter requests a repetition
Oh,
of
I'm
the last
sorry. Do you
statement.
understand that
Usted
doing
entiende
so
que si usted
could
lo
result
hace,
in
usted
new
puede
criminal
resultar
charges
en
for which you could
cargos
face a sentence
nuevos que usted puede
between
tener
1 and
sentencia
5
entre 1 a
years?
5 años de cárcel. I do understand.
And do you understand that
Pero
because you are
entiende que
pleading
porque
guilty to a
usted está aceptando
felony, you
culpabilidad
also
de un
may not
delito
use a
mayor,
firearm
usted
in the
no puede
commission of a
utilizar
crime in the future?
delito, puede portar utilizar un arma de fuego en cualquier delito en el futuro. I do understand.
Do you understand
Pero
that
entiende de que
because you are pleading
porque usted
guilty
está
to a
aceptando
crime against a
culpabilidad de un
minor
delito en
that
contra de
includes
niños,
conduct
eso
of a
incluye
sexual
conducta
nature
de
involving a
naturaleza
minor,
sexual en contra de un menor,
that you are
que
pleading
usted
to a
está
dangerous
aceptando
sexual
culpabilidad
offense as
de
defined by
delitos
state law, and that you will be required to
usted va a estar
register
requerido
as a
que se
sex
registre
offender.
como ofensor, depredador sexual. I do understand.
Ms. Perez Vasquez, do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
La defensa de alguna problema mental. I do understand.
And do you understand that by pleading
Entiende que al
guilty, you
aceptar
are giving up the
culpabilidad, usted
following
está
rights?
renunciando los
The right
siguientes
to a
derechos:
trial by
derecho
jury,
al juicio con jurado,
the right to
el
remain
derecho a
silent,
mantenerse en silencio,
the right to
el
confront
derecho de
witnesses against
confrontar
you,
los testigos que testifiquen contra suya,
the right to the
el
assistance
derecho
of
de
counsel,
la ayuda de un abogado,
the right to
el
the
derecho
presumption
de
of innocence,
presunción de inocencia
and the right
y
to
el
appeal if
derecho de
convicted of these
apelar si se le
charges at a
encontrase
trial.
culpable en un juicio.
Do you understand that you are
¿Entiende que
giving
está
up those rights by
renunciando a
entering
estos
a guilty
derechos
plea?
al aceptar culpabilidad hoy? Sí. Yes.
And is it your decision
Es
to
su
waive these
decisión de
rights, which
renunciar a
means
esos
not to
derechos,
use them,
no-
and to
no
enter a guilty
utilizarlos
plea
al
today?
aceptar culpabilidad hoy? I do understand.
Has anyone forced,
¿Quién ha
threatened, or
forzado,
promised you
amenazado,
anything
le
to
ha
get you to
prometido
enter
algo
this
para que
guilty
usted acepte
plea?
culpabilidad hoy? No.
And is it your
Y
decision
esa
to enter a
decisión
guilty
de
plea
aceptar
because you are in
culpabilidad
fact
porque,
guilty?
de hecho, usted es culpable. Yes.
All right, Ms. Perez Vasquez,
Perez
in
Vasquez,
indictment number
la acusación
22
22
SC
SC
181653,
653.
how do you plead to the
¿Cómo usted va a
reduced
contestar
charge
a ese
of
cargo
felony
reducido
sexual battery?
de agresión sexual, delito mayor? ¿Cómo usted contesta? Culpable. Guilty.
Is this guilty plea
Esta
freely and
culpabilidad
voluntarily
nace de
given
libre
with full knowledge of the
con
charges against you?
conocimiento completo de los cargos en contra suyo? Yes.
Do you understand that you have only a
Entiendo de
limited
que
right
solo
to
tiene un
appeal
tiempo
this guilty
limitado
plea
para
conviction?
apelar esto. Entiendo. I understand.
And do you understand
Pero
that if you
entiendo
wish
de
to
que si
challenge
usted
the
desea
voluntariness or
apelar
any other
que lo ha hecho de
constitutional
manera
aspect of this
voluntaria o
guilty plea,
algún
you
aspecto
must do so by
constitucional,
filing
tiene que
what's
hacerlo
called a
presente en
habeas
una
corpus
petición que se llama
petition.
habeas corpus. Entiendo. I do understand.
And do you understand that
Y
for a
entiendo de
felony
que para
offense
un
such as
delito
this
mayor
one,
como
you have only
este,
4
usted
years
solo tiene
from
4
today to
años de
file a
periodo
habeas
comenzando
corpus
de hoy para
petition?
hacer esta petición. Entiendo. I understand.
Thank you, ma'am.
Gracias, señor.
Judge, that concludes
Sí,
the
señoría,
plea
con eso,
colloquy. As to the factual basis for this
las bases de
case,
este caso,
on April 28th of
28
2018,
de abril de
officers
2018,
with the Hateville Police Department Special
policía de
Victims
Hateville
Unit
de la Unión a la unidad de
Special Victims Unit
la unidad de víctimas especiales
were dispatched to
que mandaron a
550 Lake
550
Drive
Lake Drive
regarding a sexual
con
assault.
una agresión acerca de una agresión sexual.
The officers made
Los
contact
oficiales
with
hicieron
the
contacto
minor
con el
victim,
menor,
whose name
que el
is
nombre
Manuel
es Manuel
Velazquez, Velazquez, who stated that he
Que dijo
was
que
approached by the
se le
defendant while walking
fue
home from
acercado
a
a la
park
casa por esta
located on
persona
Claire
que iba
Drive.
Claire Drive.
The defendant asked the victim to help carry some bags into her residence. The defendant also asked the victim how old he was, to which he replied that he was only 14.
Le di cuántos años tenía, él dijo que 14.
Once inside the residence, the defendant placed her hand inside of the victim's pants and began rubbing his penis.
Y le tocó el pene.
The victim left the residence and contacted his grandfather, who arrived at the location and confronted the
Le
defendant.
confrontó al acusado.
The victim's grandfather also completed a 6-pack photo lineup in which he identified the defendant as the person whom
Y lo
he
identificó
confronted.
como la persona que había confrontado.
On May 8th of 2018, a forensic interview was conducted at the Georgia Center for Child Advocacy.
De abogacía para los niños.
The victim again disclosed that he had been at a park in the area when the defendant asked him to help bring some things inside of her residence.
Cosas adentro de la residencia.
He again stated that the defendant asked him how old he was, to which he responded that he was 14.
Que tenía 14 años.
Once inside the residence, the victim asked to use the restroom.
Pidió utilizar el baño.
And after leaving the restroom, the defendant asked the victim to bring her a drink from the kitchen.
Y le trajeron una bebida en la cocina.
Once the victim handed the defendant the drink, the defendant grabbed the front of his pants. She then placed his hand inside of the victim's pants and began to rub his penis. The defendant told the victim not to tell anyone, and she then left the residence, at which time the victim contacted his grandfather. On May 17th of 2018, investigators interviewed the defendant, who, after waiving her right to counsel, admitted that she had encountered the victim and invited him into her residence after the victim had asked to use the restroom. The defendant also admitted that she was aware of the victim's age. However, she denied any sexual contact between herself and the victim. Investigators then obtained warrants for the defendant's arrest on charges of child molestation and enticing a child for indecent purposes. And Your Honor, I'll state for the record that the state has complied with its obligations under the Crime Victims Bill of Rights to speak with the victim in this matter and to consult with his family. They have expressed the desire to move on from this incident. The victim is now 18 and has recently graduated from high school. And so it is their hope that he can put this incident behind him and get back to living his normal life. Regarding the defendant's criminal history, Ms. Perez Vasquez has 6 cycles. She does have a prior conviction under the First Offender Act, and that was in 2009 in Clayton County. but no other felony convictions.
For what?
It is for the manufacture, sale, or distribution of a false identification document.
Okay. Did Mr. Velasquez know Ms. Perez Vasquez or completely stranger on stranger?
Completely stranger, was able to identify, or rather describe, the clothing that Ms. Perez Vasquez was wearing on the day of the incident, off because he had also been to the residence.
Or at the house?
Yes. Was able to identify the residents. Officers attempted to do a knock and talk with Ms. Vasquez. However, she was not there at the time. There was I believe, a white truck that was left in the driveway. And so using the tag of the vehicle, they were able to identify Ms. Perez Vasquez.
Okay. Got it. Ms. Jackson, do you have any additional criminal history information beyond what Mr. Shapiro shared?
I have that she has 9 cycles.
Okay.
The last arrest was May the 9th, 2022. That was in South Carolina for petty larceny. She did receive the first offender treatment in Clayton County for the manufacture, sale, and distribute false identification documents. And it was sealed March the 10th, 2011. And she has misdemeanor convictions. One in 2022 out of South Carolina for petty larceny. And one in 2016 out of Barrow County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you. I may have missed it, Mr. Shapiro, while I was looking over the indictment and taking notes. Did you ask Ms. Perez Vasquez as to whether she's a U.S. citizen?
No, Judge, I did not.
All right, I'll cover that. I just didn't want to reinvent too much of the wheel, but I'll go there when it's my turn. All right, Mr. Bennett, you are up.
Yes, sir. This is a relatively old case. It was indicted right before the statute of limitations expired, like by a month.
Yep. Which would explain why it's a probated sentence, because if it were indicted in 2018, I assume it would, just based on the allegations, have a different recommendation coming from the state.
It would, Judge, and we think that it's a very favorable recommendation. We appreciate, and Ms. Perez Vasquez appreciates the opportunity to serve her sentence on probation and take care of some of the issues that she may have and address those in a manner other than prison. So we think it's a fair resolution. We'd ask the court to accept the negotiated plea. On the immigration side of things, I know that we're going to have the colloquy with her directly. She is not a U.S. citizen. She was granted asylum by the Los Angeles Immigration Court in 2016. She's a national of Guatemala, and the particularized social group did involve her sexual orientation and her gender dysphoric status. So based on that, it's our legal opinion that this conviction, while an aggravated felony under the INA, which would generally result in removal from the United States, she, because of her asylee status, would not be subject to removal by the immigration authorities. It's sort of an odd legal limbo that she's in that's similar to that of like a Cuban resident in Miami. It's a very similar form of legal status, but she will not be able to get a green card, and she will not be able to naturalize as a U.S. citizen as a result of this conviction. And we've discussed that.
Got it. Thank you. Anything else?
No, sir, that's all.
All right.
Hello.
Hello?
Your Honor, if you can hear this, the Zoom has lost your audio.
Hang on, I'm sending an email.
Ms. Rivers, can you hear us now?
I can hear now. I was typing an email. Okay.
Okay, where did you get cut off?
You started to talk to the defendant, and that's when I lost sound.
Okay, I will restart in a little bit. I need to attach a couple other devices.
Will I be deported when the probation?
That is not what we expect.
Esperamos que no, que no
The judge
suceda.
is right.
Pero pues tiene la razón en decirle eso.
The rules can
Las
change.
reglas cambian.
So you have to be aware
Así que
that's
tiene que
possible.
saber que existe esa relación.
But like I told you,
Pero como yo le dije,
if you get
si usted tiene algún problema
we will
con
step in
migración, nosotros nos vamos a involucrar.
and explain to the
Y vamos a
judge
explicarle al juez de inmigración
what your situation
su
is.
situación.
Agents have different than the judges.
Los agentes nacionales de veces actúan diferentes de los jueces. De los agentes de inmigración, immigration, ¿no?
And the courts in
Los
California
jueces en California
are much more
son mucho
sympathetic.
más empatéticos o que aquí son más duros. They do have more.
Okay. Podium defendant, prosecutor, witness. That ought to do it. All right, Ms. Rivers, you can still hear us?
Yes, I can hear.
Great. Ms. Perez Vasquez, I have to repeat myself because it needs to be made part of the official record. It's my understanding that you are a citizen of Guatemala, not a citizen of the United States. Is that correct?
Yes.
You understand that the advice you receive from your lawyers is, I am sure, very good advice, that you will likely be able to remain in the United States after this conviction. You understand that they can't promise that you will stay in the United States.
I do understand.
Okay, and that I am not representing one way or the other whether you will be able to remain legally in the United States. You understand that? And you understand that INS could decide, after looking at your situation, to remove you from the United States.
I understand,
But they may not.
pero tampoco.
Given that uncertainty, are you comfortable moving forward with your guilty plea? And if you need a moment to talk with Mr. Bennett, with the interpreter here, it's fine for you to talk. I know it's a difficult thing to work through, but I need it to be clear on the record that you understand that there is a possibility that this guilty plea could result in your removal from the US.
I do understand.
Okay, and you still want to go forward?
Yes.
Okay. Other thing I need to cover with you. It's a requirement because of the crime you're pleading guilty to that you will have to register as a sex offender in Georgia.
Depredador sexual aquí en Georgia.
You understand that?
Yes.
That could affect where you can live. It could also affect where you can work. Do you understand that?
I do understand.
For example, if you wanted to be a school teacher, you couldn't be a school teacher because you're not going to be able to supervise children. Understand?
I do understand.
And your house cannot be too close to a park or a playground. Understand that?
Entiendo, pero mi casa está cerca de un parque.
I do
¿Qué puedo
understand. I do understand, but my house is close to a park. What am I going to do?
Well, close is relative. I think it's like and don't quote me on this, but it's like 1,000 feet. If you are 3 blocks from a park, it's fine. If you are next door to the park, that's an issue.
Eso va a ser un problema.
Está cerca.
It's close.
Okay, well, you and Mr. Bennett can talk about that. I just need to make sure you understand that part of registering is that it limits where you can work and where you can live. Do you understand that?
Yes.
Okay.
What am I going to do? Where am I going to live?
We'll talk about
Vamos a hablar acerca de
it.
eso.
And what the judge is
Y
saying
lo que el juez
is
está diciendo es
there's
que
limitations,
hay limitaciones,
but we can talk about
pero
them when
vamos a
we get
hablar
to that
acerca de eso
stage
cuando lleguemos a ese punto
and look exactly
y
what
ver
they're going to
exactamente
be.
cuáles van a ser.
Dígale a él que cuando yo fui arrestada, el oficial bueno, el otro juez me prohibió que no podía estar en lugares donde hay niños.
Please tell him that when I was arrested, the other judge told me that I couldn't be in places where children are.
Right. It's very
Right.
similar.
Same situation. And if, I don't know, but if your house is too close to the park, you don't have to move in one day. You will be given a chance to find a different place to go. They don't evict you.
No es que la desalojen inmediatamente.
Right. Okay?
¿Está bien?
Yo no entiendo para dónde me voy a ir.
I don't understand where am I going to go?
You don't have to go anywhere right away. You will meet with your probation officer, and that person will figure out, well, where is the park? How close is it? Is it an issue at all? And it may not be an issue.
Okay, I understand.
All right. Ms. Perez Vasquez, I find there is a factual basis for your plea.
Para su contestación,
In other words, that the state could prove the charge.
cargos en contra suya.
I also find that
What did you say?
I find, based on what Mr. Shapiro told me about your case, that the state could prove you guilty at trial. If Mr. Velasquez came in here and told the jury what he told the police, and the jury believed him and not you, the jury would be authorized to find you guilty. So I understand why you're entering a guilty plea. That's all I'm saying. Does that make sense?
Yes.
I also find that your plea is knowing, meaning you've understood what we talked about, and voluntary. No one is forcing you to enter this plea. You're not excited about it, but you've decided that entering a plea is far better than going to trial. Is that true?
Yes.
Okay. I'm sentencing you under what's called the Probation Options Management Act.
La ley de probatoria.
All that means is that while you're on probation, if you have a small problem on probation, you and probation work that out. But if it's a big problem, you get arrested again, that comes back to me.
I didn't understand that.
I'll talk a little
Yo voy a
more
hablar
with
un
you
poco,
about
le voy a explicar un poco después acerca de la probatoria.
I'll give you an example.
Voy a dar un ejemplo.
you are going to be required to meet with probation every so often, let's say once a month. If you miss one meeting, you and probation can figure out what the penalty should be for missing a meeting. If 6 months from now, you get arrested for something like this, you're going to have to deal with me. Does that make sense?
Lo que él me acaba de decir es que si el señor Velázquez, yo no sé ni cómo se llame, viene, si enfrentara un juicio y no viniera, entonces hay posibilidades de que me retiren los cargos, porque es que exactamente como él dice, no pasaron las
You're
cosas.
telling me if Mr. Velasquez or whatever his name is come here and he withdraw the cases, the charges, because it's not what he said it happened.
Well, okay. Okay, but
I never touched him.
Ms. Perez Vasquez, right now, we're not going back and forth like that. I didn't say what you did. And you went back in time a little bit. All I was trying to explain when I used that phrase factual basis is that if Mr. Velasquez came into court and swore to tell the truth and told the jury that would be sitting right there that you did those things, the jury could believe him. And if they believed him and not you, the jury would probably find you guilty. I'm not saying who did what. Okay. All right. Count 1 is being dismissed. Count 2 has been reduced to sexual battery. I will follow the joint recommendation and sentence you to 5 years probation. Special condition number 1, no contact with Mr. Velasquez or his family. Number 2, you will submit to a psychosexual evaluation and follow any treatment that's recommended. Number 3, you're agreeing to what we call a Fourth Amendment waiver, which means that the probation officer, if she wanted to make sure you haven't been doing something with your phone that you shouldn't be doing, she can search your phone, things like that. Were there other conditions?
Judge, the state's recommendation was that Ms. Perez Vasquez complete the entire term of probation for community safety, so just no behavioral incentive, anything like that, and just the registry requirement would be gone through.
Got it. Okay. You will be required to register. We talked about that. And it is my recommendation to probation that you remain on supervised probation for the entire 5 years. Mr. Bennett, did you have any conditions you thought should be in there beyond that, or did I add something that wasn't part of negotiations?
No, sir, that's all accurate.
Okay. Ms. Perez Vasquez, do you authorize me to sign the indictment for you indicating your guilty plea? We don't hand papers around right now.
Porque no hay papel ahorita. ¿Usted me autoriza que yo pueda firmar su aceptación de culpabilidad?
Well, let me start this way. Mr. Bennett, may I sign your name indicating you've represented Ms. Perez Vasquez in connection with this guilty plea?
Yes, sir.
And Mr. Shapiro, may I sign your name?
Yes.
All right. Ms. Perez Vasquez, can I sign your name as well?
It's just signing it. It's no different than me signing my name and.
I can print it out and you can sign it, but either way, I need your signature on the indictment saying guilty to that lower charge.
Dígale, no me da el beneficio de como nulo, ni culpable, ni inocente, porque es que yo siento que esto es una injusticia. Yo no puedo declararme culpable. Me están quitando todos mis derechos como persona, como ser humano.
Please tell him that if he cannot give me a NOLA situation, because I don't want to plead guilty or innocent, because they're taking that I'm innocent and they're taking all my rights as a human being.
So what we're gonna take a quick timeout. And I'm gonna have Mr. Bennett talk with you, Ms. Perez Vasquez, about what your options are. If you don't want to enter this plea and no one is forcing you to do that, then on Monday, right after Thanksgiving, we'll bring in jurors and they will decide what ought to happen. And they will be hearing not about sexual battery, but child molestation and enticement, which carry much more significant penalties. So you get to decide. No one's forcing you, and Mr. Bennett will represent you very well at trial, but I suspect he's told you about the risks of going to trial and the benefit of the certainty of a guilty plea where you're getting probation. But ultimately, the decision is not his, it's not mine, it's yours. So why don't the three of you talk? I'll have you step outside and then you can let me know what you want to do. That you want to go forward with the plea with 5 years probation, or you want to say, no, thank you. And then on Monday, we'll bring in 48 strangers and we'll pick a jury who will hear from Mr. Velasquez and his grandfather about the situation. Okay? All right, you guys talk, and Mr. Bennett, when you're ready to get back on the record, we'll do that.
Yes, sir.
Thanks.
No, sexual battery, yeah.
And it's right, it's the 16.622.1D delta. Should we do Mr. Jackson? You've been available all day. I want to try to get you out of here. Mr. Hiles, you good for that?
Yes, sir.
All right. So what we'll do is start with Mr. Jackson. We may pause it if Ms. Perez Vasquez pops back in, just so we can close that one off, or folks will know what we're doing next Monday. Can I have the case number for Mr. Jackson, please?
Yes, Your Honor. The new case number is 22 SC 185166.
Great, thank you.
You want the plea back there?
Up at the podium would be great. Mr. Jackson, come on up, please.
All those cases have 3 years, 10 is hard. We'll just start with time. Rest of the day. Okay.
So Ms. Jones, you're with GPDC. Your entry says limited purpose coverage attorney, but you are sufficiently unlimited that you're fine assisting Mr. Jackson with his plea.
Yes, I agreed to assist him with the plea, Your Honor, for today.
Great, thank you. All right, and Mr. Jackson and I have met each other before, so we're not strangers. Just as you've heard, there was some transition with representation. Where is your normal home base?
Douglas County.
Okay. With a conflict defender out there, or a public defender, or none of the above?
I am a conflict defender under their contract for ARPD. He came for prelim, so that's why we're in a limited capacity, but I do have an office in Douglas
Got
and the clerk's office, because I do work out in Fulton too. So my phone address is actually in the system too.
Okay, great. I'm glad you're here. All right, Mr. Jackson, you ready to go forward?
Yes, sir.
Okay. What I understand is that this new case, which is actually an accusation, is really a carryover from the plea you had earlier, and the state through Mr. Hiles had represented. When we get our arms around all these other things, we're going to package them into an accusation. You're going to waive indictment, and I've seen the waivers of indictment. And then the sentence that you got for that other case or cases will be the same sentence here. So this isn't going to extend any time. It's not going to shorten any time. It's a way to wrap up a bunch of what we call CP or unindicted cases that were rattling around, preventing you from moving forward. Is that your understanding?
Yes, sir.
Good. All right. Mr. Hiles is going to put you under oath in just a moment. Once you're under oath, then you need to answer his questions and mine truthfully and completely. If at any time you've got a question of your own, either let Ms. Jones know or let me know. Okay.
Yes, sir.
All right, Mr. Hiles.
In Your Honor, before we start, for the record, the cases that he is under sentence for that we had, when we took the plea back at the end of August, we had put on the record that these would run concurrently. Where that was our agreement. And those two cases are 18 SC 162228, as well as 20 SC 177222. And when we took that plea, you said you would consider, and you didn't make up your mind, but you said you would consider whether or not to package all of the cases together, including the ones he took a plea for, in sentence under first offender. So I will, I guess, read that portion and then allow you to make that decision if you wanted to bundle for, I guess, purposes of trial.
Okay.
And so, all right, Mr. Jackson, will you please raise your right hand? Do you swear or affirm that the testimony you shall give before this court shall be the whole truth, the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Quintavious Jackson.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
22, and I got my own GD.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you were charged with the following offenses in counts 1, 3, 5, 7, and 9? You were charged with theft by taking.
Yes.
Felony. Okay.
Yes.
And do you understand that in counts 2, 4, 6, 8, and 10, you were charged with violation of the Criminal Street Gang Prevention and Terrorism and Prevention Act? Do you understand?
Yes.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you reviewed all of your rights and the rights that you were waiving by entering this guilty plea with your attorney?
Yes.
Have you had enough time to speak with your attorney, Ms. Jones, about all the facts and circumstances known to you regarding the charges in this indictment or in this accusation, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Jones, do you waive formal reading of this accusation?
We do.
And Ms. Jones, do you waive any and all defects in this accusation, including any with respect to your client's name?
I do.
Okay. Mr. Jackson, are you have you been advised the minimum and maximum sentence for each charge that you are pleading to today?
Yes.
And Are you aware that each count of all 5 counts of theft by taking all carry with them a potential sentence range of 1 to 10 years?
Yes.
And are you aware that each sentence, each sentencing, I'm sorry, the sentence for each count of the violation of the Criminal Street Gang Terrorism and Prevention Act carry with it a sentence range of 5 to 20 years?
Yes.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 3 years in custody with the balance of 7 years being on probation, with the special conditions the same as your sentences in 18 SC 162-228 and 20 SC 177-222. Those sentencing is or those particular special conditions being that you have no contact with known gang members, and that you possess no weapons nor replicas thereof. And do you understand that that's the recommendation?
Yes.
And do you understand that the court does not have to accept this recommendation, and that the court may can sentence you to the maximum on each charge and can run these sentences consecutively or one after the other?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in federal court?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today? Do you understand?
Yes.
That being said, do you understand that this plea will not affect any sort of probated sentence in the 2 cases that we have agreed to run this concurrent with? Do you understand?
Yes.
Okay. Do you understand that if you were placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation of the balance of your sentence? Do you understand?
Yes.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Mr. Jackson, are you a United States citizen?
Yes.
Okay, Mr. Jackson, do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes.
For example, do you understand your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment? Do you understand?
Yes.
Mr. Jackson, do you understand that by pleading guilty to a felony, if you use, receive, or possess or transport a firearm, you could be guilty of a crime that carries with it a sentence range of 1 to 5 years? Do you understand?
Yes.
And do you understand that if you use a firearm during the commission of a crime, you could be guilty of a felony, which may carry a sentence from up to 15 years consecutive to any underlying felony for which that firearm is used? Do you understand?
Yes.
Mr. Jackson, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
And outside of the cases that we have already discussed that this will run concurrent to, have you ever pled guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
And again, outside of the cases that we just discussed, have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment? Do you understand?
Yes.
And do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? You're giving up the right to trial by jury. Do you understand?
Yes.
You understand you're giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that you are giving up the right to confront witnesses called to testify against you?
Yes.
Do you understand that you are giving up the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that you are giving up the right to the presumption of innocence?
Yes.
Do you understand that you are giving up the right to testify on your own behalf and present other evidence?
Yes.
Do you understand that you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that you are giving up the right to have the charges against you proved beyond a reasonable doubt?
Yes.
And you understand that you are giving up the right to appeal if convicted of these charges after a trial?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Sorry. Mr. Jackson, how do you plead to the accusation 22 SC 185166?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Okay. Your Honor, this accusation consists of 5 separate incidents between the dates of August 11th and August 26th of the year 2020. I am going to go through each of those incidents in sequential order.
Okay.
Your Honor, on August 11th, 2020, officers responded to address 146 East Andrews Drive, City of Atlanta, Fulton County. They responded to a theft report of a 2018 black Range Rover from Brandon, common spelling, Wycherly, Wycherly. Officers were quickly able to get a hold of the video surveillance from this particular gas station. And what officers saw was that a blue Chevy Camaro with Ohio license plate pulled up at this gas station, and an individual who was later identified from surveillance as being Mr. Jackson was seen at the getting into the running Range Rover, which had the key fob inside of it, and the car was stolen from the scene. The officers went back, investigators went back and determined that this particular blue Camaro was actually rented by Mr. Jackson's mother, Miss Lamira Jackson. That's Lamira, and then Jackson, common spelling. So that was the first incident. And on the second incident, it occurred on August 12th of 2020 at 1:25 p.m. Officers responded to the gas station at 3736 Roswell Road Northeast to a 2020 black Range Rover that had been stolen. The particular Range Rover that was stolen belonged to a Robert, common spelling Alpert, ALPER2. That car was left unlocked with the key fob in the door. The same blue Chevrolet Camaro, as mentioned from the previous incident, was seen on video surveillance. It was seen that as it pulled up to the video or to the car, an unidentifiable black male got out of the Camaro and into the Range Rover as it drove away. This was rented by Mr. Jackson's mother, same car. Later, the vehicle was recovered, and a close associate and fellow member of the criminal street gang 27 Unos named Desmond Lindsay, his fingerprints were recovered from the stolen vehicle. And then phone searches of call detail records later showed that both Mr. Lindsay and Mr. Jackson were in the area of both this incident and the previous incident mentioned at the time of the thefts of these cars. On on August 16th of 2020, City of Atlanta police officers responded to 2345 Peachtree Road at the Bank of America in Fulton County to a theft of another 2018 black Range Rover, which belonged to Old Lobby. That is OWLA, B as in boy, I, Kosoko, KOSOKO. This particular car was left running in the parking lot, and the car was stolen after the same blue Camaro pulled up to it, and an individual was seen getting out of the car, out of the rented blue Camaro and into the stolen Range Rover, the call detail records placed Mr. Jackson in the area of the theft at the time of the theft. The next incident occurred on August 18th, 2020 at 1 p.m. at 4413 Roswell Road, City of Atlanta, Fulton County. On that, officers responded to a vehicle theft of a 2014 black Range Rover that belonged to Monique Harrison, Monique Harrison, common spelling. When officers arrived, they were told by the victim that the car was stolen when the victim left it running and then ran inside to handle some personal matters. The video surveillance was a little bit funny. All you could see from the surveillance was that a car that was unidentifiable pulled up next to this particular Range Rover with an individual getting out and getting into the stolen car. However, Mr. Jackson's phone records placed him in the area, and he had it was the same mode and manner as the other cars that were stolen. The final theft occurred at the Sherwin-Williams at 4340 Roswell Road, Northeast, at 1:59 p.m. on August 25th of 2020, at which time a black Audi SUV bearing Florida tags pulled up next to a 2014 gray Range Rover with the doors unlocked and the push start keys inside of the car at the Sherwin-Williams. This car was owned by Stephen Sigmund, Stephen, Sigmund, Sigmund. Officers then ran the tags and saw that it was a rental car. And again, this particular car was rented by Lamira Jackson. The surveillance matched the same mode and method as Mr. Jackson's other thefts, and police were actually able to tie him to this case, not through phone records, but through pictures recovered in the phone of Mr. Jackson when a warrant was taken out and his phone searched. Your Honor, Mr. Jackson is a member of the criminal street gang 27 Unos, which is known for car thefts. And at this particular time, there was a large-scale investigation into thefts of Range Rovers throughout the city that 27 Unos was discovered to be a part of. This is the same mode and method that the gang would, the same mode and method that Mr. Jackson used was the primary method that the gang was using to steal these particular cars. The crimes were committed either with the help of fellow gang members, either Desmond Lindsay and Xavier Smith, Xavier Smith. Your Honor, that would be the basis of the state's case. And we would just ask that you accept the plea as negotiated.
All right. And this accusation, it looks like, was built off of 5 different complaints. I guess it would be one for each of the stolen Range Rovers.
Yes, Your Honor. They were originally individual APD case numbers assigned to it. It was very quick once the pattern came out that they were all related, but it was a little bit of time before each incident was connected to Mr. Jackson himself, at least all 5 of them.
And is there restitution, or that's not something you're working through?
We're not working through that. The cars were either recovered and returned, and then the balance, the insurance compensated the victims. So,
got it. Thank you. I don't need to get into criminal history. We covered that last time. Well, I guess I should just confirm. Ms. Jackson, any reason you see Mr. Jackson not being eligible for first offender from your look at his record?
No, Your Honor.
Okay, thank you. Ms. Jones.
Good afternoon, Your Honor. To clarify, just for the record, if there's an issue later on, I think ADA misspoke and said that he's giving up his right for an counsel, but Mr. Jackson had an attorney previously under the first time that he pled, and obviously he's represented by attorney today. So he's been well represented through the entire thing. We do ask that you go ahead and enter in for the first offender. I do understand that this is the second time that he will actually plea, or third time, because there's 2 other ones. Normally they're bundled together. And that dealt with mainly, my understanding possibly is because Mr. Jackson has been unrepresented given the shortage of attorneys on this. And so that it would, if he had a counsel, I do understand he had counsel, normally we'd bundle them all together just for the court's sake, and later on that they all be considered together for first offender so they can get the first offender treatment seal when he successfully finishes his probation. Your Honor, as it was stated beforehand, he is 22 years old. He has accepted responsibility for his actions. He is shown to be remorseful. We do ask that the plea is entered in, and had for Mr. Jackson not having counsel, I think all this would have been resolved earlier. And he has been incarcerated now for, I think he told me 24 months left, 26 months when I last spoke to him. We were supposed to have a preliminary hearing last week. We do appreciate this court giving us in the very next week. He spoke to me about it. We waived the preliminary hearing, did the accusation just so he can actually get this resolved immediately. So we do ask that this be entered in on his behalf, Your Honor.
Okay. And I'll clear up the record as well. There was a window when Mr. Jackson didn't have a lawyer, not because he was choosing to proceed pro se, but there was turnover within the conflict defender's office. And it was a while before we got Mr. Cladis, who was the lawyer who represented Mr. Jackson for the pleas in the 18 SC case and the 20 SC case. And then Mr. Cladis was leaving the conflict defender's office, wanted to see through the pleas in those two cases because he and his client felt that those were reasonable recommendations from the state. And there just wasn't time to get these 5 clearly related Range Rovers in the Buckhead area thefts cases accused. So they are all part of what would have been resolved had there been more consistent and persistent representation for Mr. Jackson. He's always qualified for appointed counsel, and he has intermittently had appointed counsel. And I very much appreciate Ms. Jones, you stepping in to say, look, I will shepherd this last little bit through. And it is our understanding that it's the last little bit, but we'll see.
And to add to that, Your Honor, my contract actually ends December 9th, and that's why Mr. Hiles and I were rushing this through.
Oh, no. What's happening on December 10th?
Only God knows.
Okay. Well, when she tells you, tell us. Okay. Anything you want to add, Mr. Jackson?
No, sir.
These rental cars that you were popping out of, the Camaro and the Audi, those are fancy rental cars. Had your mom actually rented them, or you and some of your guys rented them and you used your mom's name? So I'm talking about these Range Rovers that were taken. I know it was a little while ago, back in 2020, but there's surveillance footage of you popping out of a blue Camaro with Ohio plates. That was a car that had been rented in your mother's name. Same with the black Audi SUV with the Florida plate, rented in your mother's name. Did your mom actually go down to someplace and rent them? And then you were borrowing them, or did you or some of your friends rent them in your mother's name?
She rented them.
She rented them. Did she know you were borrowing them?
No, sir.
Okay. All right. Well, Mr. Jackson, I find there's a factual basis for your plea in this case as well, and that your plea is knowing and voluntary. You've understood all the things we've talked about. You've told me you don't have any questions or anything else you want to add. I'm sentencing you under the Probation Options Management Act, which means during the 7 years you're going to be on probation. If there's a small or technical problem, you and probation will work through that. But if you get arrested again for anything, that'll come back to me. I told you before, and I'll stick with it, that I will sentence you as a first offender. This would have been part of what we did back in September, so 2 months ago. We couldn't get those charges together before Mr. Cladis was heading out. So I will treat this as a first offender. This is the biggest and probably most generous first offender I've done in a while. And I share that not so you can say, hey, Judge McBurney's a great guy, but so that you know very clearly that if we are together again in 6 months, whenever you get out, you're going to be in for a little while longer. But when you get out, 6 months after you get out, if we're together again because you got arrested for something stupid because you were running around with the wrong guys, I will not hesitate to resentence you as a convicted felon and drop some big hammer down. Not a million years, but I'll revoke a bunch of time. And you'll say, dang, I just got out. I'm 23. But you'll go back and you'll lose your first offender status. But you and your family convinced me that you were running a little wild back in 18, 19, and 20. But 25, 6 months in jail, you figured out that's not where I want to spend the next 10 years either. So you'll spend a few more months in and you'll be out. But know that first offender carries with it that risk that if you have not broken free of 27 Unos or whatever group you want to call your friends who were mixed up in all this, Ricky Wolf and Xavier Smith and all those guys, if you're not done with them, it's just going to suck you back into this. And Ms. Jones isn't going to be able to get you out of it in a real simple way. She may be a ballerina by then anyway, because she doesn't know what she's doing come December 10th, but you'll get a lawyer. I think that's all I need to cover. I will sentence you on each of the 10 counts to a term of 10 years to serve 3 with a balance probated. They will all run concurrently with each other. And the sentence in this case, ending in 166, will run concurrently with that 18 SC case and that 20 SC case that Mr. Hiles mentioned. And I think the last thing I need to do is make sure it's all right with you, Mr. Jackson, if we electronically sign this accusation on your behalf. You all right with that?
Yes, sir.
Ms. Jones?
I'm all right, and Your Honor, just for the record,
You're not going to be a ballerina?
no, I'm not going to be
Okay.
a ballerina. I've noticed some problems. If you can make sure it says he gets credit for time served, some of the DOC has not been crediting correctly.
Yes, ma'am. In fact, it will say that he should get credit from October 16th of 2020. This is in one of his other sentences, October 16th, 2020 to the present. He's been in custody nonstop. And he got a bonus about a month, June to July in 2018. So we will include those same dates. Ms. Nelson was able to verify those in his other cases into the credit line in the disposition here.
Thank you.
Sure. Mr. Hiles, anything else?
No, Your Honor, that should close out all of his cases. I saw today that there was one other CP case that for some reason is outstanding. However, it was just not linked to that 20 SC indictment. So I've gone ahead and filed the paperwork with the court, just saying that with the clerk, just saying that based on his entering a guilty plea, we have dismissed that charge. And so this should resolve all of his matters with the county.
Okay, I appreciate your thoroughness. So does Ms. Nelson. If this has held Mr. Jackson up a little bit, it's the cost of doing the business you were doing. Hopefully you're done with that, but we'll be here for you if you're not. Thank you, Ms. Jones, for managing this one. Ms. Tucson, do you need any information from Mr. Jackson? He already went through this process in those other 2 cases.
I remember those, Judge, and I have his information in the system. So I'll pull this docket, upload it to that one, and then he'll just have to report to Fulton County when he is finished doing the time.
Sounds good. Okay. All right, Mr. Jackson.
All right, thank you.
Good luck.
Thank you.
Your Honor, that concludes my business. May I please be excused?
You may. Back to those skulls on the wall there.
Have a good day, Your Honor.
All right. Yes, ma'am. Thanks for being here.
Thank you. Have a good day.
All right. I need to give the support staff a break. Deputy Gordon is sort of sliding down the wall. He hasn't had lunch. I want to get closure if we can on Ms. Perez Vasquez's case, and then we're going to take a little break. I know we've got Mr. Ford to do, and we're going to do that after we take this break. In theory, Mr. Getter has shown up, and we'll deal with him after Mr. Ford. I don't know what else we've got. I'm sure there's some things. I've got a search warrant with Sergeant Bruce. I'll do that during my break. So I'll get you out of here. And then may have other stuff that's piled up. That's what happens on the eve of Thanksgiving. Ms. Rivers, you'll get a break in just a second as well. If you can get back on the record in Ms. Perez Vasquez's case.
Okay, I'm ready.
Great. So we're back on the record with Ms. Perez Vasquez. We paused. Ms. Perez Vasquez had expressed some frustration and concern about the fact that she felt Mr. Velasquez, the alleged victim in the case, had been untruthful. And I explained to her as best I could that Ms. Perez Vasquez could always ask a jury to try to resolve the dispute of the he said, she said, but that carries with it the risk of uncertainty
de la incertidumbre
and a potentially more severe sentence
más fuerte.
if the trial did not go well for Ms. Perez Vasquez. I also understand that she is frustrated and maybe frightened by the uncertainty
Incertitudes
as to her living arrangement
de eso, dónde ella va a vivir,
and the citizenship question.
la cuestión de la ciudadanía.
So this is not an easy situation.
Sí,
I respect that.
yo respeto eso.
I just need to know if we're going to finalize the plea today or if instead we'll all be together on Monday picking a jury. And I'm going to let actually Mr. Bennett confirm that he was able to have a conversation with Ms. Perez Vasquez, and then I'll ask Ms. Perez Vasquez what she wants to do.
¿Qué es lo que quiere hacer?
Yes, sir, we did
Sí, señoría.
have an additional opportunity to speak just a few minutes ago. And it's my understanding at this moment that Ms. Perez Vasquez does intend to complete the plea hearing process this afternoon.
Okay. Ms. Perez Vasquez, did you have enough time to speak with Mr. Bennett?
Señor Bennett,
Me declaro culpable.
I plead guilty.
Okay. Did you have enough time to speak with Mr. Bennett?
Señor Bennett,
Ya hemos hablado lo suficiente, yo pienso.
we have spoken enough.
Okay, all right. Really, the only thing left then is for you to tell me that it's okay for me to electronically sign the indictment.
Perdón?
Sí.
Yes.
Okay, then Ms. Tucson, what do you need to get from Ms. Perez Vasquez so she'll know when and where to report for probation? Ms. Tucson, you still there?
I am here.
Great. What do you need from Ms. Perez Vasquez?
If moving forward with the plea, I will have to send over the documentation to you, as far as all the SPS conditions.
Sure. No, we've moved forward. We're done. And so I just wanted to know what Ms. Perez Vasquez needed to know in terms of reporting instructions.
Okay, so since this is specialized, Ms. Perez will need to actually report tomorrow at 10 o'clock, but I will need beforehand the police report sent to me, maybe from the attorney or the DA, so I could get it over to the SPS officer so they know that they will be having another person to report to their unit tomorrow.
Okay, so 10 a.m. tomorrow. And is it the Memorial Drive address?
276 Memorial Drive. And if the attorney, I can give my number or vice versa, and I'll call and get the information well. And then we can go from there, and I will give my email because I will need that police report.
Sure. So Ms. Perez Vasquez, your address is in Hapeville?
It's Fulton.
So that's Fulton. So yeah, that's the right address. Okay. So why don't you give us your phone number and Mr. Bennett can call you just outside the courtroom and get all the information from you and get some information to you. So Ms. Perez Vasquez knows where to be tomorrow at 10 a.m.
Perfect. 404
Mm-hmm.
308
Mm-hmm.
7618.
7618. Got it. Thank you. I will give you a call in just a few seconds.
Now, before we wrap up, Ms. Perez Vasquez will need an interpreter. Will there be someone at DCS who will be able to assist her linguistically?
I will indicate that in the notes when I send it over. When I send over the indictment and everything like that, if that also can be emailed to me. But I will let them know that interpreter will be needed. But as long as there's documentation with the name, they'll have it over at least, she'll be included in that she was there to report.
Okay. Mr. Bennett, anything else you need? I guess you'll be talking to Ms. Tucson, so you can get that.
Yes.
Mr. Shapiro?
Nothing to say, Judge, and I'll get Ms. Tucson a copy of the police reports.
Okay, thanks.
Great. So the prosecutor will get you the police report. Anything else you need, you'll be able to reach out to him or to Mr. Bennett. Okay? Okay. Ms. Perez Vasquez, good luck with everything. Does she have a question or you have a?
When is my probation gonna be over? In what year?
So if this is 22, it should be 27.
Del 22.
Del el 2027 va a terminar.
Del día 23.
Perdón?
Año 27 del día 23.
Year 27 of the day 23rd?
I guess that a year from today. And so you would, I don't know if you get credit for the day.
No.
No, well, it won't start probably till tomorrow. So yeah, November 22nd, 23rd of 2027.
27 alrededor de esa fecha.
Okay. All right. Good luck.
Thank you, Your Honor.
Thank you, Mr. Bennett. We will take a break. Ms. Rivers, when would you like us to be back? How much time do you need?
Not much, Judge.
How about if we come back at 2:10? Is that enough time?
Oh, that's perfect. Thank you.
All right, we'll be back at 2:10. We will do Mr. Ford's plea. Ms. Wood, is he all set to go at 2:10?
Yes, Judge, we're ready.
Great. Thanks, Zeke, for hanging in there. I'll deal with Sergeant Bruce's warrant. Do you have something too? There's someone with a badge behind you, Sergeant Bruce. Your team? Okay. All right. Well, I'll go read that. I'll come back out here, swear you in, et cetera. Did you have something also?
No, Judge,
Oh, you're keeping him in line. Good luck with that.
Bye-bye, man.
All right.
Judge, may I be excused?
Thank you for this.
This gentleman has trying his permanent.
Okay.
Yeah, whenever he is.
We can get Ms. Niles out here and she can talk with him. So I'll go back with the warrant. I'll send Ms. Niles out. Great. Yeah. I'm glad that went through.
I earned my lunch.
You sure did. You earned your via in Italy. I'm glad you were leaving it. Mr. Lyles was nervous because he's got one of these things he has to do now that he's a full-time employee. And I did not want him to miss that. He was very stressed. Those were too complicated pleas. Can we have a simple plea?
Shut that man 13 times off. Man, crazy. He probably never heard no facts. He go back home with a real old man. They probably like, just all in jail. You know what I'm saying? I mean, that's what they're like.
Oh, Mr. Hand, how you doing over there?
It's weird. I've been there all morning. I haven't had a chance to see anything.
Oh, I thought you over there with the computer over there.
I'm working though.
Yeah, I think you're answering my emails.
Yeah, that was the first one. Also, but she didn't even come on that. She probably know herself. She didn't even come. Sister came on that. They were trying to calm everybody down. Wow. She won. Yeah, I'm supposed to say one with the chopper folks at right side. Wow, that's what it is. Them folks got up there and said, please let my brother out. He did it for self-defense. Them folks came right behind him.
Y'all on the clock? I'm on the clock or y'all? I mean, what?
You on the clock?
Yeah, we are.
Oh, yeah, that's right.
Oh, yeah, I'm good. I'm sure.
That car, still.
Oh, my God.
But you got it. Okay, let's see. Wait, what the hell? You got the crazy.
They got that phone back and it's raining.
How come you trying to- You get that money on the form, they say you got that right there. And then, so, yeah, you know what? Even though she said, oh, I keep finding them things. So how do So do you drive that work or you drive a car?
So my part, I gotta get 2 bills.
Okay, right.
You know, dog,
Yeah.
He said I'm going with me. I'm trying to do it though.
That's all you say. How long would the engine phone work then? Okay. That one thing, okay,
But-
think about.
But that's because of the thing. I was.
So how much is right there? I want to stick over there. Okay. Yeah, crazy. 2 and 3. So why they want to? Okay, got that other car.
But I'm just doing this shit for Saturday.
So what else you think on when you get in there for 2 and 3?
It's gonna be on the show.
That's gonna be on the side. Yeah, that's free.
Hey, sir. Hey, how are you? Good. I'm done. Stop it.
Yes.
See,
I was told after I had to be the judge of McBurney and his chambers. They said.
All right, you got paperwork you need?
Yes.
You can get to this.
Well, I need him to sign off on something.
Yeah, we go there, see the paperwork there.
Okay. It's a lot, so I gotta talk to him, so I don't wait as long as possible. I just called up.
what is
Let's still do it.
No.
Oh, that was that too.
And so who's okay. Yes. Okay. Well, the Constitution.
That's how they get the money. I haven't got to know my mother, right? I say, so I got 13 paid on, and I have another 10.
Okay.
Cause I got another.
And so who made this?
10, with 7.
Who would know it?
When I see the people.
Oh, one of the officers, okay. And they give you this as an example of how you would get yourself done?
So now she's going down there.
Okay. You have your case on? Do you have a number?
Yeah. That's what she said. I see it on the website.
You watch the videos?
Oh, it's a video.
You gotta watch the commission.
Oh, before the mission. Okay.
What kind of officer?
I don't know.
Yeah.
That's and what's your grade?
No, guys.
I'm gonna talk to them. I'm gonna see more, to see if you can, figure out a direction, figure out what's still. Yeah, you need to talk to. I'll come speak with you in a. Yes. Yes. And that's why I was not.
Yeah, like early, this one. I had to come down and he started at 8:30.
Is it part of that? Yeah. Well, I've been just for brand.
I ain't doing shit.
No, after 18, they got 5 cents. I really want to help it, but I don't want to get but I do so. Why you say that? But I can drive her. I just gonna be something I really. I'm gonna treat it like a home. If I can't get a food, I'm gonna have to. I can't get a health care too. I'm gonna get a. I'll probably get a. But it won't be something else. I said, I'm somewhere. I'm gonna fight.
What was the sergeant?
And every time I want to change like that, I always like to
Some. All right.
Bring me some.
What do you want?
I'm just playing. So scared that you heard me? Oh, whisper. She loves you. Thank you. Anything investigation, jail, that's what I'm talking about. You know, get fired.
All right, Sergeant Bruce. I think I understand all this. You got a phone, you want to search the phone. Okay. And it was, in theory, Ms. Hill's phone.
Yes, Your Honor.
She's just trying to figure out like who's sending the money, all that kind of stuff. Okay, great. All right. Do you swear or affirm the contents of your affidavit are true and correct to the best of your belief and knowledge?
I do.
Do you guys have like fancy equipment to extract the phone, or you have to give that to someone else?
Someone that APD will do it for us. We don't have equipment in our setting.
All right, you don't need a no knock. So you'll sign on that page that's sticking out, and then you've got everything you need. Sorry to keep you waiting. You bet. Did Ms. Niles talk to you, sir, about your situation? I'll talk to you. Did she give you a piece of paper back? All right, so here's your deal. You have an open criminal case here with the Fulton DA's office, and that number she wrote on the piece of paper, it's 2022, or this would be like 22 CP and then some other numbers. You already had that? All right, so because your case is still open, I can't order anything returned. You should either talk to the lawyer who helped you get your bond. You should have had a public defender, or you may be that you've hired your own attorney. If you want to fight this on your own, that's fine. Take care, guys. Again, sorry for the wait. Or you can work through the DA's office, but as long as the case is open, then judges aren't going to say, hey, here you can have your property back, unless the prosecutor says, oh, we don't need that property. I'm making it up. Let's say they took your car keys and that's all you're trying to, I just want my car keys back. You should be able to get that back. But that's a conversation between your lawyer or you and the prosecutor. Mr. Hand is a prosecutor. He's not the one who'll be managing your case, but he could at least let you know who you would reach out to. If there's an impasse, you or your lawyer's talking with the DA's office and people can't agree to it, then your lawyer or you could file a motion saying, this is ridiculous. Why does the state need the car keys? It's a case about marijuana. So maybe they keep the backpack the marijuana was in. If there was a gun in the bag, they're gonna keep the gun. There were scales, they'll keep the scales. They're gonna hold on to the cash, at least initially, until it all gets litigated. But if it's car keys or something like that, you ought to be able to get that back. Unless that's somehow the way the state would prove that it was your car because you had the keys in your pocket and the marijuana was in the trunk. So that's where you're at. It's a conversation that you. Well, you got arrested and you went to jail and you got a bond. Did you do that all by yourself or did a lawyer help you get the bond? There was no lawyer sitting with you when you got the bond? Okay. Do you think you are going to end up hiring your own or would you qualify for a public defender?
Well, I was told that just to don't worry about it for right now because they said this case is very small, so like they might close it anyway, so I wouldn't have to worry about that.
You're right. No, I'm not saying you got to go hire one right now, but let's just pretend for a minute they weigh the stuff or the way it was packaged. They say we're going to move forward with it because what you were arrested for is possession with intent to distribute marijuana. So it was either the weight or the way it was packaged or whatever the officer saw at the time saying, hey, this guy's selling it. It's not just personal use. That's a felony. Been arrested for a felony. If the state decides they want to go forward with it as a felony, then you'll get indicted or accused and you'll need to come to court. And that's when a public defender will either represent you or you'll say, no, I can hire my own attorney. Assuming it goes forward, what do you think you'll do? Okay. Well, then you can either contact the DA's office saying, how do I get my stuff back? And you give them that CP number, they'll be able to look up the case and say, it's fine, here are your car keys, whatever the deal is. If they push back on.
The only thing I really want back is my cash because she really violated me and still let me get somebody back my phone. I understand the phone, they can keep the phone, I already know about the phone and all that.
Okay.
I just want my cash back.
How much cash was it? All right. Good luck getting that back. I mean, it's there. It's not gone. It's not that it's gone. That's not what I'm saying. But if the prosecution's angle is you were selling, then, hey, those are your proceeds. I'm not saying that's what they were. You could have earned them because you wrote a book and sold 1,000 copies of the book. But that'll be viewed as evidence unless and until the state says this case isn't going forward.
So when I got locked up and the officer didn't write the report, I nothing saying about I'm just took everything in and gave nothing on our name.
Like no receipt or anything like that. Huh. Well, that's not good. So you may want to reach out to the public defender's office. You may want to talk to legal aid or someone because you may have a totally separate claim about, wait a minute, like basically they stole my stuff.
No, that's all we did. They stole my stuff. They don't even know what I got.
Right. Well, I don't have the police report. I don't know what was documented, but my ability to sign an order would be driven by you either working with the prosecutor saying you can have it back. We the prosecutor don't need it. Then the order actually goes to whether it was Atlanta Police or College Park. I don't know what the agency was that arrested you. Okay, so there'd be an order saying Georgia State Police, you need to return to you the following things, but I don't just sign that out of the blue. The state would have to say, we don't need that stuff for the case. Okay?
I can at least let you know who the prosecutor is on your case, but that's it probably. Yep.
You're welcome.
How you doing, Judge?
I'm well, sir. Yourself?
Yes, sir. Okay. Okay, good deal. All right.
All right, let us press on here. I think we said we're going to do Mr. Ford next. Is that right, Ms. Wood?
Yes, Judge, he should still be on the Zoom. There he is.
All right, let us put you there and add Mr. Ford. Mr. Hand, this is your case?
Yes, Judge, it is.
All right, Ms. Rivers, you ready?
Yes, Judge, I'm ready.
Great, let's do this. This is way down our trial calendar.
I believe it's number 20, Judge.
Number 20, 22 SC 181904, Zolly Reuben Ford. Mr. Ford, before I have Mr. Hand put you under oath, I need to make sure you're okay proceeding virtually. You have the right to be here in court, but you can waive that right and appear remotely. Are you waiving your right to be here in open court?
Yes, sir.
Okay. You also have the right to have Ms. Wood by your side for these proceedings, but you can waive that right. We'll still make sure the two of you can speak in private if you need to. You can always drop off the call and get on cell phones and talk. But are you waiving your right to have Ms. Wood by your side during this plea?
Yes, sir.
All right. With that, then we can get underway. Mr. Hand will put you under oath. Once you're under oath, please answer his questions and mine truthfully and completely. And if you've got any questions of your own at any point, let me know. Will you do that?
Sure.
Good. Mr. Hand?
Yes, Judge. Mr. Ford, if you could for me, please raise your right hand so I can see it in the camera. Perfect. Do you swear or affirm that the statements or testimony that you shall give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand for me. Thank you. Judge, just to let the court know at the outset that the state is reducing count 1 from aggravated assault to simple assault under OCGA 16-520. For aggravated battery, the reduction will be to just battery under 16-523.1.
Okay, and then the simple battery is staying a simple battery?
No, Judge, the state is no processing the simple battery, the second.
All right, so.
Third count, Judge.
Got it. Count 1 will be simple assault. Count 2 will be battery. Count 3, null prost.
Yes, Judge.
All right.
All right. And the state will also advise that both victims in this case have been given the Zoom link and are viewing that way, Judge.
Okay.
Mr. Ford, can you please state your full, true, and correct name for the court?
Zolly Reuben Ford IV.
And are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Have you not taken any medicine that you would normally take or been given today?
No.
How old are you, Mr. Ford?
46.
And how far have you gone in school?
I have my bachelor's in social work, and I'm currently at pursuing my MSW at Georgia State University.
Can you say you're pursuing what at Georgia State?
My master's in social work at Georgia State University.
Got it.
Okay. And is it correct that you can read, write, and understand the English language?
Yes.
Okay. Do you understand that you have been charged with the following offenses in today's case, to which you will be pleading guilty? Simple assault for count 1. Count 2 will be battery, and then count 3 will be no pros. Is that your understanding?
No, my understanding was that the third count would be dropped. I don't understand what no process.
I'm sorry. Let me.
Means the same thing.
Oh, okay. Yes.
It's just legalese for not prosecuted or dismissed or dropped.
Got it. Okay.
Do you understand that you have the right to plead guilty or not guilty to the charges today?
Yes.
And do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that the state will be required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review all of your rights with your attorney today?
Yes.
Have you had enough time to speak with your lawyer about today's charges, including any facts and circumstances surrounding those charges?
Extensively.
Is that yes or no?
Yes.
Okay. Would you like more time to speak with your lawyer about your case?
No.
Are you satisfied with your lawyer's services?
Yes.
Okay. Attorney Wood, would you waive formal reading of today's indictment for purposes of today's plea?
So waived.
And do you waive any and all defects of the indictment for purposes of today's plea as well?
So waived.
And Judge Estate is unaware of any outstanding warrants related to these charges.
Okay.
Mr. Ford, do you understand that the minimum and maximum sentence for each charge are as follows? For count 1, 1 day to 12 months imprisonment. For count 2, 1 day to 12 months imprisonment.
Yes.
And do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, that is overall 24 months probation. That is 12 months consecutive of probation for each misdemeanor in count 1 and count 2. 300 hours community service, an anger management course, and a no contact and stay away provision for Olivincia Washington. That first name is spelled Olivincea. Washington, traditional spelling. And Alexander is the second victim. His name is Torres Medina. So it's 2 hyphenated names, Torres, Torres hyphen Medina. Do you understand that to be the negotiated plea you're entering guilty to today, Mr. Ford?
Yes.
And do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge today?
Yes.
Do you understand that if there are multiple charges to which you're pleading guilty to today, the court also has the right to run those consecutively, which means one after the other?
Yes.
And do you understand that if the court decides to enter a sentence that differs from the negotiated plea that you're expecting today, that you have a right to withdraw your plea of guilty?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, which is the recommendation, you cannot violate any criminal laws of any governmental unit, that being municipal, county, state, or federal laws?
Yes.
Do you understand that if you are placed on probation, you must follow all special conditions of probation?
Yes.
Do you understand that if you fail to follow all special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? Those are a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to assistance of counsel, the right to the presumption of innocence, as well as the right to appeal if convicted of these charges at a jury trial.
Yes.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to enter into a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of simple assault, count 1, count 2, battery in indictment 22 SC 181904?
Guilty.
Is this plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file this habeas corpus petition?
Yes.
Okay. Judge, at this time, the state will give a factual basis for the plea today.
Okay.
Were this to proceed to trial, Judge, the state would show that on June 25th, 2021, about 4 a.m., Atlanta Police Department received a dispute call or call in reference to a dispute taking place at 594 Wimbledon Avenue, apartment 6132. Once upon arrival, APD officers met with 2 victims, the first being Mr. Olivincia Washington, the second being Mr. Alexander Torres Medina, who were mentioned earlier, and they explained to the officers what had occurred. Through that information, as well as in further investigation, the state would show that the day before, which technically would be the 24th, Mr. Washington and Mr. Torres and Mr. Ford were all hanging out together. As background, Judge, there'll be testimony that Mr. Ford and Mr. Washington first knew one another, that they met one another via social media. They're both members of different fraternities, but that's how they began to socialize. At that point, they hung out, I think, once or twice before, but they hadn't known each other extensively, maybe for a month or so before this incident. Mr. Ford, however, was considered a friend of Mr. Washington. Mr. Washington was in an intimate relationship with Mr. Torres. They were, for lack of better words, living together, cohabitating at the time. Mr. Washington was turning 46 on that day, July 24th, and June 24th, and wanted to celebrate his birthday. So he went out to at least one bar with Mr. Ford as well as Mr. Torres. At some point, there was a proposal that for his birthday, he wanted to invite Mr. Ford into to be intimate with himself as well as Mr. Torres. And so there was an agreement to return to the incident location, which is 594 Wimbledon.
And is that Mr. Ford's apartment or Mr.
That's Mr.
Washington's?
Torres's apartment.
So Mr. Torres.
Yes. Judge.
Everyone is going after having some drinks.
Right.
Everyone retires to Mr. Torres's place on Wimbledon.
Yes, Judge.
Okay.
And for clarification, Mr. Washington occasionally is there staying the night. And so he considers it his place, but it's technically lease-wise, it was Mr. Torres. He's no longer living at that location. So they retired to that apartment. They all three were in Mr. Torres's bedroom. At some point, Mr. Washington would testify that Mr. Ford became aggressive or too rough with Mr. Torres. So he asked him to step out of the bedroom. They were kind of in between the bedroom and the kitchen, having a conversation about that particular issue. Mr. Washington states that at the time Mr. Ford got upset, was talking so aggressively that he was foaming and somewhat spitting on him. And so he would testify that he told him, hey, calm down. You know, if this is what you're going to do, then you should leave, ask him to leave. Then he told him that he was spitting on him as he was going back and forth in this argument. And then he would testify that Mr. Ford actually did directly spit on him. At that point, he pushed him back and told him—
Washington pushed Ford, or Ford pushed Washington?
Washington pushed Ford.
After he got spat on.
Exactly. And he said, hey, you spit on me. At that moment, Mr. Torres, who's in the room, heard that statement and decided to exit the room to see what was happening. By then, Mr. Washington would testify that he was pushed by Mr. Ford into a stove that was right near the entrance of the kitchen, so hard that that stove actually broke and had to be replaced by Mr. Torres later. But pushed into the stove, they get into a tussle. Mr. Ford then swings Mr. Torres into the living room. He falls to the ground, but gets back up. Mr. Ford grabs a nearby statue. It's a Buddha statue, ceramic material, and then he uses it to hit Mr. Washington in the head. Mr. Washington then falls to the couch, and then on the ground. Mr. Torres would state that at this point, Mr. Washington appears to be unconscious. Mr. Torres has exited the room and is seeing what's happening. He then saw Mr. Ford grab the head of the statue because the head had broken from the first hit. And then he continued to hit Mr. Washington with the head. Mr. Torres then states that he tried to stop this. And so he grabs Mr. Ford, tries to keep his hand from actually hitting. So he's trying to put his hand in the way. At the same time, Mr. Ford starts to elbow Mr. Torres to get him off his back. This happens, maybe about 4 strikes happen. Mr. Torres would testify to that. And then at that point, Mr. Ford gets up and exits the apartment. At that moment, Mr. Torres calls 911. That's where the phone call comes in, and police arrive. The fire department also arrived and administered medical aid to Mr. Washington, who was bleeding profusely. He refused to be transported to Grady, but drove himself, as well as Mr. Torres, to Emory Crawford Loan for treatment. Once there, he was treated with getting stitches in 2 locations, one in the back of his head from the first strike, and then on his temples as well, Judge. While Mr. Torres and Mr. Washington were speaking to police, they gave Mr. Ford's name through social media. On social media, he was just listed as Zeke. They didn't know his last name at the time, but they gave him his phone number as well. Through that, they were able to run his name in the system, get a photo. The next day, an investigator came and did a photo lineup with Mr. Torres and Mr. Washington. And they positively identified Mr. Ford as the person who had committed the assault the day before. On the way to the hospital, Judge, when Mr. Washington was driving himself and Mr. Torres to the hospital, and at the hospital, there were phone calls and text messages between Mr. Washington and Mr. Ford. Mr. Washington was trying to figure out what happened, how that happened. While he was on the phone with him, it came out that he being Mr. Ford, felt that Mr. Washington was jealous of the way that he was being intimate with Mr. Torres. And so there are text messages from Mr. Washington to Mr. Ford saying, "This is ridiculous, this is crazy, how could I be jealous," or whatever. There are not text messages from Mr. Ford back except to ask for a case number, because at that point he told Mr. Ford that it had been reported to police and that they were moving forward prosecution. That's as far as exchanges go between them. Police contacted Mr. Ford. He arranged to turn himself in July 6th, 2021. And honestly, Judge, that sums up the factual basis. I would like to share just a bit further information regarding the victim's sentiments and more on the case. Mr. Torres wanted me to at least let the court know that he felt very traumatized by the event. He had to break his lease because he felt he wasn't sure if Mr. Ford would return to the apartment and be aggressive as well. In an effort not to re-traumatize himself, he would prefer a non-trial resolution, which is why we're here today. However, he was committed to attending court and giving testimony, as well as Mr. Washington. Both would like this matter to be put behind them. They, if anything, just want Mr. Ford to admit guilty behavior in what occurred. Of course, the state would also, from our conversation with Ms. Wood, anticipate some sort of self-defense argument. But the victims are most interested in Mr. Ford taking responsibility for what happened. And that's essentially how the state and the defense landed where we are with the recommendation, Judge.
Okay.
Nothing further.
All right. Ms. Jackson, do you have any criminal history information on Mr. Ford, who's shaking his head like nothing happened in this case? He can explain how this guy had all those stitches in his head in a little bit.
Your Honor, the defendant does not have any prior arrests on file.
All right. Thank you. Ms. Wood.
Thank you, Judge. Like Mr. Hand said, we do have a bit of a different perspective of what happened. Mr. Ford does maintain that there was more to it than it described and that he was defending himself, Judge. However, after many discussions with Mr. Ford, he decided that this would be the best path forward for him to accept the state's offer in this case. I do believe it's a reasonable offer for the charges. Judge, he's 46 years old. He had recently moved to Atlanta at the time of this incident. So he knew Mr. Washington previously. And so I don't think there will be any issue with the stay away, as they were only like acquaintances from college. So I don't think there's any issue with stayaways from either victims in this case. Judge, he is a high school graduate, as he's already said. He has a bachelor's in social work and he's working on his master's. And Judge, I do want to point out, Mr. Ford would like to use first offender on this case. I strongly advise against using first offender for a misdemeanor. However, I know it's his case, and so it's up to him. So I don't know if the court wants to speak to Mr. Ford about the pros and cons of using first offender on a misdemeanor. But I did just want to put that on the record. Otherwise, Judge, I'm sure Mr. Ford is just ready to get this behind him. So we ask that you accept the state's recommendation in this case.
Okay. Mr. Ford, where did you get your undergraduate degree?
Bowie State University in Maryland.
Say that again?
Bowie State University is located in Maryland.
Maryland. Okay. And did Mr. Washington also go to Bowie State?
No, I didn't know him through college. I knew him through one of my fraternity brothers. I knew him off and on, indirectly for about a few years. So I didn't just meet him.
Okay. And he was also in your fraternity, or it was a fraternity brother of yours who knew him, and that's how you got to know him?
No, I got to know him through a fraternity brother of mine. Mr. Washington is saying that he's a Q, but he's not.
Okay. I just asking how you got to know him.
Yeah, just through one of my frat brothers here when I would come back and forth to Atlanta visiting, and I've known Mr. Washington indirectly for more than about 7 or 8 years. We just never hung out like that.
Got it. And what brought you to Atlanta? Was it getting your master's, or was it work?
Yeah, we just wanted to. I was coming back and forth to Atlanta anyway, and then I just wanted to relocate. And then once I got accepted into the MSW program at Georgia State, is why we relocated here.
Okay. Are you working right now?
Yes, I'm currently a behavioral health technician at Northside Hospital.
All right. First offender, it sounds like you know what it is, but I need on the record to discuss it with you. It is an opportunity to have this situation not be a conviction. Of course, it would only be a misdemeanor conviction either way, but if you are treated as a first offender, then while you will be on probation, there is no conviction. If you successfully complete probation, it's pretty easy to get everything expunged, the records sealed, et cetera. That's the upside of first offender, is it's not a conviction. You'll be under sentence for a while, but when it's done, it's gone. The risk of first offender is that if you were to do something that would cause your probation to be violated, not only could you have some probation revoked, but I could take away first offender sentence status and resentence you as a misdemeanant. However, I couldn't sentence you to any more than you got now, 24 months. I could have it be 24 months in prison rather than on probation, or whatever was left in your case, but it wouldn't be any longer because you actually are having the maximum amount of probation, because these are misdemeanors. So it's mostly an opportunity. What Ms. Wood highlighted is something that I'll point out as well. You get one first offender, whether you use it on a felony or a misdemeanor. And most of the folks we deal with are using it on a felony because they've had more complicated background than you have. And they're trying to keep that felony off their records, because felonies are really what shut you down from work and going back to school, et cetera. Misdemeanors aren't good things, but they tend not to disqualify people from as many opportunities. Go ahead.
I said it would, not to cut you off. My biggest concern, and not to, because I'm in behavioral health and I don't get in trouble. Unfortunately, when I go to work, which I work with people in the vulnerable population, any type of assaults, anything like that, I'm not going to be able to work.
Got it. Then you'd want to use first offender because it's not a conviction, and when it's done, it's very expungible. So that's a decision for you to make. You're eligible for it, and I will sentence you as a first offender. Well, the thing you said to me just now that I think is most important is you saying, look, I don't get in trouble. And that's just going to need to stay that way because you'll have used up your first offender. So if you do get in trouble again, and everyone hopes you don't, then you won't be able to play that card and you will eat the misdemeanor or felony if something like that comes up. But you as a 46-year-old, not having been arrested before, tells me that whatever happened on June 24th, 25th of last year was out of the ordinary and is not what you usually find yourself in the middle of. And hopefully it doesn't happen again.
Can I ask a question? If I didn't take the first offenders, is it still possible to, or what's the time frame for expungement, if that's even an option?
That's a great question. I'm going to let Ms. Wood answer that because she's more in that line of work than I am. I sign things when people bring them to me saying, hey, it's time to expunge. I make sure it's authorized, but I don't know the parameters of that. Ms. Wood, if Mr. Ford were to enter the guilty plea, not as a first offender, so he's got a misdemeanor, at the end of the 24 months, if he does probation just right and there are no issues, what are his options?
Judge, it would still show up as a misdemeanor conviction to the simple assault and the simple battery.
That's what I thought. And so some background checks that would pop up. There are a lot of background checks that are only allowed to show felonies and they don't show misdemeanors.
No, my line of work is extensive.
I bet it is. I bet it is. So you'll just need to think through right now which one you want to do. It sounds like the first offender is what would give you the most protection when it comes to background checks because it's not a conviction. When we're done today, you don't have a conviction. You are what we call a first offender probationer. But if anyone were to run your criminal history, the arrest would be there. That you could get expunged after you're done with your sentence, but there wouldn't be anything showing a conviction because it would not be a conviction.
Okay.
All right. Any questions about that?
No, sir.
Mr. Hand, is there any restitution? I didn't hear you mention anything about that.
No, Judge. Mr. Washington's insurance covered.
Okay.
His procedures.
Well, Mr. Ford, I find there's a factual basis for your case. I could tell from watching your body language, and you should never, ever play poker, that you have a very different view of what happened, and that may be exactly right. And if a jury heard everything, the jury might say not guilty, but the jury might not, and it would be a public spectacle, and you may not want to go through all that. If the jury were to credit Mr. Washington and Mr. Torres's version of events, and I'm not crediting it one way or the other, I'm just telling you that if what they told the police and what Mr. Hand shared with me, if they told that same story to the jury, a jury could choose to believe them. The jury gets to decide who they believe if there's a conflict in the evidence. And so all I'm saying is if the jury decided to believe Mr. Washington and Mr. Torres, you could be found guilty of simple assault and battery. And for that reason, I'll accept your plea. I also find that your plea is knowing and voluntary. Voluntary means that no one's forcing you to do this. You're clearly not enthusiastic about it, but you've thought long and hard about it. You've received some real good advice from Ms. Wood, and you've decided that the best way forward for you is to take this misdemeanor first offender plea. Is that a fair enough statement?
Yes.
Okay. And a knowing plea means you've understood the law that we've been talking about. And when you didn't, you asked a question like you did now about expungement and whatnot. Do you have any other questions about your situation? I'll tell you what, you can think about it because I have a few more things I need to cover. I'm going to follow the joint recommendation and sentence you on count 1, which has been reduced to simple assault, to 12 months. Count 2, which has been reduced to battery, to 12 months. I'll run those consecutive to each other, so it's a total of 24 months. They will be probated, so there's no custody. You'll be required to complete 300 hours of community service. I encourage you to be thinking about how you could do that. You may well be able to, in your profession, perform community service because you are providing behavioral health care to others and you're just not charging for it. So your community service could be particularly meaningful. It doesn't mean you got to go rake leaves for 300 hours. If you're passive about it, those like, hey, you got to clean up this park. But there are lots of ways people give back to the community that are fulfilling, not just for the community, but also for the person performing those hours. You'll need to complete an anger management course. You can find one or probation will find one for you. And obviously, and in some ways, most importantly, no contact with Mr. Washington or Mr. Torres. I bet that's going to be easy for you. My guess is you don't want to see those guys again. Don't go out of your way to find them. Don't flame them online, nothing like that. They go their way, you go your way. If you complete the class and the community service in advance, then I will support an early termination of your probation. So you can shrink that 24 months down to the amount of time it takes to knock out your community service and your anger management course. Do you have any questions about the sentence that I've just described, Mr. Ford?
No, Your Honor.
Did I miss anything, Mr. Hand?
No, Judge.
Okay. So Mr. Ford, are you ready to finalize things or do you have questions?
No. I just want to get this over.
Okay. So no questions. You are ready to finalize. Then the last thing I've got for you, and this is under first offender. So I'm sentencing you as a first offender. Do you authorize my staff, Mr. Ford, to electronically sign the indictment indicating your first offender plea to the 2 misdemeanors?
Yes.
Ms. Wood?
Yes, Judge.
And Mr. Hand?
Yes, Judge.
All right. I think that's it. You do not need to be here on Monday, Mr. Ford, because you have resolved your case. I will cross it off my trial list. Means I don't have many cases left for trial for this coming week. I think that's it. All right, Mr. Ford, I hope you have a good holiday and good luck getting the rest of your masters.
Thank you.
All right, Ms. Wood, anything else on his behalf?
No, Your Honor.
All right, you two are free to go.
Judge, before I.
Oh, wait, yeah, one thing. So misdemeanor probation. Ms. Wood or misdemeanor probation will be in touch with you, Mr. Ford, letting you know how to connect with them. And you're going to need to do just that. The quickest way to get a probation warrant is to ignore them or not show up. And by showing up, it could be that you have to talk to them on the phone for that initial intake session with misdemeanor probation. Okay?
Yes.
All right, Ms. Wood.
I will submit that information to misdemeanor probation, Mr. Ford, on your behalf. And Judge, I just want to confirm my other case that was still on the trial calendar. Did your office receive the order for diversion from Mr. Whitenauer?
Is that Ms. Saxon? No. Duncan?
Duncan, yes, Judge.
Yes. Yeah. And I've signed that. I have 3 cases left for next week. None is yours. 2 are Ms. Feely's, and we're going to talk about them with Mr. Hand present. And then 1 is a private attorney, and his client, I think, is COVID quarantined right now, so we're stuck. She's in custody. So I think that's it. So I will not see you on Monday morning.
Thank you, Judge. Have a good holiday.
You too. Bye-bye. Okay. We need to talk, Ms. Feely, with your client. I'm gonna have you pronounce his last name and we're gonna figure out why he declined to come to court.
I'm actually gonna have him, we have spoken over the phone, but I actually did not, I forgot to ask him the correct pronunciation of his name.
All right, well, hopefully he will reveal himself and I'll be able to see him.
My video doesn't work on my laptop.
Well, that's a slow start to things. How do we
it's
pronounce?
better than my phone. My phone is unreliable. When I spoke to Lacey Woods the other day, we had to call each other several times. And that's another issue I'm working with my phone company, AirTouch. Their support people are in India. And
Mr. Can you please
tell us your last name?
Yeah.
It's pronounced Guter. I've heard every pronunciation. son's the son, so that's.
Sure. Thanks,
Doesn't
Mr.
bother
Guter.
me.
All right, and what's the case number, please, Ms. Feely?
22 SC 184420.
Okay, so this isn't Mr. Hand's case, but he can cover right now just for this question about a bench warrant.
I've emailed Miss Charles also once we got this arranged, but I have not heard
Sure.
back as of yet.
Okay, and she may be otherwise occupied. Let me see one thing here. So this is old. Conduct was almost 3 years ago, the allegations are. Okay. So Ms. Feely, why don't you tell me why the bench warrant ought not to be in place for Mr. Guter?
Yes, Your Honor. So he missed court on Thursday, the 17th, and subsequently contacted my office urgently and desperately multiple times. And I believe he contacted your court staff as well. He is unfortunately unhoused at this time, and so he did not receive his mailed notice. I now have good contact information for him. I have his phone number, I have his email address, so I don't anticipate this being a problem in the future. But as the court can imagine, he is very anxious to not end up at Rice Street. And I've already filed the waiver and entry of appearance on his behalf as well.
Okay.
I also wanted to let the court know that since we've been on Zoom, Ms. Charles did email me, and she wanted more time to review the file.
Okay. I've got an address for Mr. Guter in Jasper, Georgia. Is that no longer a good address, Mr. Guter?
No, it's not. Left Georgia years ago. I'm homeless and unemployed and living in my truck.
And your truck is parked in what state now?
It varies.
Well, I can make this really easy. I am not lifting any warrant until you come into court. So you figure out how to come to 8D and we can work through this unwillingness of your part to show yourself or tell us where you are. That's not how this process works. So when you and Ms. Feely can figure out the best way for you to make it into my courtroom, then I will gladly discuss the concept of lifting the bench warrant. But it's not an optional thing where you show up when you feel like it, or you tell us where you are when you feel like it, or you show yourself when you feel like it. These are serious charges. You, of course, have the presumption of innocence strongly in your favor, but that's doesn't give you a free pass to be in your truck in another state. So you figure out.
I'd rather not be that. I mean, I'd rather be, back to work. I'd rather have this, over and done with. I've been, leaving messages for my previous public defender, Eric Cho, for years.
Mr. Guter, I'll give you a call after this, okay?
Yep. So you are in the hands of a seasoned, experienced public defender who has been in my courtroom for a while now, and blaming the system isn't going to be a reason for not being here. The one thing I will acknowledge is that this is an old case, and these allegations from 3 years ago have suddenly sprung up, and that's why I am open to the notion of you showing up and me lifting the warrant. But I am not going to lift the warrant with you in a truck in an undisclosed location. So you and Ms. Feely should talk. She can share with you some ideas about how you might get here. And once you do, and I can see you and you're in court, then we can talk about how best to move the case forward. You're a free agent right now. You don't have to show up, but it means that if you're rolling down the back roads of Wyoming and you get pulled over, they're going to hold you in Wyoming till we can get you to Georgia. And that is a slower way to get here with less wind in your face than if you get yourself here. So you and Ms. Feely should talk. I won't take up any more of your time. Ms. Feely, you feel like you have a way of reaching Mr. Guter?
I do.
Great. You should do that and then let Ms. Nelson know what we're going to do.
All right. Thank you for working that matter in, Your Honor.
No problem. Mr. Guter, you are free to go. I need Ms. Feely to stay on because we have to talk about a couple other cases of hers. All right. Ms. Feely, updates please on Mr. Jones and Mr. Coleman. I'm sorry about Mr. Coleman. He was in court, if I'm remembering, when we called the calendar, and was maybe even going to be a plea then, and he seemed to be in good health. So since then, he's been stabbed?
That is, yes, and it is an ongoing criminal investigation. I don't think the person's been arrested yet.
Okay.
But both Mr. Jones and Mr. Coleman want to accept the state's offers. They just both have, hopefully the court understands the reasoning that they couldn't do it this week is at some point.
No, I do understand. And so that's the update part. Tell me your best understanding when, and let Ms. Jackson, you are free to go. Thank you so much for this long day. Same with Ms. Tucson and Ms. Rivers. We have taken care of the business that might result in a plea or anything that needs to be taken down.
Thank you, Judge.
Happy holidays to all of you. I'll be doing drug court tomorrow, but I don't think any of you, well, Ms. Rivers may be around, but otherwise, thanks folks, and have a good Thanksgiving break.
Okay. Happy holidays to you as well.
You too.
All right, so back to Mr. Coleman. I don't know the specifics of his condition. When do you think he could be available for a plea, virtual or in person? Just so we can figure out how best to schedule things.
So I know we have court on the December 9th. I think that may be pushing it out enough where he won't be on such heavy medication.
We do have some calendars. That's assuming I'm not still in trial from whatever we try the week of the 5th. We could certainly, the week of the 28th is now going to be open. I know that's sooner, but if I don't know if by the 2nd, December 2nd, he might be either more mobile or more coherent. But I'm not trying to rush anything. I just want to work with you and Ms. Nelson to figure out when we can do this. What I would really like to avoid is letting this calendar close and we haven't resolved his case and then he changes his mind. That will bring disappointment to a lot of us.
I expect both of those to resolve. And I think Mr. Jones was kind of really trying to get his strength together to be there November 28th.
Okay.
Would the court entertain a plea at that time?
Sure, I'll be here. We won't have jurors, but the 28th is great. So this coming Monday.
Yes, that's for Mr. Jones.
Yep, for Mr. Jones. But your sense with Mr. Coleman is that he may need a little more time?
He was very groggy sounding when I spoke with him and I think that surgery was pretty recent.
Mm-hmm. Okay, well, why don't you try to get an update? Are there family members you work through or it's just you and Mr. Coleman?
It's just been me and Mr. Coleman.
Okay. Well, why don't you maybe on the 28th, reach out to Mr. Coleman, see if he's doing a little bit better and see when we could do that. I don't have an issue with the 9th. My only pushback was, if the jury's deliberating or something by then, if we go out with something, then I'm fine doing it on the 9th. I wouldn't want to do it much later than that because that week of the 12th is the last week of the calendar.
Understood.
Okay. And you might be busy that week.
Right.
Okay. All right. So Mr. Jones, you're saying tentatively we could expect to see him and you and Mr. Hand next Monday morning.
Yes.
All right. And you'll keep Ms. Nelson posted so that Mr. Hand doesn't come on down here. You'll keep all of us posted so we know what to expect.
Of course.
Okay. All right. And then Coleman, maybe we'll get an update while we're doing the Jones plea. You don't have anything on the December 5th calendar?
I do not.
Is Tuesday better?
It is.
Okay.
Because it gives me time to set up, and if you have anybody else who want to transport, we can do it on Tuesday.
Got it. Can we do Mr. Jones on Tuesday, the 29th?
I will give him a call and
He'll only be stronger then than he would be on the 28th. But Ms. Nelson just burst in here saying 29th is better. For that on the 29th. And let's just sort this out over email. So reach out to Ms. Nelson after you check with Mr. Jones. And if he says, I absolutely cannot do it on the 29th, then we won't, but let's aim for the 29th. Okay.
Okay. Sorry.
Okay. All right. And then you don't have anything the week of the 5th?
I
as
do.
Best I can tell. Okay. Let me ask, just since you're still on, I know Ms. Wood left, but they're her cases. Mr. Hand, you and Ms. Wood have 3 cases the week of the 5th?
I believe so, Judge. No, 2. I have one with a private attorney.
Oh, that's right. It's Hood, not Wood. Sorry, I just was skimming. So you've got Landon and Sexion. Landon is number 2. Is that something you will be ready on, or you're thinking that it's going to sort out?
I'll be ready on that one, Judge.
Okay. What is 77 Landon? Oh, okay. All right. Great. That's all I got. Anything else, Ms. Feely?
No, Your Honor.
Have a great Thanksgiving.
You as well.
Mr. Hand,
Same
have a
to you,
great
Judge.
Thanksgiving. See you guys.